not the same as seeing it in real time, but it's already up there on the live stream. Uh, so I can put that or if anyone needs that, the live stream link is in the chat. I just put it in. Um, So, unfortunately, there's no real great option other than I can try and also message you, to send a group message to all the schools in the waiting room. I'll try to pay attention to that more. It didn't occur to me that I should be doing that or something. But I can message you, in according to like when each round in the schedule finishes, so that uh, that um, where we are on the schedule.
All right. Yeah, well, I guess when the rounds end, that would probably be enough. Like when one grouping or
Yeah.
Yeah, just something in the chat, even moving on to blah. So
well, do we have a chat in the waiting room?
oh, I don't know.
Yeah, I can send a message to all the participants in the waiting room. I mean unless
Great.
something has changed, but that I should be able to do.
Thank you.
Thank
No
you.
problem. Should be beginning shortly. Let me text IT. Started. All right. So, with that, I wanted to say I put in the chat the live stream link this morning. So anyone who needs to send that out to anyone, hopefully someone can take it, copy it from the chat and email it to everyone on the team so they can then copy and paste it in their phones and text it wherever. Um, also, I'll reshare in the chat and just do my pitch again, though I did it to some of you already. Um, the online art auction is currently going on. Mango Tango donated $26,000 worth of art again this year. We have to raise $27,000 a year to fund the program at what you're used to experiencing. Those in-person luncheons that we do at the courtroom, which, Judge Brady earlier commented how important it is to, the experience in person. We do try to do that, but those are about $4,000 a piece. It's not cheap to feed a bunch of high school students and all the court staff and all the people volunteering. So what I ask is each student, each participant, each coach, you please take a look at the link, open it, and genuinely look at the pieces and try to think of three people you think would really just, even if they're not going to buy it, would like looking at the pieces there. You know, Sherry Erickson is an artist who is in there. She is a really well-known artist. She's got, a $3,000 painting in there that you could bid on for $1,000. I don't even know how we got a piece that discounted from an artist of that caliber. There's also, the old Mappus Mund historic prints photos in there. Their opening bid is like $10, $20. So there is quite a range of items in the art auction that you could do that. And we still have to raise about $17,000 by April of next year if we want to bring the competition to back what it was in previous years. With that, I want to take a moment to introduce Mallory Winnie Diaz. She is the Chancellor of the Bar Foundation. And I know in past years you're used to getting a welcome from the Bar Association, but the moot court competition is no longer under the Bar Association. And so we are welcoming the head of the Bar Foundation, our new nonprofit home, to do a brief welcome and tell us a little bit more about the Bar Foundation.
Hi, good morning, everyone, and welcome to the 31st Moot Court Competition, the championship round. Congratulations. As Adam said, my name is Mallory Winnie Diaz, and I am the Chancellor of the Virgin Islands Bar Foundation, which is the philanthropic arm of the Bar Association. And the foundation is now the entity that is hosting the Moot Court competition, and I could not be happier to be speaking with you here today. The Bar Foundation is fairly new in what we're doing, and we are attempting to create more programming for the community and for the attorneys relating to providing information to the public on the legal aspects of the law in the Virgin Islands and getting people more involved in their rights. And basically, we're here to provide a service to the community, and our ears are open, and we're willing to work with anyone that has an idea or a thought and wants to put forward some programming. Of course, programming requires funding, and so we are also doing we are working on doing a lot of fundraisers so that we can put on some programming going forward. This summer, one of our initial programs is going to be a law school for the community, and inviting different attorneys to speak on various topics that community may be interested in learning about. So be on the lookout for that. We maybe will putting out some advertisements for that soon, and inviting everyone to join us. Now, to the moot court competitors today, let me start off by saying what you're doing here is impressive. You've stepped into a world that most people don't experience until law school, and you're doing it while juggling classes, homework, and everything else that comes with being a high school student. That alone deserves recognition. For many of you, this is your first competition, and whether you feel nervous or confident, your voice in this virtual courtroom matters. You belong here. You've studied the facts, you've analyzed the law, you've practiced your delivery and worked as a team. You've done the hard work, and that's what advocacy is. It's preparation meeting purpose. It's having the courage to stand up and speak when your heart's racing. It's thinking on your feet, and especially during appellate advocacy, answering the hard questions that are asked of you honestly in a way that is beneficial to your position. These competitions aren't just about winning. They're about building the mindset of a leader. Every argument you make and every time you recover after a stumble, that's growth and resilience. And that's what it takes to lead in a courtroom, in the classroom, on the basketball court, and in life. So some of you may go on to become attorneys or judges. Some of you might become leaders in business, medicine, the arts, technology. No matter what path you take, the skills you're building here, critical thinking, public speaking, teamwork, those are the tools that will set you apart and prepare you for success in whatever path it is you choose to take. So when you step up today to the podium, do it with confidence. You've earned your place in this courtroom. Speak clearly, think boldly, respect your opponents, and trust your preparation. Don't be afraid to take up space. This isn't just practice. This is you becoming something greater than you were yesterday. So good luck to all our competitors today. I look forward to watching today's competition and seeing each of you succeed. Take a deep breath and have a lot of fun. Thank you.
Thank you, Attorney Winnie Diaz. That I don't know that it could have been said better. And definitely take a deep breath. It helps relax everyone. You will, uh, Attorney Diaz and I, we worked together for several years, both as law clerks at the Supreme Court and in private practice at the same firm. We still take a deep breath when we have to go to court and talk to the judges. That doesn't stop. And you definitely, as she said, you've earned your right to be here. And Judge Governor Bryan last year, he said, we need people who can think, and Attorney Diaz, expanded on that today. It doesn't matter what you go on to become. You're going to use the skills that you learned through Moot Court. And so this is really a great opportunity, and congratulations for putting in the hard work to get this far, everyone. With that, we will start with the introduction of our Moot justices. So we have Judge George W. Cannon Jr. He is a senior judge of the District Court of the Virgin Islands on St. Croix. He attended the University of Texas at Austin and received his BA, and later graduated from what was then the Antioch School of Law. It is now the David A. Clark School of Law at the University of the District of Columbia. Following his graduation from law school, he moved to St. Croix in 1980. He worked as an assistant attorney general at the Virgin Islands Department of Justice, following which he was in private practice. Judge Cannon was appointed a magistrate judge of the Virgin Islands District Court on April 12, 2004, and he was later reappointed again on April 12, 2012 and April 12, 2020, and he retired on April 30th, 2022. So, Judge Cannon, do you have anything you want to say to the students before we get started?
Yes, just very briefly, I want to first express my appreciation for being involved in this process and congratulate each of you for your willingness and desire to not only participate. I also want to echo what Attorney Diaz said, but I like to share a quote because part of this learning process that you all are going through in this moot court competition is something that I think really helps you understand the concept of justice, which I think we are very much in the embryonic stage, but at the same time, you all will hopefully carry it forth in your life. So I just like to end my comments with this brief quote that I had in my chambers, one that I continually read to remind myself of the importance of justice. It is, O Son of Spirit, the best beloved of all things in my sight is justice. Turn not away therefrom if thou desirest me, and neglect it not that I may confide in thee. By its aid thou shalt see with thy own eyes, and not through the eyes of others, and shall know of thy own knowledge, and not through the knowledge of thy neighbor. Ponder this in thy heart, how it behooveth thee to be. Verily, justice is my gift to thee, and a sign of my loving kindness. Set it before thy eyes. Thank you.
Thank you, Judge Cannon. So next we have Moot Justice Henderson. Judge Henderson is the magistrate judge of the St. Croix Division of the District Court of the Virgin Islands, who began his time on the bench on May 1, 2022. For those of you who were paying close attention to the bios here, that is the day after Judge Cannon retired and had his last day on the bench. So we have the most recent and current serving from the St. Croix Division here. Judge Henderson graduated from St. Croix Central High School. He then attended Mars Hills University, where he received his Bachelor of Arts in History with a minor in Political Science in 1997. He received his Juris Doctorate with a concentration in litigation from Western Michigan University Thomas M. Cooley Law School in 2001. He spent many years in private practice and also served as chief legal counsel to Governor Mapp before coming onto the bench. Judge Henderson, do you have anything that you would like to say to the students this morning?
Hi, good morning to everyone. Let me first say that I am truly happy to be here today to serve as one of your Moot justices. I've done this many years ago when I was in private practice, both as a an attorney helper for the schools and then as a moot court justice. So I've always loved this program, what it does, how it assists students in being able to participate in their public speaking and the confidence that it builds in each of them. So I am intimately aware of the work that you put in to get to this point and to be here before us today. And I truly look forward to hearing the wonderful arguments that I'm sure that you've put together. So kudos to all of you first for participating and more importantly for having the courage to stand up and make your arguments. And I'm certain I'm going to hear a bunch of you who will be arguing better than some of the lawyers that I see every day. Um, but it is my honor to be here today to participate in today's moot court competition. Good luck to you all.
Thank you, Judge Henderson. I think you will be impressed after listening to yesterday's arguments. I have to say the only thing that I really felt the need to say to everyone, all the participants, is an apology, because if they can prepare the level of arguments I saw yesterday with such a late release, had I actually had this out on time, I think we would just be stunned today. And so I think you will just find it very impressive if the trend holds true. So next we have Judge Douglas Brady. Judge Brady is a judge of the Superior Court of the Virgin Islands. He graduated with a Bachelor of Arts in Sociology from Wheaton College in Illinois in 1973. He received his Juris Doctorate from Columbus School of Law at Catholic University in Washington, D.C. in 1976. He worked in private practice from 1980 to 2012, and it was confirmed by the 29th legislature of the Virgin Islands then in 2012. He was in 2019 reappointed to serve a second 6-year term as a judge of the Superior Court of the Virgin Islands. Judge Brady, do you have anything that you'd like to say to the students before we get started?
Certainly, I will be brief because we're not here to listen to the old folks speak. We're here to listen to the next generation coming up. I'd like to echo what Attorney Diaz had to say. So true. I join Judge Cannon and Judge Henderson in being honored to be here and pleased to be here. And the participants, you student attorneys, are situated in a setting where you will benefit by your preparation and your participation today. I'd encourage you today to be bold in your arguments. Bold, but measured. Just as I'd encourage you in life to be bold and measured. There's nothing, as Central High grad Judge Henderson proves, there's nothing that a young person growing up in the Virgin Islands cannot accomplish. And I would encourage all of you to pursue your dreams. If they are to practice law, please return to the Virgin Islands. We need local lawyers. And if you aspire to do something outside the law, I can certainly understand that. But this is a good training ground and a good practice session today. I wish you all the best, and I look forward to hearing from you. Good luck, everyone.
Well, thank you, Judge Brady. That is, I think, really great advice for life in this competition, just in general. So our timekeeper is on. It is Attorney Marinelli. Adam, can you unmute yourself, say hi? Everyone pin him to the screen, or the first round of people and the justices pin him so you can see.
Good morning, everyone.
Good morning.
All right. So, just as a reminder, each litigant is given 7 minutes to argue their issue. There is no rebuttal, so there's no reserving time by appellants or anything like that. The time begins when the student begins speaking. The time is paused when the moot justice speaks or interrupts to ask a question. It starts again immediately when the moot justice is done. Attorney Marinelli will hold up warnings at 5. Yeah, okay. 5, 3, 1, 3, 1, 30 seconds, and time. And he will do that silently without interrupting, because otherwise Zoom blocks out what the competitors are saying. So with that, All Saints appellants, you are the first to argue today, and so while I move everyone else into all the other schools into a waiting room, All Saints, please get ready and be prepared to put your notice of appearance on the record. All right, so Rogers, All Saints. All right, can All Saints, can you please put your notice of appearance on the record?
Good morning, Your Honors. My name is Gabriel King. Gabriel spelled Gabriel, King spelled King. And I'm representing the appellants, the 1% LLC in Oceanborn, on behalf of Viking Law. I will be addressing issue 1.
Good morning, Your Honors. My name is Morgan Richardson. Morgan is spelled Morgan. Richardson is spelled Richardson. I'll be representing Oceanborn Air Transit on behalf of Viking Law. I am doing issue 2.
All right, Moot Justices, you got all your notes and the people are properly identified? Good to start?
Good to start.
All right, then you may begin when you are ready.
May it please the court. The Moot Superior Court erred in refusing to allow defendants to argue that other parties contributed to the cause of the accident, and I say this for 2 main reasons. First, it wasn't for the court to decide what caused the decedent's injuries or her death. The law clearly states that is a decision for the jury to make. Second, the appellants followed every necessary step to file suit against GMC and St. Thomas Super Shuttles so they could establish their contribution to the decedent's injuries, but the Superior Court improperly denied them.
Excuse me, Attorney King. Since you're the first one to get off the block this morning, let me ask you if you could just give us, who are just appellate justices reading papers, tell us in a little bit of detail what happened exactly in this case. How did this accident happen? How did the person get injured and ultimately just die?
Yes, Your Honor. Miss Lannister was an employee of St. Thomas Super Shuttles who had not undergone proper emergency training where they're supposed to teach you how to operate and stop the van properly in case the brakes were faulty. When the brakes on this GMC van she was driving ultimately failed, she didn't know what to do and crashed over a 35-foot embankment into Veterans Drive, killing all 12 passengers in the van and launching herself out of the vehicle.
Attorney King.
Yes.
You just indicated that Ms. Lannister failed to go through the training in the event that her brakes went out. Was the issue of her brakes going out, what does that have to do with her training? Wasn't her training about actually being able to do the tours and drive the bus? How would she be responsible for brakes if they are faulty, that they go out? Why would that be a part of her training?
No, Your Honor. The training was specifically for in case of emergencies. And because she was a new hire, and this happened around COVID-19 time, so my perception, she was being hired out of we don't have enough employees, and they didn't put her through that emergency training. That's what that was supposed to do.
And
And
your position is that the emergency training included what
include
to do if your brakes went out?
correct.
Okay.
Later, a yacht owned by the 1% LLC, my client, came loose from its dock due to a strong storm. And at the same time, a plane was trying to land and did not see the drifting yacht until the very last minute. And as a result of trying to avoid that same yacht, she ended up crashing into the accident site.
Excuse me, Attorney King, I have to ask you this question. I'm not clear, but you indicated that the yacht got loose because of a strong storm. Was there any other facts that caused this yacht to get loose?
Yes, my clients did not properly tie up the yacht. They said that on a regular day, the way they tie it, it would usually stay in place and would not budge. But due to this strong storm, it wasn't tied up correctly and it
So
drifted.
let me follow up with you then. As part of your argument, you want other entities to be responsible for the cause of this accident. Do you not see your company, your client, as one of the main reasons this accident happened?
I'm not arguing that my clients aren't responsible in a way. What I'm arguing is that the other parties who partially caused her accident should be held liable at some extent.
Thank you. You may proceed.
Thank you. Miss Lannister was sent to the hospital, and in the hospital, she was declared a paraplegic and later succumbed to her injuries. Based on these facts, here's what we know. We know that GMC's brakes failed. We know her employer failed to properly train her about what to do in the event that the GMC brakes do fail. We know that the crash killed all 12 passengers in the van, launched Miss Lannister out the vehicle, and the jury wasn't given a chance to even consider the fact that any of the tragic events before the plane crash resulted in her paraplegia or her death. What we don't know is if the GMC brake failure partially caused her injuries or death. We don't know if her poor training partially caused her injuries or death. The jury was never given the proper facts to determine whether and to what extent GMC and her employer contributed to her death and injuries.
Let me interrupt you again. I apologize, but you just indicated that the jury wasn't given the proper facts. Is it the jury wasn't given the proper facts, or the judge erred in the rule of law that should apply to the facts?
The judge erred by not allowing us to proffer evidence at GMC and St. Thomas Super Shuttles toward the jury.
All right, thank you. You may proceed.
And by failing to allow the appellants to proffer evidence at GMC and St. Thomas Super Shuttles, the judge took factual questions away from the jury. There are more than sufficient facts for a jury to determine that St. Thomas Super Shuttles and GMC were the actual and proximate cause of the plaintiff's death and injuries. When she was alive, Miss Lannister clearly believed that other defendants were responsible for her injuries. In fact, she sued them and recovered. However, the judge decided as a matter of law that the appellants should not be able to, even though every party, including GMC and St. Thomas Super Shuttles, agreed they were partially responsible. That is a reversible error. My clients brought to the
Attorney King, excuse me, your client filed cross claims or contribution claims against the other defendants who were sued. Is that accurate?
Yes, they tried to interplead with that St. Thomas Super Shuttles and GMC. They tried to interplead.
All right, and the point being there that your client should share the fault and the damages with the other participants. Is that right?
Correct.
And the court below determined that it was inappropriate to allow the other defendants who had settled with the plaintiff. Is that correct?
Correct.
If there had been no settlement, how would your argument be different, or would it be different?
Well, we could say at the very least, if they didn't settle, that the plaintiffs would agree with me that they are somewhat liable. And I say this because it would be very unethical for lawyers to file a complaint with facts they did not investigate and that they did not believe had a basis of fact.
But isn't that the reason why settlement with parties are not brought up in court so that the jury don't assume that if a party settled that they are liable, and that's the reason why the judge did not allow you to bring them into the case?
Settlements don't erase a third party's liability, and we're not asking the court to punish GMC or St. Thomas Super Shuttles again. We're asking to allow our clients to seek contribution against them.
But wouldn't, if your argument is that you don't want to punish the settling defendants, but if you're talking about contributory negligence, isn't the jury required to apportion the percentage of fault?
Correct.
Okay, and in doing so, wouldn't that be placing the settling defendants at fault for all the world to see, which is why people settle?
Correct.
So how do you both those two issues together? Your argument and the fact of what the result would be if the court were to permit a new trial and have the evidence of the settling defendants be put forward in the trial.
It would not be fair for my clients to hold 100% of the blame for an initial crash that wasn't their fault. So I feel
why wouldn't it be that the jury is looking at 100% to determine whether you're 100% liable for your actions and having nothing to do with assessing blame against anyone else?
My clients tried to give them the evidence so that they could fully see the full picture, see what we were liable for, what the other parties were liable for. And that's where the judge blocked off that evidence and didn't allow the jury to see it.
Okay.
Attorney King, isn't that similar to the Palermo against World Fresh Markets case, where the Supreme Court agreed with the trial court that the issue of a joint tortfeasor is not to be considered by the jury under Section 1451 of Title 5, I guess it is.
Correct. But unlike the defendants in Palermo, we followed the correct procedure under Rule 14. We attempted to interplead GMC and St. Thomas Super Shuttles. We made the request while litigation was still pending and before trial so that the jury could consider their share of fault. But the court blocked us for not for lateness by saying that the connection was too attenuated. But that's where they stepped into the jury's role.
All right, so there is the Supreme Court in Palermo at least implied, if didn't say so directly, that had World Fresh Markets filed claims for contribution, then the jury could have considered all of the actors, but exactly. the failure to bring those contribution claims took that issue away from the jury.
Correct, Your Honor. Now, this leads me to our second issue, that as established in Miller versus VI Real Estate, it wasn't for the court's decision to make whether or not the situation was too far attenuated. We are not asking the court to absolve my clients of any responsibility. No. We are simply asking for the opportunity to present all the facts to the jury, not just a portion. The trial court erred by denying the appellants the right to show that other parties who had already settled and acknowledged their role may have also contributed to the tragic outcome of this case. We followed the correct legal procedures. We raised valid questions of proximate cause and the law through both binding precedents such as Miller versus VI Real Estate and World Fresh Markets versus Palermo makes clear that these questions should be decided by a jury, not cut off at the threshold by the court. We respectfully ask that this court reverse the decision of the Moot Superior Court and allow a new trial in which the full story can be told and every responsible party can be considered.
What is
Thank you.
I'm sorry, what is your expectation to the extent as to why you need all of the information to be put forth? Can't you do that without them having to be defendants in the case?
Well, that's what we attempted to do, Your Honor. But as I said, the court improperly denied that.
And if the court argued, or I think not argued, that's not the right term. If the court determined that there was some superseding cause between what occurred the first time and what occurred the second time, right? Does that in any way work as an advantage or disadvantage to you as you see it? And if so, how?
So in my case, I feel it's an advantage because we are arguing, but for the failure of the brakes and the lack of emergency training, Miss Lannister's continuous sequence of events that led to the tragic outcome wouldn't have occurred. The plane crash may have been the final blow, but it doesn't erase the original role played by the first crash.
Thank you.
Thank you.
Thank you, Attorney King. I see your time is up.
Thank you, Your Honors.
All right. Well, the Moot justices are making their notes. Can we please get Mr. Richardson up? And I also want to take this moment to recognize Malika Lett. She is an alternate on this squad. She put in all the hard work, and we don't want to not recognize that the alternates also participated. Moot justices, give me a thumbs up or some sort of signal when you're ready to go. We got one. 2. 3. All right, you may begin when you're ready.
Good morning, Your Honors. May it please the court. On September 12, 2021, Natasha Lannister was driving a group of children to a volleyball tournament when her brakes failed. Her van went over a cliff, and during the emergency response, a seaplane also crashed into the scene, caused by a drifting yacht and bad weather. Sadly, Ms. Lannister later died from her injuries. Her non-dependent adult son, Alvin Lannister, filed a wrongful debt lawsuit against the remaining defendants, Ocean-Born Air Transit and the 1% LLC. The defendants argued that Alvin, a non-dependent adult child, had no legal rights to sue for wrongful debt based on the current law, which limits only minor children who are dependent on the person who died are allowed to sue for wrongful debt. We respectfully ask this court to reverse.
Attorney Richardson, excuse me, didn't the 2001 amendment to that particular statute permit an adult child to bring a suit?
No, it did not, Your Honor. The governor vetoed it in 2001, which basically paused the law. So it was never approved that non-dependent adult children could sue.
When you say the governor vetoed it, but was it not published in the Virgin Islands Code, the elimination of the word minor to imply that adults could also be brought in wrongful discharge cases?
Yes, Your Honor, but the legislature made a mistake when it released that to the courts.
So when you say the legislator made a mistake, who would know that if there is no legislative history in the code, and the code itself clearly states that based on the amendment, the minor part was eliminated, implying that an adult can bring a wrongful discharge case? How would that be known?
Well, Your Honor, that is up to legislators to make sure that the courts know, and they failed to do that.
So if I was to go as a lawyer and look into the code to follow what the law says, and I follow the code as updated as I can as to this most recent amendment as to what the law states, and I have no other information other than what the black law or law says in the code, am I to also now do research and go to the legislature and see if they made a mistake or not? Or should I just abide by the code?
Well, Your Honor, according to World Fresh Market versus Palmero, the court has repeatedly rejected arguments that rely on the legislature's silence to create ambiguous or introduce uncertainty to otherwise clear statutes. We should interpret the silence from the legislature and the governor as confirmation that the law remains as is written, limited to minor dependent children, since the governor vetoed the 2001 expansion.
You may proceed.
Thank you, Your Honor. We respectfully ask this court to reverse the Superior Court ruling that permitted Alvin Lanster, a non-dependent adult child, to bring a wrongful death claim on behalf of his deceased mother. The lower court made a legal error when it allowed Alvin Lanster, a non-dependent adult child, to recover damages for the wrongful death of his mother. A dependent person is someone who relies on a parent or guardian for financial support or security, something Alvin does not rely on. The current law limits recovery to minors or dependent children, and Alvin does not fall in either category. The legislator attempted to amend the wrongful death statute to expand who could sue, including adult children. However, the governor blocked that change by exercising his veto power under the Revised Organic Act of 1954, which gives
I'm sorry, Attorney Richardson, for interrupting you again, but let me ask, was the issue of the legislature and the governor vetoing the legislature brought to the trial court attention in the lower court?
It wasn't, Your Honor. That's why we're saying there was a mistake, that they did not take the proper steps into verifying that there was no veto, verifying the law, what the law is.
All right, thank you.
Okay.
Attorney Richardson, are you familiar with Section 14 of Title I of the Code?
Could you say, no, Your Honor? Could you say what it means?
The Section 14, which is part of the library, is titled Correction of Errors, Classification of Acts. And it says that the publisher, what is published by the publisher as the official volume of the code, is what is the law of the Virgin Islands, except that the publisher may not alter the sense, meaning, or effect of any act of the legislature. Are you familiar with that particular statute, sir?
No, Your Honor.
Okay. All right, then I'll just pass on that question.
When the lower court allowed Alvin to sue anyway, it ignores the governor veto and oversteps his role, basically rewriting the law rather than interpreting it. In Dawson versus Trump,
Counsel, what did you do to bring this to the attention of the lower court that there was this error?
Well, Your Honor, we didn't do anything, and we're bringing it up now.
Right, and you didn't do anything then. Why should we consider your argument now on appeal? Wouldn't that be a favor of your argument below? Even
well,
if you
continue. Sorry, I didn't mean to interrupt.
Wouldn't that be a waiver of your argument, of the any objections that you had, even if you're right?
Well, Your Honor, Your Honor, the court is supposed to interpret the law strictly and precisely, Your Honor. If they, even
if we agree with you, right, and we say, you know what, you're right, the governor issued the veto. It was not the law at the time, but the defendants did not object to it at the trial and therefore waived. Under this circumstance, the defendant waived their argument. Why would that not be sufficient in this case?
Because, Your Honor, the veto is the law that the Revised Organic Act gives to the governor that we should follow.
Right, but you waived it. You didn't. Did you know at the time when you were at the trial that that wasn't the law?
No, Your Honor.
Okay.
In Dalton versus Shrum, the court held as common law that only certain individuals may recover for harm, those within the orbit of duty. In the context of wrongful death, this concept refers to people the law expects to be protected when someone dies or anyone who relied on them for support. Alvin Lannister is an independent adult who was not financially dependent on his mother, who clearly falls aside of the orbit.
Excuse me, Mr. Richardson, and I know that I'm constantly interrupting you, but I need to ask you to clarify. You said that he's an adult that's not dependent on his parents.
Yes,
you know how many adults we have living in the Virgin Islands who live in their parents' home, who are supported by their parents, who are constantly being given assistance by their parents? Are you aware of this in our culture, in our country?
Yes, Your Honor, but in the fact pattern, it did not mention any type of dependency to his mother. He was not wasn't financially dependent or emotionally dependent on his mother.
In the fact pattern, that it said that he was independent of his mother.
well, not exactly, but it could be said how he wasn't financially dependent, and minors are mostly financially dependent on their parents.
All right. Do you know how old Mr. Richardson was? The son, how old he was, the adult son?
Did not mention his age, Your Honor.
Okay.
Okay. The 2001 legislative amendment that would have expanded the wrongful death statute to include non-dependent adult children was an attempt to abrogate the common law principle and should have been nearly constructed, but the amendment was never passed. Additionally, in regarding casualty code, the court made it clear that liability should not be stretched beyond what is reasonable, foreseeable, or legally authorized.
Attorney Richardson, let me just ask you about what you just said. You talked about the common law. Does the common law, without a statute, recognize a wrongful discharge action? I'm sorry, wrongful discharge. Sorry, a wrongful death action. Is there such a thing in common law as a wrongful death action?
In a sense, yes, Your Honor.
And what is wrongful death action in the common law as you understand it?
Well, the common law basically is, from what I understand it as, is basically when courts they follow rules that like courts have used in the same sense.
All right, thank you, sir.
So, courts must apply the law as it is, not as we might wish it to be. While it may be foreseeable that bad brakes could lead to a serious accident, it was not reasonable or foreseeable that such negligence would cause a chain of unique events, like a drifting yacht or a crashing seaplane. The events lie far outside what the law considered reasonable, connected, or legally foreseeable. In conclusion, since the governor legally vetoed the legislature attempt to amend the wrongful death statute, the change never became law. Therefore, the current statute still does.
I'm sorry, Mr. Richardson, but you said never became law. I want you to explain to me if the fact that it is in the Virgin Islands Code, the code which governs the laws of the Virgin Islands, state that the word minor has been deleted, which assumes now that it allows for an adult. How could you say that it never became law if the code is where we go to look up the law?
Never became law because the governor vetoed it. So the legislature made a mistake when they still published that law as that non-dependents could sue for wrongful death.
Thank you.
Mr. Richardson, didn't the Supreme Court of the Virgin Islands in the Bertrand against Mystic Granite and Marble case, and the I think it's the Third Circuit, or maybe it's the Supreme Court, I'm not sure which case, the cigarette case, the R.J. Reynolds against Gerald, weren't those adult children who sought and received damages, and the Supreme Court did not strike those awards to those adult children?
Yes, Your Honor. It's because the legislature kept silent and still did not fix the mistake when they published the VI code, that wrongful death statute that non-dependent adult children could sue.
So that those Supreme Court cases were decided wrongly. Is that your position?
Yes, Your Honor.
Okay, thank you.
Okay. The Superior Court ignored both laws and the Constitution boundaries by allowing him to recover. We respectfully urge this court to reverse the decision of the Superior Court and uphold the proper limits set by the wrongful death statute and the revised Organic Act. Thank you, Your Honors.
Thank you, sir.
Thank you, Mr. Richardson.
All right. While the judges write their notes, I will move everyone in and move out. Next is Charlotte Amalia.
Adam, before you let them in, I have a, well, they're already in. It's
Oh,
okay. I'll
all right.
ask this.
All right. Sorry. Boy, as the years go on, it's more and more difficult to read that fine print on the screen. I was struggling reading the schools. Charlotte Molly High School, while the moot justices are finishing up, can you unmute your microphone and let's do a sound check and everything? Can you hear me just fine?
Yes, I can hear you. Can you hear me?
Yes, can you take that off the screen and let's make sure the camera is working because we had trouble with you freezing yesterday as well. All right, there you are. Good to see you this morning, Ms. Warner.
Thank
Okay. All right, Moot Justices. I see Judge Cannon's ready. Let me know when you're the two.
All right.
All right, Amalia Law, please put your notices of appearance on the record.
Good day, Your Honors, and all in attendance. I am Samara Warner. That is S as in sailor, Amara, and as for Warner, W as in woman, Arner, and I am representing the Charlotte Amalia High Law Firm. Today, I will be representing the appellees, and I will be addressing the first question on appeal, the denial of the lower court to allow claim for contribution.
Good day, Your Honors, and all who are in attendance. My name is Abigail Jabouin. That's ABIGAIL and I'm a partner at Amali Law Firm. I'm here on behalf of the appellees, and I'll be addressing the second question on appeal, the ability for non-dependent adult children to recover for wrongful death.
Thank you, ladies. You may begin, Attorney Warner.
May it please the court?
Yes, ma'am.
Your Honors, the lower court has correctly refused the argument that parties shall have to be held as contributors in this case, either for the accident, for compensation, or for both. Before this court once more is the next stop in what has been a 4-year saga of loss. What started with the 1% LLC leading to the crash of ocean-borne seaplane, resulting in the loss of 16 lives, has now added a 17 to the total in the form of plaintiff Ashana Natasha Lannister. Affirming the Moot Superior Court's ruling will bring this case closer to a final and just end for a spouse and son who cared for and have now lost a partner and a mother.
Excuse me, Attorney Warner. First of all, the name, I believe, at the bottom of the screen is Ms. Jabouin's name. It should be Attorney Warner, I believe. But Attorney Warner, it was not only the seaplane that was involved. As a matter of fact, if the brakes on that van had been in operating order, that van never would have been in the water and never would have been in danger of being damaged by the seaplane. Is that accurate?
Yes, Your Honor, that is true, but it is also important to take note that my client, Miss Lannister, was not properly trained or prepared.
So, excuse me, Ms. Warner, if your client was not properly trained or prepared, doesn't that suggest that there's also people who should be liable for not properly training her and preparing her?
Yes, it does.
So shouldn't the defendant be able to bring those people also into the case and share liability?
Yes, Your Honor, but it's also important to notice that this case has already came to a decision years prior.
Came to a decision now.
It came to a decision when the lower court had made their ruling and provided all the necessary facts.
Should the court be the one providing the facts? Or
Yes.
is that something that a jury should be determining what the facts are?
Yes, Your Honor, the court should be the one providing all the facts.
Why should the court be the one providing all the facts?
Because it is the law, and the law has certain requirements. And if those who have failed to meet those requirements, it just cannot be done.
Shouldn't the courts be the ones to determine what the law is? And then once determining what the law is, then the jury determine what facts have been proven. Shouldn't that be the case?
Yes, I know, Your Honor, because the court has already provided all of the facts, but the jury has to go with what the court has provided.
Okay.
Thank you. The ruling of that court should be affirmed for the following reasons. Number one, those who have already settled are non-parties in this suit, and non-parties are not held as contributors. Lastly, the previous verdict and the
Attorney Warner, excuse me. They are not parties to the suit, but they're not parties to the suit in the sense that your clients settled with those parties. Is that correct? And that's why that they are not parties to the suit?
Yes, Your Honor.
But they were originally parties to the suit and they were originally defendants. Is that correct?
Yes, Your Honor.
And does the Palermo against World Fresh case indicate that the word defendant, as it's used in Section 1451 of Title V, is significant, and that the jury should be able to apportion liability among all the defendants, which means that people who were included in this case with the original plaintiff lawsuit and the cross-claim for contribution by the remaining defendants. Isn't that what that case stands for?
Yes, Your Honor, it does.
Then, if that's correct, then shouldn't the court below have allowed the jury to consider whether your client's employer or the brake manufacturer or the car dealership were liable as well, and allow the jury to apportion damages among all of those defendants?
Yes, I know, Your Honor. Like I stated before, this case, all the parties who are part of this case was a part of it years prior. And the court has already provided the facts, and the jury has settled and made their decision. But in this case has been brought up again, and this highlights to World Fresh Market and Palermo, where it notes like a reference to this case and the similar attributes.
Attorney Warner, didn't the jury make its determination based on just some of the facts, meaning that they weren't permitted to see the whole story? And that by not being permitted to hear the or other way around, maybe had they been permitted to hear the entire story, meaning all the defendants that were involved, they may have had a different result.
That is true.
So if that's the case, then why should we not reverse the decisions of the Moot Superior Court and send it back for a new trial to include all of the information?
Because the lower court has already disputed their facts, and the non-parties cannot be disputed.
Yeah, but you're here in this court. So we are permitted as the Moot Supreme Court to correct what happened below. You would agree to that?
Yes.
And so if we decided to do so by sending the case back down so that all the defendants and all information related to any person who may have fault in this case, shouldn't that be the right thing for this court to do?
I do feel like not necessarily no, because this case specifically. Now, Miss Lannister, all of this was happening. All the parties before they settled before Miss Lannister's death. So now that she's died, 1% and Oceanborn are still held responsible because they have failed to uphold and accept their
And why would they be the only ones responsible for her death?
May you repeat the question, please?
Why would under your scenario then, why would Ocean and 1% be the only ones now responsible for her death?
Because Ocean 1% LLC and Oceanborn claims that since they collided in the path of Miss Lannister's accident, that they should not be held as responsible.
Right, but your argument was that the other defendants settled with Miss Lannister before she died, so that they should not now be a part. Miss Lannister has now died, right? And now also have her son who's filing a wrongful death action, right? Which he could not have done but for her dying, right? Is that correct?
Yes.
All right. So at this point, why is it, if all of the stuff are in sequence, why is it that only Ocean and 1% is responsible fully for her death?
That is because, sir, that a jury determined the approximate actual causes of Miss Lannister's injuries as because of 1% LLC and Oceanborn. So although that, her vehicle dropped from a great height, 1% LLC and Oceanborn, they collided into the accident, causing her to be more severely hurt.
The jury didn't know what happened before. Isn't that why we're here? Because the lower court did not permit Ocean and 1% to put forth any evidence of any other defendant that may have had fault?
Yes, that is correct.
And had the jury heard that of all these other things, all these other defendants and what they may have done, wouldn't the result or couldn't the result have been different?
Yes, Your Honor.
All right. Go ahead.
To my first point, Your Honors, approximately a year ago, this court heard an appeal with the present parties and an additional 20 plus parties. Before the Moot Superior Court passed the verdict, then multiple parties settled. After the appeal were returned to the lower court, as noted in the facts of this case, was the removal of a superseding cause instruction, which this court held was incompatible with the 5 VIC section 1451. World Fresh Market versus Palermo notes it was the legislator's intent to allow allocation of fault among only the parties to a lawsuit, not against non-parties. In World Fresh, PDCM, World Fresh's landlord, simply owned the property and made the economical decision to settle. Those who leased and operated the property, World Fresh Market, were not allowed to return them or the settlement to this case.
But didn't the Supreme Court say in that case that if World Fresh had filed a claim for contribution, if World Fresh had filed a claim for contribution against the landlord, then it would have been proper for the jury to be able to apportion the damages between the two defendants, that is, to portion fault and damages between the two. They could have considered whether the leak in the ceiling contributed to the accident, not only the wet spot on the floor. Wasn't that what the Supreme Court said in that case?
Yes, Your Honors, but Section 5AC, Section 1451 also states that court is constrained by the plain text of the statute, and it only allows the jury to apportion liability among the defendants.
And the point being in Palermo that because those parties, that party had settled with the plaintiff, and there was no cross claim filed, then the landlord was not a defendant. But if the World Fresh had sued or had brought a cross claim for contribution against the landlord, then they would have been a quote unquote defendant under the statute, and the jury would have been able to apportion fault in damages. Is that correct?
Yes, Your Honor.
And doesn't that apply to this case as well? Because in this case, as I understand it, the defendant, the 1% did file a cross claim for contribution against all of the other defendants who had settled out, did they not?
Yes, they did.
And
Yeah.
doesn't Palermo require then that the jury should have had the opportunity to consider those other defendants in the determination of apportionment of fault and damages?
Yes, Your Honor, but they also stated in Rules of Civil Procedure 14 that there was a method to return settling defendants, and some of the defendants came from a third party.
Okay, thank you.
Okay. While this court noted that Rules of Civil Procedure 14 provides a method to return settling defendants to a case, this will have been last year's case before the Superior Court and not the version before this court today. To my second point, Your Honors, with no questions on the facts from last year's case and only a question on law, we note again that a jury determined the proximate and actual causes of Mr. Lannister's injuries as 1% LLC and Ocean-Borne Airlines. Not one, not a superseding, but two causes that left Mr. Lannister paralyzed. Restatement third of tort physical and emotional harm, section 29, limitations on liability for tortious conduct notes that multiple factual causes always exist and multiple proximate causes are often present. An actor's tortious conduct need not be closed in space or time to be the plaintiff's harm to be a proximate cause. Further, the magnitude of the risk is the severity of the harm discounted.
Attorney Warner, if that is the case, what you just read, if that is the case, then why weren't the other defendants permitted to be a part of that case, meaning the information about them and what they did?
Your Honor, that is because the other defendants, I believe they probably don't want nothing as much to do with the case since they have already heard the decision from years prior.
I'm certain they don't want to be a part of this case. Thank you so much. Go ahead.
Thank you. In Wolf, Weave Checker Taxi Company and a Regardian Case Company and our 1% LLC and Ocean-Borne v. Lannister, even if death is delayed by 20 minutes, a few weeks, or 4 years, the wrongdoer is responsible for that wrongful death due to their negligence. In brief, if 1% LLC, Your Honors, I see that my time has elapsed. May I have at least 10 seconds to conclude?
Sure, Attorney Warner. Yes.
In brief, if 1% LLC thought that my client's death will make the responsibility go away, or thought that returning others to a case that was settled a year ago will make the responsibility go away, they were wrong. They are both responsible for Mr. Lannister's injury. Others have settled, and in some instances, they even have settled. This court cannot allow them to wrong another one of their victims by acting as though they played no discernible part in their death. Contribution either for reappointment or compensation was rightfully refused, and this court should affirm the Moot Superior's Court ruling on this issue. Your Honors, thank you for your time.
Thank you.
Thank you, Attorney Warner.
All right. Well, the judges finish up their notes. Ms. Jaboyne, please come to the podium and be ready to speak. I will let you know, okay, I got one ready. 2, 3. All right, you may begin when you are ready.
May it please the court?
Yes, please.
Your Honors, the second question on appeal addresses this court's longstanding application and analysis of 5 VIC Section 76 and the lower court's further understanding of the issue. The Moot Superior Court correctly ruled that recovery by adult children has been the longstanding practice of the Virgin Islands, and this ruling should be affirmed for the following reasons. To my first point, Your Honors, both Lannisters, father and most importantly son, have a relationship with the decedent, which entitles them to file suit. And to my second point, Your Honors, by overturning this ruling, you overturn over 20 years of precedent set by this court. To my first point, to some, adult children may seem like an oxymoron. How can you be both an adult and a child? Well, this is clarified by one simple fact. Everyone has parents. And a brand new 18-year-old graduate.
Attorney Jaboy, excuse me, aren't we trying to determine whether or not the 2001 amendment to the wrongful death statute is still applicable? And for you to be, for your argument to succeed, we must agree that the governor's veto was ineffective. Is that correct?
Your Honor, despite the governor's veto not being correctly applied, my client can still file suit no matter what the version of 76 is, because in the law there is a blood relative clause, and my client, Alvin Lannister, is a blood relative of Miss Ashana Lannister.
So let me interrupt you one moment. I need to understand the logic of that. So the blood relative then would allow the grandmother also, or the mother of Miss Lannister, to file charge and file a claim, or the cousin or aunt or uncle.
Yes, Your Honor, as long as this relative is partly or wholly dependent on the person they're filing suit on behalf of, they can file suit as a blood relative.
So as you understand, the laws of the Virgin Islands will allow, you know how many cousins and second cousin and third cousin and distance relatives we have here in the Virgin Islands, and you're saying that all of them could come in a wrongful discharge case because they're blood relatives?
No, Your Honors.
Okay.
The person filing suit has to be either partly or wholly dependent, and the level of dependency will be determined by the jury or whoever is ruling on the case. I'm just using this statute to prove that no matter what the version of 76 is, my client, Alvin Lannister, is entitled to file suit on behalf of his mother.
All right. Thank you.
I think it's a very good argument, a very ingenious argument, taking the language of the statute. But as Attorney Cannon said, a decedent could have a household of nieces and nephews who are at least partly dependent upon her for support or services. And therefore, aren't you really walking down a slippery slope that is could potentially open the floodgates to, as Attorney Cannon suggested, anybody who is a blood relative and is able to make some kind of creative claim about need for support? And let me ask you at the same time I'm asking this question: does support only mean financial support? What about emotional support? Would that be enough?
Well, Your Honor, to address your first question, I do not think it's a slippery slope because the court has discernment and they will be able to determine whether or not anyone who's filing suit is truly, partly, or wholly dependent on the person who they're filing suit behalf of. And to address the second half of your question, Your Honor, I do believe that support does not just mean financial, and support can be emotional or social. And this sort of emotional or social support can continue well into these adult children having children themselves.
So to win your argument, it's, as I said before, it's a very interesting and good argument that you're making. It doesn't matter whether the governor vetoed it or not, so is what you're saying. It doesn't matter what version of the pre or post veto language of the statute is in the code, because you win either way. So that's your point?
Yes, Your Honors. My client is entitled to file suit no matter the version of 76. In R.J. Reynolds versus Gerald, the adult sons of Gerald and Brown were substituted as plaintiffs, and this court recognized that both were in communication with and cared for their parents. Christian Brown lived a far more independent life from his mother than my client, Alvin Lannister. He was not present, not in the territory, and not even in the same time zone as his mother when she died. However, he was still allowed to file suit, and this court was comfortable in the knowledge that Christian's relationship with his mother was nearly unbreakable. This
So
court,
let me interrupt you. I apologize. You're correct with your understanding of the court's ruling, but let me just sort of ask very clearly: do we not recognize that when the governor vetoed a bill, that on our legislative process, that bill then is not valid? It is not the law? Is that not your understanding of how we operate here in the Virgin Islands?
well, Your Honor, this is where the principle of precedent comes in. Precedent, as defined by Black's Law's Dictionary, is a court's decision that is considered an authority for deciding subsequent cases involving similar facts or similar legal issues. Since 2001, this court has used the published definition of Virgin Islands Code Title V, Section 76. That is over 20 years of doctrine and numerous cases that have all been decided using this statute.
I respect that, and I know you're very aware of the understanding of precedent. But I also have to bring to your attention, even though this is not part of your case directly, that precedent can be changed. We have seen that in our Supreme Court ruling that Roe versus Wade is no longer the law of the land. So this court has the option to no longer follow precedent if we feel that it is not appropriate in this case. So why should we accept a failure, whether it was on the legislature, whether it was on the publisher, to recognize that the veto that was done by the governor, taking out the adult and putting back in the minor, is the law of the Virgin Islands?
Well, Your Honors, I'm not saying that we should recognize this law and the failure of the law to incorporate the governor's veto. However, it is not the job of the judicial branch to correct the laws. The job of the judicial branch is to interpret the body of law that was placed before it. And as it stands, this version of Title V, Section 76, is the law of the land. And until that has been corrected, the court should uphold the lower court's ruling on this issue.
Isn't it the role of the courts to determine what the law of the land is?
It's
Through
the role of the court to
interpretation.
Sorry, Your Honor.
Through its interpretation?
Yes, Your Honor, but to
And
interpret the law does not mean to correct it. And the law.
Wait a minute. In so doing, doesn't that mean that there are times in our interpretation of what the law is that we necessarily have to correct what has happened before?
Yes, Your Honors, and I have nothing against this court correcting the law and correctly incorporating the governor's veto. However, I believe that you should not overturn this ruling because, as I've stated previously, no matter the version of 76, my client Alvin Lannister can still file suit. And all this court would be accomplishing by overturning this law is making this poor young man who has already gone through so much trauma and distress go through this legal process all over again just to get potentially the same ruling.
Attorney Chapoin, I want to, because you mentioned something that I thought was, in my view, was ingenious to argue, which is the blood relatives argument. But if we look at the statute as written, right, the legislature included the term minor children originally. And in an attempt to amend the law, they removed the word minor to include children. But when you read the Section 1, B1 in totality, it then speaks to, and when partly or wholly dependent on the decedent for supportive services, any blood relative and adoptive brothers and sisters. Doesn't it seem that the legislature intended to keep separate children from other blood relatives, which would be like cousins and aunts and uncles, and not include them in that group, but specifically speak to children? Or else they would have just removed all of that altogether and just say any blood relatives.
Yes, Your Honor, but my client Alvin Lannister is the child of Ashana Lannister. He
But
is
the
just
statute
an adult
provides,
child.
the statute though provides for minor children. That's what it says. And so your argument has been that even though the governor has vetoed the bill, or that line section, I should say, that removed the term minor, that would have then included your client. And by a scrivener's error, having nothing to do with the governor, that the code printed what the legislature, what the governor had actually vetoed out of there. And then giving all of the lower courts the thought and all the lawyers the belief that the law included just children. Your argument is that on precedent, meaning that the courts have made decisions based on a printing in a book that was incorrect, that we somehow should not correct that? In other words, how is that precedent? If it's wrong, if the law is wrong, meaning none of the courts took into account that the governor vetoed the bill, vetoed that section of the bill, then wouldn't that mean that all of our precedent was based on an incorrect law and we should correct it?
Yes, Your Honor, this would mean that all of our precedent is based on an incorrect law. However, as seen in Fleming Foods Technis versus Rylander, unless the revised statutes constitutes the law and are the law, citizens and courts alike will be compelled to seek it in the session acts of the legislature. This is an insurmountable task for the average citizen. How can we expect average citizens and legal professionals to search through session laws for rulings that this court did not even know were incorrect? This is insurmountable for the average person, and this error should not be held in the fault of my client, Alvin Lannister.
But Attorney Jabwan, aren't we required to follow what the law is?
Your Honors, as it currently stands, the current version of Section 76 is the law. That's what is printed in the Virgin Islands Code, and that's what this court has used as precedent for 20 years. Unless this ruling is amended, it's not the law.
Let me ask you again. What impact does a governor's veto of a law have on that law? Just answer that question.
The governor's veto means that whatever the governor vetoed is not part of the law. That's how our system of checks and balances works.
Right. And in this scenario, the law that amended Section 76 to remove the word minor was that vetoed by the governor.
Yes, Your Honor. The governor vetoed the word minor, but the law still includes the word children.
And did the governor return his veto to the legislature?
No, Your Honor. But in VI Code Section 1, Section 14, if any correction that is provided in this section shall become effective, it is a matter of law. And the court, the legislature, and the governor have had over 30 days to overturn the law. They have not corrected the law, so functionally, the version of VIC Section 5, subsection 76 is the law of the land in the Virgin Islands.
I have to interrupt because I have some confusion. Didn't the legislature in the bill in which it amended, which was approved in June 5th, 2001, and I'm reading, this is bill number 240043, and that it says in subsection B1, delete the word minor, but yet at the same time, at the end of the bill, it notes the governor objection to bill number 240043. And it basically says that in the subsection B1, the delete word minor, he objects to that. So it was in the code that he objected to it. Isn't that correct?
Yes, Your Honor, but it was not in the printed code. And the time to correct the bill has passed, which means that what is in the printed code is now the law.
Thank you.
And what's
Your
the
Honor,
for that? That when the company that prints our laws makes an error in printing in our books, that they then become the arbiter of what our laws should be if no one goes to correct it?
May you repeat your question, please, Your Honor?
In this scenario, everyone is in this problem because the printer is who made an error. Nobody else made an error. The legislature sent a bill up. The governor objected to the bill. The legislature to date has failed to override the governor's veto of that bill. The only reason we're here to some degree is because the printer printed an incorrect version of the law. So am I to understand your argument is when a printer prints an incorrect version of law, if nobody calls the printer in 30 days to tell them, hey, you need to go reprint all your books because you printed something wrong, that now becomes the law of the land?
While it is not the legal law of the land, Your Honors, this is the book of law that the citizens of the Virgin Islands, the judicial branch, and everyone who comes to this court is depending on to bring them justice. And though this law may be incorrect, you cannot expect regular citizens or legal professionals to search through the Virgin Islands Code, which has been around for numerous years, to find inaccuracies in the law. This is an error on our legislative branch and the writers of the VI Code.
So should we expect the judges of our lower courts to read through all areas of the law to ensure that the law they are applying is the correct law?
Yes, Your Honors, the lower court should review all areas of the law, but the lower court likely decided to affirm this ruling because, as I've stated before, my client, Alvin Lannister, is entitled to file suit no matter the version of 76 because he is a blood relative of Miss Asana Lannister. Your Honors, I have seen that my time has elapsed. May I please be allowed some more time to briefly conclude?
Briefly.
Your Honors, the lower court followed its duty. It followed the body of law and precedent that was placed before it, and this ruling should be affirmed. Thank you, Your Honors. Thank you for your time.
Thank
Thank
you.
you, Attorney Chapon.
All right. Now is the time for a break. Let me text IT. So,
How long is the break, Adam?
it's 10 minutes.
Okay.
So I have 9:34, so it'll be 10:44 when we come back. Judge Henderson, you had a question?
I did. No, I don't remember what my question was. I think it was with the scoring. Oh, the scoring. How do we get those? Are we
Yes. Ready.
All right. Please put your notices of appearance on the record.
Good morning, everyone. My name is Christina Francois. That is spelled Christina. Last name spelled Francois. Today I stand before you as an appellant representing Antilles School alongside my co-counsel Miko Griffith, and I'm arguing issue 1. Did the Moot Superior Court err in refusing to allow defendants to argue that other parties contributed to the cause of the accident, and then further err by refusing to allow contribution claims against those parties?
Good morning to all. My name is Miko Isaiah Griffith. That is my preferred first name, Miko. Mikko. Last name Griffith, Griffith, and I'm representing Antilles School. I stand before the court as an appellant, along with my co-counsel, Christina Francois, arguing issue 2, the rights for child recovery after the wrongful death of a parent.
You may proceed, Attorney Francois.
Yeah. May it please the court. The trial court erred in refusing to allow my clients, Oceanborn and the 1%, to present evidence that other parties contributed to the accident, preventing them from receiving a fair and complete defense. This is not a simple case of negligence. This is not a case where one party's actions, standing alone, directly led to a tragic outcome. What we have here is a chain of events and multiple decisions, oversights, and possible failures that all culminated in the accident that took Natasha Lannister's life. To assign sole responsibility to Oceanborn and the 1% is to ignore the undeniable reality that this case is far more complex than the court allowed it to be, and it oversimplifies a deeply layered tragedy.
Attorney Francois, you're not quarreling with the fact that your client has been deemed negligent. You're just quarreling with the fact that you didn't have an opportunity to have the jury apportion fault and damages?
Your Honor, that is precisely what I will be arguing today.
Okay, thank you.
Let me interrupt just briefly, Attorney Francois. If we allow your client to bring in the fact that other clients, or should say other defendants in the previous case, has settled, wouldn't that necessarily get an assumption over to the jury that those who had settled was wrong and that your client somehow is not liable?
Well, Your Honor, it is important that we're able to bring in all facts of the case, and the fact of the matter is those parties that settled separately are still a part of the story and contributed to the end result. So it is.
Let me interrupt you again, but doesn't the rule of law regarding settlements disallow the fact that parties who settled should not be brought into the case because of the prejudice that it might create for the jury to determine the true liability of who is responsible?
Well, we aren't trying to bring them in as official parties in the case necessarily, but they do contribute to the story and they are contributing factors. So it is important that the jury be able to see a fully painted picture of what went on that day.
All right, thank you.
Thank you. To begin, the court unfairly forced Oceanborn and the 1% to bear 100% of the liability without allowing the jury to consider whether other entities, such as the Vans brake manufacturers, St. Thomas Super Shuttles, or marina operators, played a role in the chain of events that led to Lannister's death. This was not just a misapplication of law, but a procedural failure that deprived the defendants of their right to a just defense. In Kaler versus BC Motor Transportation, the court acknowledged that even when one party's negligence is obvious, the other actors may still bear liability for contributing to a plaintiff's harm. that jury was given the opportunity to evaluate shared fault, and here ours was not. Moving forward, the trial court's decision misapplied the scope of liability principle. According to the restatement of torts, modern tort law requires a determination of whether the harm suffered was within the foreseeable scope of a defendant's risk. By excluding any evidence regarding independent contributing causes like mechanical failure or the marina safety protocols, the court forced the jury into an overly narrow view of causation. It prevented a full assessment of whether the defendant's actions were, in fact, the sole cause of Lannister's death.
Attorney Francois, are the restatements of the law binding upon us?
While the restatement is no longer binding, it was previously used to make rulings, and it has been replaced by the bank's analysis since then, but we used to use it, so it is still a good guideline for how we can act as far as procedures go.
All right, thank you.
In addition, the court misinterpreted joint and several liability under Title V of the Virgin Islands Code, Section 1451. While the statute allows a plaintiff to recover full damages from any single liability party, it does not eliminate a defendant's right to seek contribution from others. Instead of recognizing this, the court treated joint and several liability as an all-or-nothing assignment of fault.
Attorney Francois, the statute you just cited refers to apportionment among defendants, does it not? And your client and the seaplane company are the only two defendants in the case, are they not?
They are, and a part of the issue here is that they were barred from filing a third-party claim, and they were not able to even include evidence that other parties contributed.
Isn't this decision the court below made consistent with the Supreme Court's decision in Palermo?
Actually, the legislature's intent was not to make defendants absorb total liability blindly, but to ensure fairness by permitting courts and juries to recognize and apportion the share of fault among all responsible actors, whether or not they're ultimately responsible to the plaintiff in the final judgment. So it is imperative that we still be able to include these facts.
Attorney Francois, if the appellate court has already ruled that the superseding cause is not applicable, isn't that, or wasn't that what the trial court was supposed to follow when issuing its instructions and making its rulings?
Could you please repeat your question, Your Honor?
Didn't the appellate court, was two courts, didn't the appellate court already rule that superseding causes were not going to be applicable to this case?
While that may be true, Section 1451 is made to both protect plaintiffs and balance fairness of allocation between defendants. So it is important that we still recognize this and address it when evaluating.
So if the appellate court has already ruled that superseding causes will not be applicable, then wasn't the trial court correct in not permitting any arguments in regards to what potentially could be a superseding cause?
No, Your Honor. This statute must take precedence, and it is important that we follow the correct procedure, whether we think the results may be obvious now or not.
But didn't the appellate court already rule on that issue? So that the trial court now has to follow what the appellate court has ordered.
Not necessarily. We are asking for a reevaluation.
But why didn't you ask for that reevaluation before the trial court?
Well, we were heavily restricted in what information we were allowed to bring into the courtroom beforehand, and that is one of the issues I plan to bring to light today in front of you all.
All right.
Thank you. Continuing, this issue was also addressed in World Crush Markets, LLC versus Palermo, as you previously mentioned, where the Virgin Islands Supreme Court held that fault may only be apportioned among defendants present at trial, unless a third-party claim is filed. While the court there upheld the exclusion of evidence against a previously dismissed party, that case involved a straightforward slip and fall, not a complex multi-actor tragedy such as this one. Applying Palermo so rigidly here, where the facts are far more layered, reduced the jury's ability to evaluate causation and liability while addressing the complexity of this case. In sum, the trial court's exclusions not only prevented the jury from assessing negligence and determining the true scope of liability, but also produced an incomplete record. This flaw imposed a disproportionate burden on two defendants who could not have possibly been the sole cause of harm.
Attorney Francois, are not exactly clear. Are you saying that Palermo only applies to relatively straightforward slip and fall type situations and does not apply when the facts are more complicated? And how does that, if that is what you're saying, how does that jive with the language of the statute, which makes no such distinction?
Your Honor, that is not what I'm trying to say at all. I'm simply trying to express to you all that it's important that we take into account how much more complex this case is and delve deeper into what Palermo's ruling truly was in order to see how and when we should apply it so rigidly. In sum, we respectfully request that this court reverse the ruling and undergo a new trial where all relevant evidence may be heard and liability be equitably determined. Thank you.
Let me ask you this question.
Yes.
Because of your argument that somehow the two defendants who are presently in the case are not necessarily the total defendants responsible for the liability, let's assume that the trial court followed the previous appellate court decision, did the right thing. Can you now, even if we affirm the lower court decision, can you now still go after those other parties that you feel should contribute to your liability, assuming that there's damages found on your behalf?
Well, without restriction from the court, we will be able to file a third-party claim. And regardless of what the jury may decide, it is important that it is based on a fair and complete record, not one skewed and shaped by exclusion and assumption. Are there any further questions?
Thank you.
Well, if there are no further questions, I would like to conclude.
Okay, you've got a couple, you've got 1 minute.
Well, once again, we ask that the court reverse this ruling and undergo a new trial where we can evaluate all evidence and have liability be determined in an equitable, fair, and lawful way. Thank you very much.
Thank you.
Thank you, Attorney Francois.
Right. Mr. Griffith, while the judges are finishing their notes, let's get you up to the podium. Okay, 1, 2, all three. All right, you may begin when you are ready.
Thank you, Your Honor. May it please the court. The Moot Superior Court did err in its decision for the long-established practice of allowing adult children to recover over the vetoed expansion of the class of individuals entitled to recover for wrongful death because the governor's veto effectively nullified the legislative expansion to include adult children, and previous case rulings failed to address this veto, making them legally incorrect. The 1% LLC and Oceanborn sought to dismiss Natasha Lannister's adult child as a party to the lawsuit. The wrongful death statute, as substantially amended in 1974, limited the right to bring a wrongful death claim to only minor children of a decedent who are dependent upon that decedent. In 2001, the legislature acted to expand the class of persons entitled to bring wrongful death actions to include adult children who are no longer dependent upon the deceased. But the Virgin Islands Sessions laws, during its legislative sessions which detailed what was discussed and passed by the legislator, reported that the governor of the Virgin Islands had exercised his line item veto power, as provided in the revised Organic Act, to veto the amendment that expanded the class. specifically striking the provision for adult children. While the published version of the Virgin Islands Code includes the class of individuals entitled to recover, such as adult children, the Moot Superior Court should have applied the wrongful death provision as written in the Virgin Islands Sessions laws, which includes the governor's veto power to strike down specific provisions of the law, including
So, excuse me, Attorney Griffin, let me make sure I'm clear on your argument. You're saying that the trial judge below should have ignored what was in the code in black and white and instead follow what was in the legislative section bill
No, Your Honor.
argument? Okay.
That is not
all right.
Precise. Oh, sorry.
No, go ahead.
Okay, no, Your Honor, that is not what I'm saying at all. I am saying in this instance, where there was an error in the published law, the next best action to take was to take a look at the Sessions laws, which included the governor's veto, which I believe should have been implemented.
How would the lower court know that there would be an error in the law? I mean, the code speaks for itself. You don't go and look at the sections when you have in black letter law what the code says.
You're absolutely right, Your Honor. All that previous case was not undermined at all, for the court simply interpreted the law as published. However, going forward, I believe with a new and accurate understanding of the correct legislative intent, the court should give full consideration towards the governor's veto, as detailed in the Sessions laws.
Why that now? Because the law for the last 20 years has been, or at least the correct law, has been what the governor vetoed.
Yes, Your Honor.
Should we not correct ourselves now by saying, wait a minute, you all have been following the wrong law, and we are now correcting this law, and reverse the court by allowing your client to continue with a wrongful death action?
I'm sorry, Your Honor, what is can you please elaborate on your question specifically?
Right. You indicated that, from what I just heard you say, it seems like what you were saying was that going forward, we should apply the governor's veto, but for everything else before then, we should leave the law as it is. Am I correct in what I thought I heard you say?
I'm not trying to undermine the previous cases, no, Your Honor. I'm simply saying that going forward, the new interpretation of the law, I believe, should include and give full consideration towards the governor's veto. As was not.
Question to you is, why should we not do that now, in this case?
I'm saying we should. That's precisely what I'm saying. I'm saying in this case and going forward that full consideration towards the governor's veto should be given.
So as to not allow Mr. or Ms. Lannister's son to carry forward his claim.
Yes, Your Honor. That's precisely what I'm saying.
Got it.
I'm saying that as well, despite the plain meaning of the statute, including the right for adult children to recover, we simply cannot rely on an amended version of a statute that should have never became published law due to a valid and non-overridden veto.
Attorney Griffith,
yes, Your Honor.
It's obviously very clear as you litigants and we judges are finding just from this discussion that certainty in the law is necessary in this confusion where there is a publisher's error apparently has caused all sorts of problems. Perhaps that's why the legislature included subsection B to section 14 of Title I of the code. Are you familiar with that statute and subsection B in particular?
No, unfortunately, I am not, Your Honor. Can you please elaborate?
This is about the laws to be published by the publisher. The publisher may not alter the sense, meaning, or effect of any act of the legislature, but it may do various things as set out in subsection A. But then subsection B says Any correction provided for in this section shall become effective as a matter of law if the publishers have notified the legislature, the governor, and the code reviser, and nobody's objected within 30 days. So doesn't that seems to say that, look, the publisher by contract has the job to put the law in place, but the legislature, in adopting this provision, has said that if there's an error and nobody catches it, then the published version is valid. That's how I'm reading subsection B of section 14 of Title I. Tell me why that's not accurate.
I believe that's not accurate, as the silence made by the government in response to the incorrect publication of the law should not be interpreted as acceptance or accuracy within or for that law. While I'm unsure why the government, the legislature, and the governor were silent during that period of 30 days where the law could have been changed, that does not explain the fact as to why the published law is still incorrect. And I believe that, as I said previously, and going forward, that the published law should be updated and the court should give full consideration towards the governor's veto. And, Your Honors, I'd like to make something clear as well. I am not asking this court to rewrite the law, as the correct interpretation of the law, I believe, was established over 20 years ago. I'm simply urging the court to interpret and enforce the accurate and updated state of the law as detailed in the Sessions laws. As I was saying previously, the appellees opposed the appellant's position that an adult child was barred from bringing a wrongful death action, arguing that a recovery by adult surviving children had been upheld in previous cases, such as Burstrand versus Mystic Granite and Marble Incorporated and R.J. Rones versus Gerald. Both cases established that adult children are entitled to recover for the wrongful death of a parent. However, neither case directly addressed the governor's veto or the specific legal status of adult children as claimants. Therefore, this argument based on these cases is ineffective, as the lack of consideration for the governor's veto, which clearly intended to deny the expansion of class of eligible claimants, was overlooked.
So let me interrupt you again, Attorney Griffith. I understand your argument, but I want to see if you can sort of deal with my dilemma. If the code at this present time has not been corrected, and there is required by our code and laws that a correction has to be done within 30 days, or if not, then what is published is the law. How can we as a court then ignore the fact that what was not put into our code was the veto of the governors excluding adults, so that it goes back to the reference of minors only? The law as it stands allows an adult to bring a wrongful death. Is that correct?
Yes, Your Honor. The current published version of the law does say that adult children are allowed to cover.
And so, and I understand that you are asking this court, the appellate court, to not accept that, but to now make a decision that we should now, as an appellate court, say that the law does not allow adults to proceed with a wrongful death action, but only minors. Is that your argument?
Yes, Your Honor. That is precisely my argument.
So how do we as the appellate court take it upon ourselves to ignore the law that requires us to follow the law?
Your Honor, judicial oversight does not change the fact that the statute, as vetoed and detailed in the Sessions law, should hold precedence, I believe, despite the fact that there was silence during that 30 days where the governor could have made an attempt, or the legislature. I still believe that the error made in the published law should not continue to hold effect, as it is an error, despite, I believe it was subsection B, stating that that error should continue to be published law. The fact that the published law differs so greatly from the Sessions laws, there must be something to fix. And once again, I'm saying not to rewrite the law, but to take a deeper look into the correct interpretation of the law.
Thank you.
Checks and balances as well are a crucial element of government legislature because they prevent the abuse of power, ensure accountability, and protect democratic principles. No single branch of government, executive, legislative, or judicial, should hold unchecked authority. They ensure that power is distributed, not concentrated, and that the government remains accountable to the people it serves. The failure to recognize the governor's valid and non-overridden veto, combined with continued reliance on an outdated version of the statute, which improperly includes adult children as wrongful death claimants, represents a breakdown in the system of checks and balances.
Mr. Griffith.
Yes,
but
Your Honor.
hasn't the Supreme Court in the Bertrand case and in the R.J. Reynolds case against Gerald at least implicitly said that this is the statute that is applicable? And if that is accurate, and I think you came out and said, well, the Supreme Court just wasn't aware, in essence, I think you said, which may be true. But what effect does that have on us if the Supreme Court is saying this is the law that applies? Then aren't we bound by that law?
No, Your Honor, I don't believe we are bound by that law at all. While I do agree with you in that the previous cases were correct in simply interpreting the law as published, I believe that now, with an updated understanding of the Sessions laws and the correct legislative intent as detailed with the governor's veto, that the published law should have been updated and should be updated going forward. Your Honor, that is all of my argument. May I conclude?
Yes.
In conclusion, the Moot Superior Court erred in applying the statute as written by the Virgin Islands Code because the governor's veto was a clear exercise of veto authority, which showed the intent of the enforcement of the law. My clients maintain that adult children should not be allowed to recover under the wrongful death statute based on the veto and the legislative process.
Thank you, Attorney Griffith.
Thank you all for your time.
Yeah.
All right. I just noticed that I did something in the scheduling. Antilles Appellees are the next one, so we don't need to move anyone out of the into the break room or anything. I would normally not put both squads from the same school back to back. I don't know how I made that error, but let's get the Antilles Appellees up to the podium while the judges are finishing with their notes, and then we will get ready for the notice of appearance. I got that. 2. Yep. One more. All right. Please put your notice of appearance on the record.
Good morning. My name is Yuvraj Dua. That is preferred first name Yuvraj, Yuvraj, and preferred last name Dua, Dua. I stand before the court alongside my co-counsel Ajay Mirpuri to represent Antilles School as an appellee regarding issue 1, an issue involving the liability of the 1% LLC and Oceanborn and their respective roles.
Good morning. My name is Ajay Mirpuri. That is my preferred first name, Ajay, A-J-A-Y, and last name Mirpuri, M-I-R-P-U-R-I. And I am honored to represent Antilles School alongside my co-counsel Yuvraj Dua. I am an appellee arguing issue 2, the right of adult children to recover in wrongful death cases. Thank you.
All right, you may begin when you are ready.
Thank you. May it please the court. The Moot Superior Court did not err and was in fact correct in disallowing the 1% LLC and Oceanborn to share liability with other entities. Your Honors, I'd like to begin with the facts of our case. Lannister's taxi van crashed off of a cliff due to brake failure and improper training on behalf of St. Thomas Super Shuttles. In an entirely different event, Oceanborn Seaplane crashed into the same site of Lannister's incident due to the obstruction of the 1% LLC's loosely tied yacht. The only thing these events share in common is their location, as their causes and results are completely different. Therefore, all parties involved in their respective events should be held accountable separately in terms of liability. And my first point to defend such claim calls for me to reference Dahlstrom v. Schrum. In Dahlstrom v. Schrum, a woman, Ruth Dahlstrom, was left injured after Robert Schrum drove into a pedestrian, killing that pedestrian, and that pedestrian's body then colliding with Ruth Dahlstrom. The court ruled that Schrum, the driver, was not liable as it was found outside of his orbit of danger. What this does, Your Honors, is it affirms that when actions are taken for independent, rational reasons, those involved cannot be treated jointly liable. In Dahlstrom v. Schrum, it can also be stated as exactly that a reasonable man, under the present circumstances, could not foresee that anyone standing in the street behind the bus would be injured by an object struck by the defendant's car.
Attorney Dua?
Go ahead, Attorney Brady. I'm sorry, Judge Brady.
I was just going to ask, in our case, you are not stating, I'm sure, that the other actors do not have some amount of liability. You're simply suggesting that there is a second accident, separate and apart, that also needs to be evaluated separately to see if there's negligence and damages. Is that accurate?
Yes, Your Honor, that is exactly accurate.
In the Dahlstrom case, the whatever it was, the bus struck the first person, and that person flew through the air and landed on the second person. Well, certainly that case couldn't stand for the proposition that the person who was thrown into the air and landed on the second person is somehow liable for a separate injury. If it's one chain of events, and specifically as to damages, the damages that Ms. Lassiter suffered here are the result of all of these events, are they not? And therefore, don't they all have to be considered together?
Your Honor, the significance of Dahlstrom v. Schrum and the reason why it negates the fact that these events were all like a chain of events rather than separate events is the fact that in Dahlstrom v. Schrum, the driver was outside of the orbit of danger. What occurs inside the orbit of danger is its own event and shall be treated separately. Whatever occurs inside of its own orbit, the people or the entities found liable inside of their own orbit should be held separately liable for the actions that they caused within their orbit, even though the outcomes may intersect within or intersecting with an event or entities that occurred in a separate orbit. And in our case, because the plane and the yacht were operating in a maritime space and the van crash occurred in a land-based orbit, the two events occurred in their own orbits of danger in their respective areas. And Your Honors, though it may seem as if the water and the road, they touch, they're right there. Because of their individual uses, we can separate the two into their own distinct regions and orbits. The road is used for land operating vehicles, and the ocean is used for sea vessels, and in our case, as a landing strip for the seaplanes operated by Oceanborn. And to further my point, I must bring up Zilka v. Sandvik's construction, where a bystander lost vision as tree debris struck him during a construction procedure. The court ruled that the bulldozer operator was proceeding normally, and therefore no foreseeable danger occurred to someone at such a distance. The reason why I bring this up is to touch on a point I made earlier about the maritime versus land-based orbit and their respective uses. A construction zone's primary use is for construction. So conducting construction is therefore a normal act, and the bulldozer was operating within reason, just like our pilots were. In our case, the maritime orbit was being used for seaplanes and boats. This defines its distinctness from the land-based orbit where Lannister's accident site resides, which was being used for cars and other land vehicles.
Excuse me, Attorney Doyle, let me make sure I understand the orbit of danger. And
Yes.
if you can correct me in my understanding, I would appreciate it. Based on your argument, the orbit of danger are separate in your mind. But let's look at your facts. The shuttle failed because of the brakes, and maybe because of the improper training. There might have been also an effort that could have avoided the vehicle falling down and having an accident, but both of those caused the primary crash. Is that correct?
Yes, Your Honor.
And as a result of that, your client actually was thrown out of the shuttle. Is that correct?
I believe so, Your Honor.
Okay, so the orbit of danger at that time, your client has already suffered some amount of damages that we are aware at that time she's not dead, but subsequently she dies later on. So what in your argument somehow allows only the defendants that you now say are responsible to exclude those other parties, like her employee for not properly training her, or the vehicle manufacturer for the brakes failure? I mean, it seems like to me that orbit of danger would be something that will allow them to be brought right into the suit. And am I wrong with my understanding?
Your Honor, I see where you're coming from, but I disagree, Your Honor. The offense that led up to Lannister's incident was separate and in a separate orbit of danger. And the reason why is because the orbit of danger itself is the distance from foreseeable danger. And in order for the plane crash to be foreseeable, someone had to have been acting in an unreasonable manner. But in our case, that's not the case. The pilots were aborting a landing procedure reasonably. It was unforeseeable that they would crash into Lannister's taxi van. Does that answer your question, Your Honor?
No, that confused me even more. But in other words, you are, as I understand it, trying to affirm the lower court decision, correct?
Yes, Your Honor.
And in the lower court decision, it stopped the two defendants from bringing in other parties, right?
Yes, Your Honor.
So my question to you is, in the orbit of danger that you described, it seems to me the primary cause of the problem would have been the brakes failure and the failure to properly train the plaintiff to avoid crashing.
Your Honor, you are correct. That
okay.
The failure to properly train Lannister and the brake failure from the manufacturer GMC led to the event of Lannister's van incident. The causes, Your Honor, you are correct. That is ultimately what led to Lannister's incident, but that occurred inside of its own orbit. That event has already happened, and the parties from that event, such as the brake manufacturer, St. Thomas Super Shuttles, they have already been found liable for that separate event, Your Honor.
Was it that they settled, or were they found liable?
Found liable, Your Honor.
All right.
Well, and how is one found liable if no jury has determined that they are liable?
Your Honor, the lower court had ruled that they were liable for their actions.
No, the lower court, didn't the lower court rule that they settled?
Your Honor, yes.
That's different from a finding of liability. isn't the court's duty to address and determine what the law is, and the jury's duty to determine what the facts are that are proven?
Yes, Your Honor.
So for all of those defendants that settled, did any, to your knowledge, did any juror, any jury apportion or determine what liability they had?
No, Your Honor. The fact of the matter is that they already had settled.
Right. So the fact that they settled, right, means that nobody really knows why. They could have settled because they just didn't feel like going to trial because it will cost more money, whatever the reasons are. And in most settlements, you will agree that there's always a provision that says they don't, no, there's no, by the fact that they're settling, it doesn't mean that they are conceding that they're liable. It's just that they're settling. You would agree with that?
Yes, Your Honor.
Now, if that is the case, and all of these people, all these entities were somehow involved in some form of an injury to your client, why wouldn't the defendants be permitted to put the entire story before the jury for the jury to determine what, if any, liability the defendants that went to trial have?
Your Honor, the reason for them not permitting the defendants from, being looped into this entire situation is because of the fact that they were separate events, Your Honor. The lower court had already ruled that they were separate events because the entities leading up to Lannister's incident had already settled, and that was the lower court's decision.
Right,
Attorney, I'm sorry, go ahead.
The lower court, that's why we're up here, right?
Sorry, you cut out, Your Honor. One more time.
May have been wrong. The lower court may have been wrong.
But, Your Honor, but in this incident, they aren't wrong. They are not correct. And that is because, again, they were separate events. And it was unforeseeable that the pilot would crash into Lannister's taxi van as they were operating reasonably. And, again, I can go back to the orbit of danger and the orbit of danger doctrine itself, which establishes and it suggests that liability is only present if foreseeable harm is present in that area. This is what the lower court was this is how the lower court came to their decision that the entities involved in Lannister's separate taxi crash was because of their separate events, and it was unforeseeable.
Did the separate taxi crash kill? And I know this might be a different part. Your co-counsel will address this as well. But did the taxi accident kill your client?
The taxi accident did not kill Lannister.
All right, but yet there's a wrongful death claim.
Yes, Your Honor.
So if the taxi accident didn't kill your client, but caused some injury, right? Why wouldn't it be proper for the jury to holistically hear in totality all of what happened so they can determine for themselves how much liability to place on each person that's been involved?
Your Honor, the wrongful death claim itself relates back to these facts, Your Honor, that, again, there were separate events. The wrongful death claim, it can be argued against the wrongful death claim because they were separate events. As I was saying previously, in Zilka v. Santik's construction, because the court found that the bulldozer operator was operating in an expected manner, though a piece of debris hit the bystander, in our case, the Oceanborn's plane was expected and cleared to land, so again, it was unforeseeable.
Attorney, you've only got 30 seconds. Let me just make sure I understand. Doesn't the statute, section 1451 of Title 5, require that the jury have an opportunity to apportion damages against all persons who are defendants and the including the originally named defendants in this case, against whom the seaplane and the other defendant remaining have filed their cross claims for contribution? So isn't what Judge Henderson is asking you, isn't that what's required by the statute?
Your Honor, VI Code 1451 states that, or sorry, correct me if I'm wrong, Through reading VI Code 1450, Title 5 VI Code 1451, it can be deemed that the law is the law, and we must follow the law. Hence why following the orbit of danger doctrine was operating within reason in terms of the court.
Very well. I see your time's expired. If you want to wrap up, you may do so.
Thank you. I respectfully request that this court affirm the lower court's decision due to Lannister's taxi van crash and the 1% LLC being in separate orbits of danger and foreseeability being absent. Thank you for your time.
Thank you.
All right, Mr. Mapiri, if we can get you to the podium. Judges, let me know when you're done with your notes. 1, 2. Three. All right, you may begin when you are ready.
Thank you. May it please the court. On September 12th, 2021, Natasha Lannister was fatally hurt when her taxi van, due to a brake failure, crashed. This incident led to a chain reaction in which a loose yacht drifted into the landing path of a seaplane, causing the plane to crash into the landing site of Miss Lannister's van. After Miss Lannister's passing, her spouse and adult child were able to join the wrongful death case under 5 VIC 76 and 77 to assert wrongful death claims. The defendants argued that the adult children should not be allowed to recover because the governor vetoed the legislative expansion of the statute. However, the court ruled in favor of the plaintiffs because of prior judicial decisions allowing adult children to recover, and the published version of the law still included them. The Moot Superior Court was correct in allowing adult children to recover under the Virgin Islands wrongful death statute because past court decisions have allowed adult children to recover.
But none of those decisions, I think you're talking about the Bertram case and the Gerald case against R.J. Reynolds. Those didn't even address the issue, right? They just acted as if it was a non-issue. So are we supposed to just assume that the Supreme Court knew what it was doing, or do we assume that the Supreme Court was unaware of what it was doing and didn't know about the change in the law, or I should say about the governor's veto? And does that make any difference?
Your Honor, although the cases R.J. Reynolds versus Gerald and Mystic Granite and Marble Incorporated versus Bertrand, although they did not specifically address the issue of adult children recovering, they did still award the adult child and allow them to recover in the situation, and we can assume that they did this due to the published law still including adult children. And because this was in the VI Supreme Court, we do need to abide by it, and because it is a binding court and our highest court in the U.S. Virgin Islands.
What are we abiding by? Are we abiding by an assumption that the Supreme Court knew what it was doing, or are we abiding by an assumption that the Supreme Court was unaware of the governor's veto?
We must abide by the decision of the Supreme Court.
Doesn't matter, in other words, right? Just this is what they said, that adult children can recover, and that's that.
They awarded the adult children in this case to recover, and we can assume that they did this, as I said previously, because of the codified law that does address and allow adult children to recover. And since courts have made this decision multiple times, to maintain consistency, and since it has been made in binding courts, there's absolutely zero reason to change this decision.
Well, let me interrupt you. When you say there's absolutely zero reason, the law as it stands with the governor's veto does not allow an adult to bring a wrongful death action. Isn't that correct?
Your Honor, the governor's veto was reflected in the sessions law and not the published law. And as attorneys, we must follow the published law when coming to make arguments. And as judges, you guys must follow the published law when coming to a decision.
So we should ignore the fact that we know the governor vetoed a bill which should have been put into the published law because the published law doesn't accurately reflect the governor's veto. Is that what you're saying?
Your Honor, although it was reflected in the sessions law, and we do know that there may have been an error in translation there when the law was published, we cannot change the law in this court. It is a legislative issue and that must be resolved outside of the courtroom. Upholding previous decisions help to maintain stability and fairness in the legal system. This goes along.
Attorney McFarland, let me ask another question on that. You haven't mentioned yet Section 14 of Title I, but which is correction of errors, classification of acts, in subsection A, in preparing the laws to be published in any current pocket supplement or any volume of the code. The publisher may not alter the sense, meaning, or effect of any act of the legislature. In other words, the publisher, if the publisher gets it wrong, the publisher is not permitted to get it wrong. That is to alter the sense, meaning, or effect of any act. Well, this particular bill never became an act because it was vetoed by the governor. And the legislature did not override the governor's veto. Therefore, the legislature made a determination to accept or to concede the veto. And the publisher, therefore, putting the pre-veto version into the code seemed to directly contradict subsection A of Section 14 of Title I because the publisher has altered the intention, that is the sense, meaning, and effect of the legislature. So how can we follow what we know to be bad, inaccurate law? As somebody has said previously, this is the publisher making the decision for us as to what is the law of the Virgin Islands, and the publisher is not the fourth branch of the Virgin Islands government. So how do we deal with that?
Yes, Your Honor. Although there was a publishing issue, we still must abide by the published law, and this is still a legislative issue. We cannot solve that issue in court here. We cannot adjust the law in this court, so we must not proceed like we are able to do that. We must proceed with what we have in this court, which is the published law, and we can address this. We can inform the legislator of this mistake, but we cannot physically change it in this court, and we must abide by the published law.
Attorney I have a question. So then, based on what you just said, why should we permit publishers to change the law? So that's what happened. You would agree that's what happened here.
Yes, Your Honor.
So, to your understanding, do publishers pass and enact laws?
Publishers do not pass and enact laws. However, in this case, the legislative expansion was vetoed, and in the law, even though it was still reflected, the legislative branch was still able, they should have been able to look at the published law and recognize that issue before, after in the past.
But they didn't. So one could argue that the legislature intentionally didn't seek to correct something because the governor vetoed something they wanted. So they're not going to call anybody to say, oh, hey, publisher, go correct that. I guess what I'm trying to understand is when we think about, I think your argument was that when the publisher publishes something, if it's wrong and nobody corrects it, it becomes the law. But what happens when the law itself or the document or the bill or the act, not act, but the bill never became law. Like in this situation, it's not like something was passed and when the legislature passed the law, it was $10,000. And then unfortunately, the publisher typed $100,000. In this, that's one thing, right? Because it passed. In this situation, the governor specifically vetoed that provision, which said that it was not the law at all. And in comes the publisher who does not account for what the governor vetoed. And your argument is that, well, it has to be the law because the publisher said adults can file suit and the legislature never said anything. Isn't that the publisher enacting law?
Yes, Your Honor, that is an argument that you can make. However, this has been the law. This has been published for many years now. And we can also not only just look at the published law, but there is also judicial precedence. For this, I would like to go to the case World Fresh Markets LLC versus Palermo. In this case, the courts relied on established law when coming to a decision, and repeated judicial decisions allowing adult children to recover should follow the same principle.
And why did they do that? They did that because they looked at what was printed in the books.
Yes, Your Honor.
Right. So, if they were wrong, is it now not our responsibility to correct that wrong?
Your Honor, it is not our responsibility in this court to correct the problem between the publisher and the disconnect between the publisher and the legislative veto that happened.
But isn't it our job to correct the law?
Yeah, no, Your Honor. The law is supposed to be corrected with the legislature. The legislature should be looking at the law and should make sure that it's up to date and correct.
And they didn't.
Yes, Your Honor, you are correct.
So isn't it the court's job to now say, wait a minute, that's not the law, as part of our checks and balance process? Isn't it now our job to say, wait a minute, that's not the law? Are you saying that the court can never correct itself?
Yes, Your Honor, you are correct that we can and we should update the law in the future, but the issue is that we cannot correct it in this law, in this court, and we must, as a part of the court, we must follow the law.
Why can't we do it? Why can't we correct it in this case?
In this case, we have many reasons to proceed based on the published law. Not only just the published law, but it has not been corrected in so many years. We must proceed based on how court cases have been treated in the past.
What are those reasons?
I would like to follow with my next case to bring up another reason.
Okay.
In Fleming Foods of Texas Incorporated versus Rylander, the court ruled that the written version of the law takes precedence over conflicting legislative history, and the same idea applies in our case, showing that the official law supports adult children to recover, and this law takes importance over the governor's veto.
What do you perceive to be the conflicting history?
The governor's veto, as shown in the Sessions Law.
It's unclear. Is it right? Is it in dispute, to your knowledge, that the governor vetoed that section of the bill?
No.
So that's not in dispute. So that doesn't that make that case you just mentioned inapplicable or at least distinguishable?
It does make it distinguishable, but in this case, we have seen that the law has been written and published for many years, and we do have past cases that have allowed adult children to recover, and we need to proceed in the same fashion.
It has been published incorrectly for many years.
It has been.
Right. Which means that this has not been the law for many years. Despite whatever reliance there may have been before, that wasn't the law. And so the question I again have for you is, should we not now that we all know, you know, I know, Judge Brady knows, Judge Cannon knows, everybody knows that that was not the law. Is it not now for us to correct that?
Can acknowledge that, but even so, In this case, Miss Lannister's son was dependent on his mother, and we must still respect that. Even though that he was an adult, we must still reward him here and allow him to recover, as he was still a dependent.
Supposed to respect the law, which says that he's an adult, whether he's dependent or not, he's an adult, and he doesn't get to bring a claim. It's for minor children. He's not a minor child, correct?
He is not a minor child, but he is still dependent on his mother.
We should not respect the law.
We should respect the law as published.
Okay.
The Moot Superior Court also followed precedent. Courts should be consistent when coming to a decision. The court followed precedents and was consistent in their decision. If the court changes its decision now, it would create an inconsistency based on past wrongful death cases. The Moot Superior Court made the correct decision because it followed precedent, the published law as written, and past court decisions. Changing the decision now would go against precedent and create unnecessary uncertainty in future wrongful death cases. For these reasons, I respectfully request that the Moot Superior Court affirms the decision of this wrongful death case. Thank you.
Thank you.
Thank you, Mr. McFerrin.
All right, and since that is the last person for Antilles, they will stay in the group chat to be able to listen to the rest. I won't be moving them in to the waiting room. And up next, I will get Good Hope Country Day School in. Good morning, Good Hope Country Day. Just so you know, Antilles School will be on because they have finished arguing. So while the judges are finishing up with that round of scoring, let's get your camera on and do a sound check. All right,
Hi, good morning.
Good morning.
Can
You can hear me?
us?
Yeah, I can hear
Yes,
you just
I
fine.
can.
Okay, good. Then when the judges are ready, we will have you put your notice of appearance on the record.
Perfect.
I see two, just waiting on. All right, please, please put your notice of appearance on the record.
Good day, judges. My name is Neve Tricoche, that's Tricoche, from Good Hope Country Day School, and I'm representing the first issue on appeal on whether the Mid Superior Court erred when they refused to allow the defendants to argue that other parties contributed to the cause of the accident, and whether they further erred by refusing to allow contribution claims against those parties. May it please the court, good day. My name is Aliyah Bluhu, that's Aaliyah, last name Boodhoo, from Good Hope Country Day School, and I will be representing the appellants and addressing the second issue on appeal, arguing whether the Moot Superior Court erred by allowing adult children to recover over the vetoed expansion of the class limitations.
All right. You may begin when you are ready.
The Moot Superior Court erred in refusing to allow the defendants the 1% in ocean-borne air transit to present evidence to the jury that other parties were responsible. This exclusion not only impeded the defendant's ability to mount a full and fair defense, but also ran contrary to the well-established principles of fairness for two primary reasons. Firstly, while 5 IC 1451 establishes a concept of joint and several liability, it does not preclude a defendant from introducing evidence that other parties, whether settled or non-settling, contributed to the plaintiff's injuries. The statute ensures that a plaintiff can recover the full amount of damages from any liable defendant, but it does not.
Tricoche, excuse me, Attorney Tricoche.
Yes,
Didn't the Palermo case determine that the jury was going to be prohibited from comparing the negligence of the World Fresh Market, where the customer slipped and fell, and the non-party landlord who had settled the case, where the drip came through the roof? Why isn't that binding on us?
Your Honor, that is not binding on us because the Palermo case was a bit different. In this case, it was a personal injury case, and halfway through, unfortunately, Lannister succumbed to her injuries and died, changing the claim from a personal injury claim to a to a wrongful death claim, Your Honor. This means that Palermo is not applicable in this instance because it's a different case and the case has changed.
But don't we still have to you're asking us to compare the negligence, are you not?
I am asking
among all the actors.
Yes, Your Honor. I am asking you to compare that negligence. However, the Palermo case isn't applicable because the Palermo case didn't go through a claim change as this one did. It's a different case now, because of the claim change, because it changed from a personal injury claim to a wrongful death claim, Your Honor.
Thank you.
Of course. While 5 AIC establishes a concept of joint and several liability, it does not preclude a defendant from introducing evidence that other parties, whether settled or non-settling, contribute to the plaintiff's injuries. As a result, this denied the defendants the 1% and ocean-borne air transit the opportunity to present relevant evidence concerning the potential liability of other parties such as St. Thomas, Super Shuttles, GMC Brakes, and others. These parties were directly involved in the chain of events leading to Lannister's injuries and could have shared in the responsibility. The defendants should have been allowed to argue whether these parties contributed to the cause of the accident.
Let me interrupt you. And
yes,
I understand your argument, but I want to ask, doesn't the law which requires that cases where the parties settled not be brought into evidence because of the prejudice it might create in the eyes of the jury if they heard that these other parties had settled, so that the jury would not find that the defendants are not liable because the parties that settled should be held liable instead?
I'm sorry, Your Honor. Can you please repeat that?
Yes.
Thank you.
The fact the trial judge below did not allow your defendants to bring in the other parties.
Yes.
Because they had settled the case. And you begin your argument by saying that it's fair that the jury be able to consider all the parties that might have been actors in it causing the accident. The fact is, though, when a party settle a case, it implies that they did so because they're liable. And if the jury was to have heard that, they would think that your clients, the defendants, were not liable. And that's why the judge made sure that that was not brought into the case. It's not the prejudice. So you agree with that?
No, Your Honor. I disagree with that. The case that they settled was for a personal injury claim, not a wrongful death claim. Lannister died during the process. So when they settled, they were settling a personal injury claim, not a wrongful death claim, Your Honor.
So are you saying that Lannister can bring another wrongful death action against the parties that settled?
Yes, that is what I'm saying. Yes, Your Honor.
All right.
Or the plaintiff, excuse me, not Lannister. By preventing such claims, the trial court effectively deprived the defendants of a safeguard, potentially leaving them solely responsible for the entire financial burden of damages that they did not fully cause. Defendants are typically allowed to raise all defendants and claims related to the responsibility of others, which is an essential aspect of ensuring fairness in the litigation process. This would have been relevant to the question of how liability should be allocated among the parties by jury. By preventing contribution claims, the court denied the defendants an opportunity to do this and seek some form of reimbursement for what they might ultimately pay in damages, especially if those other parties were partially at fault. Secondly, yes, Your Honor.
Didn't the court already make a determination that superseding clauses were not applicable?
Repeat, please. I'm sorry. May Your Honor, may please repeat?
Already make a determination that
yes.
clauses are applicable. And if so,
Yes.
Was it the trial court required to follow that directive?
Yes, the trial court was required to follow directive for the case on personal injury, Your Honor.
So you're making a distinction
I
between
am.
the wrongful death action itself and personal injury action.
Yes,
So that you
because it was a new case.
that because it's a new case, whatever persons that settled, it didn't include all claims, so that everybody else can be brought in now on a wrongful death action.
Are you asking me if that is what I'm asking for you to do, or are you asking me if that's what occurred?
Yes, if that's what you want this court to do.
Yes, that is exactly what I am requesting this court to do.
Okay.
And bring everyone back into that a jury may hear evidence, important evidence, that I believe is necessary. Secondly, as stated in Wolf versus Checker Taxi Company, the active and efficient cause that sets in motion a chain of events which brings about a result without the intervention of any force started and working actively from a new and independent source is the direct and proximate cause. The principle articulated recognizes the importance of identifying the true proximate cause amidst the sequence of events. The defendants were prepared to argue and should have been allowed to argue that Lannister never would have been at the plane crash site had the brakes not failed.
So let me interrupt you just to make sure I'm clear. Who do you sort of identify as being the proximate cause of the plaintiff's wrongful death?
Mm-hmm. Who do I identify?
Yes, which party?
Your Honor, I identify that the party that is responsible is St. Thomas Super Shuttles, in my opinion, because the brakes failed and Lannister lacked proper training to maneuver the vehicle after the brakes had failed, Your Honor. So although there are many causes that go into the chain that eventually led to Lannister's death, I do believe that the point was that other parties, that the jury should have been allowed to hear that evidence, and they were not allowed to.
Okay, so if you say that the employee and the brakes were the proximate cause,
yes,
and you say that that was part of the personal injury, then the wrongful death claim, which is the party that you are defending now, aren't they the one that caused her death? Because she didn't die when she was thrown from the shuttle taxi. She died after the crash of the plane as a result of the yacht. Isn't that correct?
No, Your Honor. She died later at the hospital. She succumbed to the injuries that she accumulated during the entire chain of all causes of the accident, not specifically after the plane crash and the yacht collision. She died later on, Your Honor.
All right.
So I believe that all these causes led to her.
Thank you.
Yes, Your Honor. The defendants were deprived of a chance to demonstrate that the injury and later death was also caused by earlier events, and that Lannister never would have been put in that position there at the yacht collision at the plane crash had the brakes not failed previously. Your Honors, several liability, when considered along several principles, provides a necessary framework for allocating fault equitably among all factors whose conduct may have contributed to the plaintiff's injury. It ensures that.
I want to go back to what Hannah, because I want to make sure I'm clear.
Yes.
You made the argument that you are making a fine line distinction between the personal injury action and the wrongful death action.
Yes, Your Honor.
Are you saying that all defendants are part of the personal injury action and the wrongful death action, or that there's some defendants that are only personal injury and some that are wrongful death?
Oh, no, Your Honor. I am stating that all of the defendants should be brought in for the wrongful death claim. Because they were all, it was an unbreak, the chain did not break. And they were all, eventually, all of them did lead to Lannister's eventual death.
So
all
then
of them.
why are you arguing that there is personal injury and there's wrongful death?
Your Honor, I'm arguing that there's a difference in the case, not a difference in the defendants who played a part in causing this accident, Your Honor, because the claim changed.
So if there's no difference in the case, then
yes.
Response to Justice Cannon's question in regard, or it may have been Justice Brady, but in regards to why we don't have people who settle out, their information brought into the case after they've been settled out.
They did not settle out, Your Honor.
They
were, well, they did not, Your Honor. They were barred from presenting evidence. And yes, the plaintiff recovered with those two defendants, but those defendants were prohibited from presenting evidence that other parties contributed to the cause of personal injury. Regardless, the defendants were prohibited from doing that and barred from presenting that evidence to the jury, Your Honor. So yes, they did recover with those defendants, the defendants 1% and Ocean Board and Air Transit.
But they didn't recover as a result of a determination by the jury.
Yes, exactly, which is what should have happened. Because the standard is that for cases of negligence, the court prefers to defer to the jury, and they did not do that.
But didn't these defendants settle, meaning they didn't even have a trial?
No, they did not.
And so
it was a wrongful death.
They did not have a trial. Then there was determination of their liability on the merits.
I'm sorry, Your Honor, you're breaking up. Can you please repeat that?
Okay, so that
yes,
they did not. If they did not have a trial, meaning they settled the claim, and they didn't have a trial, then that means there was no determination of their liability on the merits.
Yes, Your Honor.
So that wouldn't it then be correct that whatever they settled, how they settled, should not be a part of the case that actually has a trial?
No, Your Honor, because at the time it was a personal injury case. It is now a wrongful death case. So what they settled, it seems my time has concluded.
You can finish answering the question and then you can briefly summarize your argument.
Thank you, Your Honor. No, Your Honor, it was a personal injury case and it changed to a wrongful death case when Lannister died. They should have had the opportunity when the plaintiff recovered with the defendants, they should have had the opportunity to present evidence that those other parties contributed to Lannister's death, and they did not have that opportunity. And the jury should have been able to hear that, and they did not, Your Honor.
Thank you.
Thank you. Because of this fact, we respectfully request that the court reverse the decision and allow a retrial by jury. Thank you, Your Honors, for your time.
Thank you. Thanks for coaching.
All right, Ms. Voodoo, get ready when okay, we got one ready. When the Moot justices are out, 2, 3. All right, you may begin when you are ready.
May it please the court. The court should reverse their decision for 3 main reasons. First, the Moot Superior Court erred when it misapplied the statute, Title 5 VIC 76, by allowing adult children to recover for wrongful death. The Superior Court instructed the jury to improperly act under Title 5 VIC 76, the wrongful death provision, which states that the provision is for minor dependent children. Secondly, the governor's veto was a lawful exercise of his authority. While the 2001 revisions toward this act did happen, the governor vetoed a portion of it, and there was no legislative override towards this act. Lastly, statutory interpretation principles that are represented in cases make it clear that courts must apply only validly enacted law, not what was mistakenly published or assumed.
Let me interrupt you. Uh, isn't it a fact that under our laws that if there's no attention brought to the publish within 30 days, then that law is considered valid?
No, Your Honor. That is not a law because it is shown in cases before that, such as DC versus Thompson, that validly enacted law should stay as it is stated. So if the law is stated and printed, it should remain the law unless explicitly repealed.
Okay, so using that ruling, the law that was specifically stated in the Virgin Islands Code allowed a adult to bring a wrongful death action. Is that correct?
Yes, that is correct.
And you are asking this court now to reverse that. Is that correct?
Yes, Your Honor. Yes, Your Honor.
Well, how is it that you can agree that it was correct, the law was correct, and yet at the same time ask this court to reverse a law that was correctly published in the code?
Well, Your Honor, the law was not correctly published. It was incorrectly published. The governor used his executive authority under the Section 90 of the Revised Organic Act to veto the amendment that the legislature attempted to make to the title. However,
excuse me, was that put in the code?
The amendment, yes, the amendment was put in the statute under.
Okay, but was the veto of the governor acknowledged?
Yes, it was.
All
Yes,
right.
Your Honor. The veto was acknowledged. The issue here is that the publishing party misprinted the correct statute. And that is what I'm here to argue. As the governor used a legitimate use of his executive power, it should be followed by courts throughout the determination of who can successfully recover under Title V VIC 76, the wrongful death statute. The veto reflects a decision in order to limit the ability to recover for wrongful death to the plaintiffs who are financially dependent on the decedent at the time of death. Allowing independent adult children to claim wrongful death damages undermines the intent of the wrongful death actions, which is typically meant to provide compensation to those who are financially dependent and therefore suffer a true loss from the death of the decedent.
Attorney Budo, didn't the Supreme Court implicitly acknowledge that adult children may recover in the Bertrand case and in the Gerald against R.J. Reynolds case? There was no analysis by the Supreme Court to determine whether or not those adult children were dependent upon their parents. So the Supreme Court appeared to simply be applying the 2001 revision to the law that the governor vetoed. Is that the appearance from those two decisions?
Well, Your Honor, the difference between those cases and this one is that the issue of the statute was not brought to the court's attention at the time. So the court had no choice but to go with that law. They had no idea that the wrong statute was published. But now we do realize that the incorrect statute is published, and we are asking you to reverse the court.
So we're assuming that in those two cases that the Supreme Court was just unaware of the governor's veto because the Supreme Court relied upon the published version, correct?
Well, the law has been incorrectly applied for the past 20 plus years. So yes, we are assuming that the Supreme Court did not know of the incorrect statute being published because it has been followed incorrectly for so many years.
All right, and while you're just answering, how about Section B, subsection B of Title 1, Section 14, which seems to say that after the publisher notifies the legislature and the governor's office that here is the new code that we're going to be publishing, you've got 30 days to file any corrections. And this is a statute. So this is a Virgin Islands legislature put this in place. It says without such correction, then this section, then the matter that is published becomes law. Does that not apply here? That after the 30 days passed and nobody told the publisher this is wrong, then because of the statute the legislature put in place, Title 1, Section 14B, that failure to correct means that probably for the purpose of avoiding any confusion like we're dealing with here, then the incorrect version has become the law by virtue of the failure to correct by the legislature or the governor or anybody else.
Well, Your Honor, we have no proof that the publishing party did notify the legislature and the governor. However, in Title 1, VIC 14, subsection D, it does state where there is no direct alteration made by the publishing party, barring the incorrect version being published. The courts should be correctly applying statutes as they were meant to be applied because the law is still the law, regardless of the incorrect statute being published. The law was never changed and it was validly enacted because the legislature had their power to override the governor in his veto, and they did not. Therefore, the governor's veto was final and the law became the law. Your Honors, adult children in most cases such as this one are no longer dependent on their parents. And they can't
Let me interrupt you. You made that argument earlier. What evidence is there on the record that the adult child is independent? I mean, a lot of the adult children in our culture live in their family's home, still receive income and food from their parents, still basically depend on their parents. What evidence do you have that he's independent?
Well, Your Honor, there is no direct proof in the fact pattern that he is not dependent. However, there is proof that he is an adult child to Lannister. And if he was a dependent adult child, there is a section in the statute, Title 5 VIC 76, I believe it is subsection G, that does state that dependent adult children, as long as they can show and prove their dependency to the decedent, can recover. So the statute already applies for
that. Thank you.
Does the published version of that's in the VI code in regards to the wrongful death statute accurately reflect what the legislature intended? And if so, isn't that what should be the law of the day?
Well, Your Honor, the legislature did intend to amend the statute in the first place. However, Governor did use his executive power to veto that amendment. And the legislature had the full power and authority to override the governor's veto. They did not use their power to override the veto, and they made the law final. Therefore, the legislature's intent does lie with the governor in the final law. In Fleming Foods versus Rylander, it states, courts must give effect to what was actually enacted into law. In Fleming Foods, the Texas Supreme Court refused to apply a codified version of a statute when the codification process introduced an unintended change, not supported by legislative action. The same principle should apply here, as the governor's veto was lawfully exercised, and the legislature did not override it. Furthermore, in DC versus Thompson, the court held that ignoring an unrepealed statute due to a codification error was improper and a violation of the separation of powers. The court in Thompson states the legislative will is found in the enacted statute itself, not in unofficial compilations or unratified amendments. Reliance on the printed version of the code rather than the true veto text is a clear legal error. Also stated in DC versus Thompson, but that condition does not bear on the continuing validity of the law. It is only an ameliorating factor in enforcement. This case reaffirmed the legal validity of anti-discrimination laws that were long dormant, setting a precedent that laws will remain in effect unless explicitly repealed. Your Honors, as we recognize that it has been allowed for adult children to recover for wrongful death in recent years, the court should not continue this malpractice of applying incorrect statutes to current cases. The court should be correctly applying statutes as they were meant to be applied. As seen in Title 1 VIC 14, subsection 8, The publishing error classifies as a correct manifest typographical and grammatical error. Also in Title I VIC 14, Section A, which states, the publisher may not alter the sense, meaning, or effect of any act of the legislature. By printing the version that did not reflect the governor's veto, the publishing party altered the meaning and effect of the governor. Though the legislature did intend to expand on the statute, the governor in his power vetoed that expansion, and the legislature did not use their power to override that veto, making it final. In Fleming v. Rylander, the Texas Supreme Court states the repeal of laws is as much of a legislative function as their enactment, and that the printed version of a law needs to reflect what is in the legislative history. If the law was successfully amended, it could have been reviewed as such under the wrongful death provision. However, the law was never changed. Only the amended version was published in error. If the courts continue to allow adult children to recover the I see my time has concluded. May I briefly conclude?
You may.
Yes.
Thank you. Your Honors, we request this court to reverse the Moot Superior Court and reaffirm that only minor dependent children may recover through the wrongful death claims. Thank you for your time and consideration.
Thank you.
Thank you.
All right. Well, thank you, Attorney Marinelli. Your replacement was on. I should have actually let you go a little early. I apologize for having you over. We appreciate all your help this morning, and have a great rest of your day.
Happy to do it. Take care.
So Good Hope Country Day doesn't have any other participants, so they're staying on, listening in to the rest of the arguments. Attorney Letson, can you put your camera on and say hi so that All Saints and the justices can pin you up in the corner and know, yeah.
Oh, God. Hello. Good day.
All right. So,
camera.
I was gonna say, is your camera working? Because that's kind of essential.
Yeah. Yeah.
All right. So we
I
got
might
the
have
camera.
to.
All right.
I might have to switch just 1 second, but go ahead.
All right. So All Saints, mark her up, and so she doesn't move when other people are talking and everything. With that delay, we're probably ready for notice of appearance. Are the Moot justices ready?
Yes.
Yes.
Okay. All right, then, All Saints, let's get your notice of appearance on the record.
Good afternoon, Your Honors. May it please the court. My name is Kiori, spelt K-E-I-O-R-I, Francois, spelt F-R-A-N-C-O-I-S, and I am representing the appealee in Issue 1 on behalf of Vikings Law. Thank you.
Good afternoon, Your Honors. May it please the court. My name is Jaedon, Jaedon, Hodge, Hodge, and I'm representing the appellees on Issue 2 for behalf of Vikings Law Firm.
All right, Ms. Francois, you may begin when you are ready.
Good afternoon again, Your Honors. The defendants squandered their rights. This case comes before you after a jury found Oceanborn and the 1% liable for the death of Natasha Lannister, who tragically passed after being struck by debris from a seaplane crash. Before that trial, several other defendants settled and exited the case. At trial, the court barred the remaining defendants from shifting blame to those settled parties or seeking contribution from them. The defense now appeals that decision. Our position is clear. The trial court rightly ensured that the plaintiffs were fully compensated by those who were legally responsible for Lannister's death. This appeal is not about revisiting the facts of who caused the harm. This appeal is about whether the defendants followed the proper procedures to file contribution claims at the right time, and they did not. The case is not about pointing fingers or shifting blame. It is about respecting the rules of procedure, the protections of 5 VIC Statute 1451, and the integrity of the trial process. First, the defendants failed to file contribution claims in a timely manner. Second, because of that failure, the remaining defendants are jointly and severally liable under 5 VIC Statute 1451. Third,
The trial court was correct in holding that the earlier facts, including the van accident and other events, were too attenuated to shift liability.
Attorney Francois, didn't the seaplane and the that is oceanborne and the 1% actually file contribution claims, file cross claims against all the other settling defendants?
Great question, Your Honor. They did, but they did so in an untimely manner. They filed their contribution claims during the appeal, which is not the right procedural time to do so.
So in the at the trial court, they had no active cross claims.
As the facts present, no, they didn't.
And so, how does that that set of facts fit in with the decision in Palermo against World Fresh?
In the Palermo versus World Fresh Market case, the World Fresh Market tried to file third-party claims against the landowner or the landlord, but he did so in an untimely manner, and that's why the court ruled that he could not file contribution claims because it was done so in an untimely and unprocedurally manner.
And so, according to your understanding of the procedural history, this case is on all fours with Palermo. Therefore, we're bound to exclude any potential comparative negligence because the settling defendants are not quote unquote defendants under 1451 of Title V in this case. Is that right?
Yes, that is correct, Your Honor.
Okay.
First and foremost, this case turns on timing. The legislature enacted 5 VIC Statute 1451, fully aware that the Federal Rule of Civil Procedure 14 governs third-party practice in the Superior Court. Rule 14 requires defendants to bring in third-party contribution claims within 14 days of serving their answer or later by motion. This ensures fairness and allows all parties, including plaintiffs, to participate in determining how liability is shared. This trial court followed this framework, ensuring the process remained fair and efficient. Your Honors, the defendants missed their opportunity. Contribution claims were settled during the first appeal. During the retrial, before the retrial was ever...
Let me interrupt you. So I need to make sure I'm clear on the facts. The contribution claims was settled during the first appeal. That is correct, right? You just said that. All right. And the case was brought back to the trial court for a retrial on the wrongful death action. Is that correct?
That is correct, Your Honor.
And so the trial court took the position that because the other parties had settled in the first case, that settlement and those parties would not be brought into this case that we're before the appellate court at this point to make a decision on. Is that correct?
That is correct, Your Honor.
But you're saying on top of that, in addition, that these defendants in the second case for the wrongful death action, I apologize, did not file a third-party claim or a counterclaim or a contributory claim against those other parties that had been settled out or the plaintiff. Is that correct?
That is correct, Your Honor.
All right. Now, not trying to be too technical, can you show me in the fact pattern where that might be? Can you read it to me? Is that too challenging for you at this point?
What exactly would you like me to
where the trial court ruled in the second case that these defendants could not bring in those other parties because they failed to file contributory claims or third-party claims or counter claim. Is that something you can go to? If it's not, it's all right. I understand it might be challenging.
I can do something from what I understand from the facts, if that's all right with you.
Yes, go right ahead, please.
In the facts, it did mention that during the appeal, the non-settled defendants and the defendants both resolved contribution claims, meaning that that was the chance. All before the appeal, they had the opportunity to file the contribution claims and they failed to do so. And that is why in my argument, I am arguing that the court was right in not allowing them to file contribution claims because they did not do so in a timely manner when they had the opportunity to do so.
All right, now I understand your argument. Thank you.
Thank you.
But Attorney Francois, were they really contribution claims if parties just settled?
Repeat your question, I'm sorry.
Are they really contribution claims if the parties just settled?
How can they file contribution claims if the party is already settled?
Well, that's another question. But the one I was asking you is, because I think if I understood your responses to Justice Cannon, what you are saying is that the parties who are no longer in the defendants, I should say, who are no longer in this case, right? You're saying that they settled their contribution claims. Did I hear you correctly in your response?
Yes.
So you are calling what they settled contribution claims.
No, I believe I may have confused you all when I was stating the facts to Judge Cannon. So if I may, could I restate the facts in a way that could be a little understandable? In the initial trial, all parties were present. So St. Thomas Super Shuttles, GMC Breaks, all of them were in trial. The jury from that trial was using a superseding cause, and they found that Oceanborn and the 1% were 100% liable for the injuries to Natasha Lannister. That trial or that verdict was appealed to the appellate court. During the appeal, the settled defendants decided that they wanted to settle, and they did so. This was the time, and all times before so, this was the time for all the defendants to file contribution claims. Now that the appellate court has given the jury the fact that they have to use the 5 VIC statute 1451, because in the Virgin Islands, we can't use the superseding cause because it contradicts with the 5 VIC statute 1451. They now are trying to bring in contribution claims because they do not agree with the verdict that happened at the trial court.
I fully understand. Thank you.
Thank you. Despite 5 VIC statute 1451 always being the governing law, the defendants chose the wrong legal strategy and now seek to reopen claims they should have addressed earlier. This is a procedural failure on their part, not a denial of opportunity. Even if the defendants were somehow allowed to bring settled parties back into the case, they would still face the same issue. They never involved the plaintiffs in contribution discussions to determine liability shares. Contribution claims directly affect the plaintiff's recovery. Plaintiffs have a legal right to participate in those discussions because how fault is divided impacts their compensation. Without having filed proper third-party claims, the defendants risk paying more than their fair share regardless. This is why contribution claims must be handled at the proper stage to ensure fairness for everyone involved and to avoid unnecessary complications. As the court held in Walford...
Attorney Francois, aren't you, by the position you're taking, aren't you discouraging parties from settling? I think that generally speaking, the courts want to encourage the parties to resolve disputes without the intervention of the court, of the court as a third party to impose a judgment on the parties who have a dispute. If the parties are able to resolve things on their own, then it's better for judicial efficiency, and it's better for the parties because they have an agreement with which they can live. But if your position is once you settle a contribution claim, don't expect that you're going to be able to come back looking for anything from us in the future. You're going to discourage anybody from ever settling cases, and every single case is going to have to include all the defendants in order to get the relief that you say can only be accomplished if there is no settlement in advance.
No, Your Honors, I apologize if that's how I'm coming off. My argument is to prove that the trial court was correct when they denied the defendants, the remaining defendants, Oceanborn and the 1%, to file contribution claims because of the time that they filed the contribution claims. The settlement people are already out of the case, and the non-settled defendants, Oceanborn and the 1%, had their opportunity to file contribution claims against those now settled defendants.
But they did so, did they not? And those contribution claims were settled among the defendants, isn't that the way it?
Yes, among all defendants before they settled during the appeal, yes.
And that included the Oceanborn and the 1%, correct?
Yes.
All of them settled their claims.
Correct.
But now what you're saying is that, notwithstanding the fact that all defendants acknowledged among themselves that we all have to kick into the pot here because we all have some kind of role here. What you're saying is that because of some failure procedurally to file a cross claim in a timely manner, then Oceanborn and the 1% are now barred from asking the jury to evaluate the respective fault of all of the defendants under 1451, because all of them would be considered defendants using the language of that statute, as the Supreme Court pointed out in the Palermo case.
May I ask you to rephrase your question in a way that I can?
Yes, I was just rambling there, wasn't I? Let me just ask you. I guess what I'm saying is that your point is that the failure of the two remaining defendants to timely file a cross claim for contribution means that they're out of luck here. Is that it?
Essentially, Your Honor.
And so that lawyer better get his or her malpractice insurance premiums paid quickly. Anyway, go ahead.
5 VIC Statute 1451 mandates that defendants who remain in the case at trial are fully responsible for the harm caused. Importantly, Statute 1451 only applies to defendants still named in the case. Once others have settled and exited, apportionment of fault can only happen between the remaining defendants. Here, that's Oceanborn and the 1%. The trial court...
Let me interrupt you, because I understand clearly your argument, and I don't want to confuse you with my question. But let's assume you're correct, that the two defendants failed to file cross claims and therefore they're barred now in bringing it up. What about the concept that they're not asking the court to bring the other parties in to contribute to the liability? They just want to be able to present to the jury the evidence of the full factual pattern so that the jury could know that they're not the one that caused the accident. It was the brakes that went out and the employee who really was the cause of the accident.
May I ask you to rephrase the question in other words?
In other words, the defendants are not asking for the judge in the lower court to bring the other parties into this case. They're asking the judge to just allow them to present the facts of what happened so the jury could know they're not the ones who are liable. Other parties are, and they're not in this case.
Your Honor, I understand your question, and I am not ready to answer.
Okay.
The defendants had their opportunity to ensure that if they had filed contribution claims in the initial trial, Then now when the appellant court had brought back down to the trial court, hey, you need to use the 5 VIC statute 1451 and not the superseding cause, the settled defendants would have still been in that case because they filed the contribution claims. Because they had not ensured that they filed contribution claims in the initial trial, they can now not try to file contribution claims after the appeal.
All right. I'm not talking about the claim now. I'm just talking about being able to just say to the jury, these are the facts. The judge denied that. The judge didn't allow them to present the facts of the other parties at all, the other people, the other entities. Is that correct?
I believe so.
And you don't think that that should be reversed by this court, that we should allow the jury to hear all the facts?
Respectfully, no, Your Honor, because like I said earlier, the defendants had their opportunity to bring that to the prior jury at the initial trial and now at this jury, because if they had brought it to the prior jury, it would have been in this fact pattern as well that the now jury has.
Thank you.
The trial court followed this rule precisely, ensuring plaintiffs receive full compensation from those still standing, allowing defendants to revisit settled matters or shift blame to exited parties would undermine Statute 1451 structure and delay justice. This statute is designed to protect plaintiffs' rights to full and timely recovery, not to shield defendants from the consequences of failing to act when they had the chance. It is important to recognize that this case is not primarily about proximate cause. It's about procedural timing and the application of Statute 1451. However, proximate cause does confirm that Oceanborn and the 1% were the only defendants properly held liable. But for cause, the idea that the van crash put Lannister at the scene is not enough. Proximate cause requires that the harm be reasonably foreseeable result of the defendant's actions. The brake failure may have set the scene, but the seaplane crash caused by a drifting yacht, stormy weather, and pilot error broke the chain of foreseeability. This principle is reinforced in Rivac versus Cowpet Bay West Condominium Association, Zilka versus Sanctis Construction, and Dashram versus Shrum. Liability is limited to those whose actions directly led to the harm. These cases collectively support the trial court's ruling under broader negligence principles, ensuring that the defendants are only held liable when their conduct has a direct and foreseeable connection to the harm caused. These precedents specifically reinforce the limits of negligence liability. The trial court's decision ensured that...
Excuse me. Didn't the Supreme Court in Palermo against World Fresh, I think, more or less straight out say that if there were a contribution claim that had been made by World Fresh, then yes, it would have been proper for the jury to consider the liability of both World Fresh and the landlord. Is that your understanding of that case's holding?
Yes.
Okay, well, in this case, there was a contribution claim that was made against all the other defendants, and all of the defendants among themselves settled their cases. So at that time, everybody agreed that we've all got a piece of this. But now you're saying when they go to the second trial in the wrongful death action, then all of that goes out the window. And notwithstanding the fact that a contribution claim was presented, the jury is limited in its review of what facts can be reviewed and what defendants can be deemed at fault under 1451.
Your Honor, this comes back to my argument about timing. Had the defendants filed the contribution claims in a timely manner, they would have been able to do so. My argument is to show the court that they were correct in not allowing the defendants to file the contribution claims in an untimely manner, not because they can't file contribution claims at all.
Very well.
Your Honors, this case is not about revisiting settled matters or shifting blame after the fact. It's about upholding three essential principles. First, the trial court properly applied the rules of timing. The defendants missed their window to file contribution claims
when all parties were present. They waited until after the settlement and the first appeal to seek to undo the closure the system demands. The trial court's decision protected both fairness and the integrity of the trial. Second, the court correctly applied 5 VIC Statute 1451, which ensures plaintiffs receive full compensation from those defendants still standing. Finally, while proximate cause is a supporting argument, it reinforces that Ocean-Born and the 1% were the parties held responsible. Your Honors, affirming the trial court's decision is not about upholding procedure. It's about honoring the very principles of justice that give plaintiffs the dignity of closure. We respectfully ask this court to affirm the trial court's decision to preserve the finality that justice demands and to protect the integrity of a process designed to bring resolution, not endless dispute. Thank you.
Thank you.
Thank you, Attorney Francois.
All right. Well, the judges are tallying and making their notes. Mr. Hodge, let's get you at the podium. Okay. I see it looks like at least one is ready. Two. Judge Henderson, you ready? All right. Okay. You may proceed when you are ready.
Good afternoon again, Your Honors. The Superior Court should affirm Mr. Lannister, an adult child, to it. My apologies. Good afternoon, Your Honors, once again. The Superior Court should affirm Mr. Lannister to file for wrongful death of the tragic death of his mother, Natasha Lannister. Lannister, an adult child who lost his mother, Natasha Lannister, in a tragic, unforeseeable series of events. First of being a tragic car accident in which Miss Lannister was driving a van full of volleyball players going to a tournament, in which there was a brake failure in the van, causing the van to crash. All the passengers ended up fatally injured in the crash, while Natasha Lannister was slightly injured. Later on, a poorly secured boat owned by 1% LLC, combined with stormy weather conditions and distracted pilots, caused the seaplane owned by Ocean Seaborn to crash into the current crash site that Natasha was present in. The debris from the crash caused her to become a paraplegic, which would then lead to her inevitable death in a hospital. According to the Virgin Islands Code, the wrongful death statute was amended in 1974, which initially brought the wrongful death claims to only minor children. But in 2001, the legislature acted to expand this class of persons entitled to bring wrongful death to adult children as well. In addition to this, the governor planned to veto that act, which would then prohibit adult children from being able to file for wrongful death. But the problem is with that is that the legislature didn't acknowledge the veto made by the governor, which then led to the publishers publishing the expansion, which did not include the veto, allowing adult children by Virgin Islands Code in Title V, Section 76, to allow them to file for wrongful death.
Excuse me, Attorney Hodge.
Yes, Your Honor.
Couple of questions. One is you just indicated that the legislature did not acknowledge the governor's veto. Is it a requirement that the legislature has to acknowledge the governor's veto? I thought it was if the legislature does not overrule the government veto, that's their step for the next action. But do they have to acknowledge it for the veto to be legit?
Your Honor, the legislature passed the bill and it went on to the governor. The governor proclaimed he exercised his veto power on the expansion of it being able that adult children are able to expand. But the legislature didn't further comment on the veto, meaning that they didn't try to override the veto it's like they didn't even know the veto was passed by the governor.
Is it necessary that they know that it's passed in order for the veto to be legit?
Yes, Your Honor.
Okay.
So this will later on lead to the action that this bill was passed onto the Virgin Islands Code in Title 5, Section 76, which talks about the wrongful death statute.
And that was a mistake, correct, Attorney Hodge?
May you repeat your question again?
That was a mistake to publish that as an act, as the amendment that the legislature put in place. It was a mistake because the governor vetoed it.
Yes, Your Honor.
It should not have been published, correct?
Yes, Your Honor.
And so, but you're asking us to go ahead and approve that mistake?
Yes, Your Honor.
Now that we understand that the publisher was mistaken for whatever reason, shouldn't we now try to implement the intentions of the legislature and the governor? I say the legislature we know had the intention to amend the law, but then the governor vetoed the law, and the legislature, even though you say maybe they didn't know about it, but they had the opportunity to override the veto. And by failing to override the veto, the intention of the legislature, we can infer, was that we will allow the veto to stand. Now that we know all of this and we understand that the publishing was in error, whosever fault it was, isn't it on us to now apply the law as it should correctly be seen to exist? That is, that there was never any 2001 amendment, and the 1974 Act still remains in place.
Yes, Your Honor. But the court or the judges shouldn't go off of what should have been or what could have been. The court should go on of what is there stated in the Virgin Island codes.
But if what's stated is wrong, and we know it's wrong, does the black and white in the book take precedent over to what we know to be truth?
May you please restate your question, Your Honor?
If we know it's printed in error, and we know that it's not accurate, shouldn't we rule applying the law that we know to be accurate, and then let the publisher deal with that later?
Well, Your Honor, there are other cases prior to this one that have went on using this law and were able to reach a verdict where it didn't negatively affect the case. So, for example, in Reynolds Tobacco Company versus Gerald, Miss England was coerced, campaigned wrongly into using Newport cigarettes around the young age of 9 or 10. This will then lead to an addiction lasting 45 years, which will then lead to her being diagnosed with bladder cancer and unfortunately dying in November of 2012. Her adult son, Javon Gerald, was able to file for wrongful death, which will then lead to him gaining compensation for his mother's death. In addition to this case, Patrice Brown was also campaigned into using Newport cigarettes at the age of 16, which will again lead to an addiction lasting for many years until in the year 2008, she was diagnosed with small cell lung cancer, and then unfortunately she died in the year of 2011. Her adult son, once again, Christian Brown, was able to file for wrongful death, which would then he was also compensated. So, Your Honor, even though it was wrong to implement the bill into the VI code without the veto, there have already been other cases that have used the same code and have went on just fine.
But just because they made a mistake, you're saying it now is not a mistake anymore? Are we bound by the mistakes that were made previously?
Yes, Your Honor.
So if you apply a mistaken rule long enough, it's not a mistake anymore. It becomes correct.
Yes, it becomes correct. Yes, Your Honor.
In your mind, Attorney Hodge, does that make sense? Is that fair? Is that just? Just because we keep making mistakes that we continue to do so?
Me repeat your question, Your Honor.
I say, in your mind, the fact that we keep making mistakes, that means that we should continue to do so, makes it fair and just?
No, Your Honor, not in that sense. The sense that I was seeing was that, yes, we made a mistake. Yes, the mistake was not corrected, but this mistake was still used in a court of law. And the fact that this mistake was used in a court of law and it worked doesn't mean that it looks now that it didn't seem as much of a problem as in the eyes of the legislator at the governor and the legislature at the time. Seeing this mistake is not as much of a problem.
It worked for whom?
Repeat your question, Your Honor.
For whom? You said the fact that it worked. It worked for whom?
It worked in allowing Mr. Gerald and Mr. Brown to be able to file for wrongful death of their parents because they were wrongfully advertised into using Newport cigarettes, which caused their addiction and the adaptation of cancer, which then led to their early death.
So they benefited from use of a law that wasn't even lawful.
Yes, Your Honor.
And so your position is that we should just continue allowing people to just use illegal laws or laws that aren't even laws to succeed on the merits simply because they're individuals who may be hurt.
Yes, Your Honor. Okay. In addition to this, Your Honor, even if the adult children are not necessarily directly dependent on their parent, there are still certain effects that they can experience when losing their parent. For example, such as losing financial support. Even though they are an adult, some adult children do still live with their parents where they gain financial support. The parents still provide them food. In addition to that, yes, Your Honor?
Attorney Hodge, it seems to me that the majority of your argument is on the issue of how an adult child may feel. Isn't the real issue in this case whether or not the governor's veto is the law of the land? Meaning that no adults can bring forth a claim for wrongful death. Isn't that the issue that we should be determining today?
Yes, Your Honor.
Right. And so do you know of any facts that the legislature did not know at all that the governor vetoed their bill, their amendment?
May you repeat one last time, Your Honor, please?
Do you have any facts to support that the legislature had no idea that the governor vetoed their amendment to the Wrongful Death Act?
Well, Your Honor, I feel like the Title 5, Section 76 of the Virgin Islands Code is the fact and is the proof that the legislator did not have knowledge of the veto.
Don't tell me what you feel. Tell me what facts do you have that would support that the legislature had no idea that the governor vetoed their amendment in regards to the Wrongful Death Act?
I don't have any at this time, Your Honor.
Okay. All right.
In addition to the factors that I was stating earlier, Your Honors, to the emotional factors and expensive hospital bills. Because remember now, Miss Lannister was in the hospital where she was diagnosed a paraplegic after the seaplane crashed into the current accident site of when the brakes failed off the van on Veterans Drive. So we'll also have to take into consideration that Mr. Lannister has medical bills for his mother. In addition to this, the adult child is not only just losing a parent, but is losing a pillar in their life, a pillar that has guided them throughout their childhood, a pillar that will continue to guide them, not from just their childhood, but throughout adulthood, Your Honors.
Accepting all of that, Attorney Hodge, does the law permit adult children file claims for wrongful death?
Yes, Your Honor. Filing to Title V, Section 76, Your Honor, yes, it does.
And how does it do so?
May you repeat yourself, Your Honor?
Do so.
It does so by allowing not just minor children, but adult children, if it would be the illegitimate child of
Where in the law does it say adult children can file claims like minor children can file claims? It says so right now in the code, right?
Yes, Your Honor.
Right. And who put that there?
This legislature, after they gave it to the publishers and the publishers published it into the VI code, Your Honor.
Did it?
Yes, Your Honor.
Was the publishers incorrect in doing so?
It's kind of an impasse there, Your Honor, because the legislator would have to tell the publisher, like the bill,
And
to
the
be
bill
able to tell the publisher.
came back to the legislature. Didn't the bill come back with the governor's objections, which is like the veto?
The veto?
Right.
Yes, Your
They
Honor.
came back together as one, right?
Yes, Your Honor.
Right. So that means that when the legislature received the governor's response to the bill, which included the veto, that means the legislature knew that the governor vetoed the bill, or at least the amendment, right?
Yes, Your Honor.
So if the publishers published the wrong bill or the wrong act, right?
Yes, Your Honor.
That's the publisher's fault?
In the terms you speak of, Your Honor, yes, it would be. But
And
even though they had made that mistake,
the publisher then can change the laws of the Virgin Islands simply by publishing incorrect law?
may you repeat that again, Your Honor? I couldn't hear you for part of it.
Does it mean that publishers can simply change our laws by publishing the incorrect law?
No, Your Honor.
So why should we allow that to happen here?
Because, Your Honor, I do not know, Your Honor.
Okay. All right.
Your Honors, these factors that I stated here today, being the citing of the Virgin Islands Code, the veto not being implemented into the Virgin Islands Code, which means that it was not implied into VI law, making it that adult children are able to file for wrongful death, and the following cases such as Reynolds Tobacco Company versus Gerald and Reynolds Tobacco Company versus Brown is exact reasons is why Mr. Lannister should be able to file for wrongful death against 1% LLC and Ocean Seaborn.
Thank you.
Thank you, Your Honors.
Thank you, Mr. Hodge.
So that was the last round of arguments for All Saints, so they can stay on and listen in. But we are now at the I'm waiting for the next. Okay, they're here. So we are now at lunchtime. We are, let me look here. We're about 15 minutes behind. Could we be back from this is to the Moot Justices because you need time to rest and everything. Could we be back at 1:15? That only gives us about 20 minutes for lunch.
Sure.
1:15, yes.
All right.
Okay.
Thank you very much. I will see everyone back at 1:15.
Thank you.
And Tracy, thank you. I think you can log if you want to stay on until lunch is over in case the next your replacement isn't on. want to see the art, not necessarily buy it, but please share it with as many people. I think it was Judge Brady who said, that there are trade-offs between an online competition versus an in-person. Part of why both rounds this year were online is that we didn't have the money and funding to provide breakfast and lunch while having you in person the entire day. So that round was canceled and moved to a remote round. We need to raise at least another $17,000 by April um, of 2026 if we want to keep the program back to normal. Uh, so, if it would be nice to increase the scholarships, but if we want to do that, we need something more around, the amount of $27,000 raised by next April. That's a lot of money to come up with in 1 year. So please, share and with anyone who would even just be remotely interested. I don't know where Judge Henderson went. That is who we are waiting on for him to return from lunch. When he logs on, we will get started. But until then, we all just need to hold tight, I guess, and wait a little bit. I can't imagine he'll be that much longer. Ah, there he is now. There we go. Good afternoon. I hope your rather brief lunch was adequate, or at least adequate enough to all the Moot justices. Moot Justice Henderson, Judith Bourne is on as the timekeeper. She's the new one. So if you want to move her wherever she is visible, that's the only change that happened while we were out to lunch. So St. Croix Central, can we get your camera on and let's make sure that your sound is working correctly and everything. Can you all hear me just fine? Oh,
Yes.
no, they're frozen.
I can.
Sorry, I must have. Okay. It's giving me. Sorry, you can hear me over there?
I can.
Yeah, but St. Croix Central isn't responding. So I'm not sure if they can hear me or if their microphone isn't working or something.
I can hear you.
Okay. All right then. Please put your notices of appearance on the record.
Can you hear me?
Yes.
Yes.
Good afternoon, Your Honors. My name is Amaya Hamilton. My first name is spelled Amaya, and my last name is spelled Hamilton. I am with the St. Croix Central High School, representing the appellants, arguing Issue 1, contribution claims. Good morning, Your Honors. Can you hear me?
Yes. Good afternoon.
Sorry. My name is Elani Lopez. First name spelled Ellany. Last name spelled Lope. I'm here with St. Croix Central High School, arguing Issue 2, wrongful death claim, representing the appellants.
Before Ms. Hamilton begins her arguments, I do want to take a moment to recognize that Amaya Pamphile and Nia Francis were alternates on this squad, and they are fully prepared, and alternates put in the same amount of work, and so we should recognize them as well. With that, Ms. Hamilton, please come up and present your arguments.
When you're ready, Attorney Hamilton.
Mr. Chief Justice, and may it please the court. This case is and always has been about fairness.
Last year, when we came before this court, we argued successfully that the superseding cause doctrine has no place in Virgin Islands law. That is because it lets some wrongdoers off the hook and only holds others accountable simply because there was a lasting time. Now the appellees, the estate of Lannister, her husband Trevor, and her adult son Alvin, seek to reintroduce the premise of that doctrine, and the lower court seemingly agreed that only our clients, 1% and OBA, were negligent. But that's only half the story, because STSS, All About Cars, GMC Brakes, and even Lannister herself all set in motion a series of events that put Lannister in harm's way. As such, we ask this court to reverse the decision of the lower court and remand this case with instructions for the lower court to allow my clients to introduce evidence of how the settling defendants contributed to Lannister's injuries for 3 reasons. First, the evidence shows that the settling defendants set in motion an unbreakable chain of events that put Lannister in harm's way and was the proximate cause of her injuries. Second, holding all wrongdoers accountable is consistent with the text and spirit of the comparative fault statute. Third, if this court sides with the plaintiffs, it'll set the wrong public policy message that people can be negligent and get away with it. At the outset, Your Honors, we want to establish that this case is not about treating our clients of their negligence. It's about sharing responsibility among responsible parties.
Attorney Hamilton, did the court below find that, contrary to what you just stated, that this was an unbroken chain of events that led to the injuries and the death of Miss Lannister, or did the trial court find something different?
Your Honors, the trial court found that there was a break in the chain of events that happened. This said that the actions of the original parties were too attenuated to be a consistent chain of events that happened. We are saying that there was no break in the chain, and that at the heart of this case is the comparative fault statute. At the heart.
Let me just interrupt you. Where you're going is good, and please don't let me interrupt you from going there. But my question is that this matter we're talking about, whether there's a continuous chain of events or whether there's a break in the action, is that a question of law for the trial court to decide, or is that something that the jury should decide?
That is something that a jury needs to decide about all the facts, and the lower court stripped my clients of allowing the jury to hear all the facts. And at the heart of the comparative fault statute is fairness. And although it's not explicitly mentioned in the statute, this court has acknowledged the awesome power of Section 1451. In World Fresh Markets, this court said that it has the power to create procedural and substantive law, just like the legislature. However, if the court and the legislature pass procedural laws that conflict with each other, the court wins. But if the court and the legislature pass substantive laws that conflict with each other, the legislature wins.
But in Palermo, didn't the Supreme Court uphold the trial court ruling that did exactly what the trial court here did, and that is prohibited the defendant from bringing in comparative negligence analysis under 1451?
The lower court indeed stopped us from arguing that there were other parties at fault for Lannister's injuries. So when this court was asked to adopt a rule that would allow for apportionment of liability among non-parties, this court had to say no, because Section 1451D only allows for apportionment of liability among named defendants. But at the same time, this court said that there's a way for defendants to turn non-parties into third-party defendants, interplea. And when we have third-party defendants, the defendants can file contribution claims against third-party defendants who were previously non-parties. The problem here, Your Honors, is that the lower court played judge, jury, and executioner when they barred our clients from presenting evidence of the original parties, stripped the jury of the right to hear all the facts, and robbed my clients of their substantive right to file contribution claims under the statute. So in World Fresh Markets,
This court made it clear that a section 1451 cannot be simply set aside because it is a substantive law. Yet that is exactly what the lower court did when it barred my clients from presenting evidence that the other persons contributed to Lannister's injuries. It pretended as if the statute didn't even exist.
Let me interrupt you, Attorney Hamilton, and ask you, I know you strongly advocate on behalf of your client that the lower court not only prevented your client from presenting evidence, but also, I think you even went further to say the judge was the executioner. I know you didn't mean that, but let me direct you toward the law regarding matters where clients, or in this case, the other defendants, settled. Would it be appropriate for the lower court to bring in the settlements of the other parties? If in fact the jury heard that they had settled, wouldn't they conclude that those parties who had settled would be more responsible for the liability than your clients?
Well, that's for the jury to decide, but the lower court didn't allow for the jury to decide when it stopped us from arguing that they contributed to Lannister's injuries. We believe that all events, when combined, establish a connection to the injuries. That this is especially true when we cannot with certainty say who or what was the actual cause of Lannister's injuries and to what extent. Because as the court in Kaler explained, the question of proximate cause is a mixed question of law and fact. When we refer to proximate cause, we mean that there is a connection between defendant's actions and plaintiff's injuries. The biggest factor of proximate cause is foreseeability. If the wrongdoer could have anticipated or foreseen the likelihood of their actions causing the plaintiff's injuries, then we have established proximate cause. No way.
Attorney Hamilton, if the only defendants in the current case are your clients, wouldn't bringing in other individuals who settled and are not defendants, wouldn't that create some confusion for the same jury that you're saying should have to make the decision?
It wouldn't create confusion, Your Honors, because they would be brought in as third-party defendants, which would allow us to go after them for contribution claims. And that's what the lower court did that's what the lower court stopped us from doing when they barred our clients. The most important thing to remember
Didn't the appellate court rule on this issue already, so that the trial court was required to follow what the appellate court ordered?
Yes, Your Honors, that is a superseding cause doctrine that we successfully argued at the last case. However, the lower court is using that precedence to continue to not allow for us to argue that that is only us because we're the last in time. But we understand that we wouldn't even be here had the original parties not put Lannister in an orbit of danger. So we understand that we wouldn't have been here had they not put her in that danger. Your Honor, we're not arguing that our clients are negligent. What we're arguing is that there was more than one of us. And the most important thing to remember in this case, Your Honors, is that someone died. Someone died. Shouldn't the lower court be concerned with hearing all the facts and gathering all evidence to make plaintiffs whole? Yes, Your Honor, it should. And what Guardian Casualty and other cases established is that where a defendant is careless and that carelessness was a proximate cause of the plaintiff's injuries, the defendant should be found liable for negligence, even in a case of multiple defendants like this one, so long as their actions are foreseeable. But in no way will the original actor be barred, no way will the original actor be relieved of responsibility. And we're asking Your Honors to adopt a new rule that when the negligence of original actors combined with the independent and intervening force that is also negligent, that independent and intervening force is foreseeable based on common observations and experiences. Your Honor, from common observations and experiences, we know that planes crash, boats drift, and accidents happen on the highway. So to say that this is too strange or unusual for it to happen is wrong, because from common experiences and observations, we know that this could happen. And
let me interrupt you again, Attorney Hamilton. From common experience, would it also mean that there might be a problem with your plaintiff receiving proper medical treatment in the hospital, if we're going to use common experience? And she might have died from malpractice of the doctor. Is that correct?
Yeah, and I see that my time has expired. Can I answer your question and then conclude?
Yes, ma'am.
So
Your question was about the malpractice?
My question is about your use of the word common experience. That we're using common experience versus us abiding by the rule of law.
Yes, because we understand in common experiences that planes crash, boats drift, and accidents happen on the highway. Common experiences shouldn't, that'll be the hospital's negligence, Your Honor, not ours. That's not a question for me to answer. However,
Go ahead, proceed.
We ask this court to reverse.
Thank you, Attorney Hamilton.
All right, Ms. Lopez. But justices, let me know when you're ready. 1, 2, 3. All right, Ms. Lopez, you can begin when you're ready.
Mr. Chief Justice, and may it please the court, we ask this court to reverse the decision of the lower court and find that the word children, as read in the statute, was not intended for able-bodied, independent individuals seeking recovery in a wrongful death case. We have come to this conclusion for 3 reasons. The first reason is that the statute as it exists today is not a valid law. Our second reason is that even if this court does find that the statute is valid, it must find that the entire statute, when read as a whole, is intended to limit support services for parents and children. Support services for parents and children partly or wholly dependent on decedent. Our third reason is that reading the statute in any other way would send the wrong public policy message to parents and children alike. Your Honor, in 1974, the legislature initially amended the law, allowing only minor children to file for a wrongful death claim. 27 years later, they noticed that this limitation to only minor children was a problem because limiting minor children excluded any other children, including adults, who may be partly or wholly dependent on the decedent. The legislature noticed, just as they noticed that viewpoints for marijuana violations changed, the legislature viewpoints on who could file for a wrongful death claim also changed. They attempted to delete the word child or children, the word minor, sorry, in B1, which meant that this delete was a major change, meaning that they would have gone through the process of corrections of error in section 14B. And we have no evidence of them going through this. The publisher can only make minor changes such as changing head notes, grammar, punctuation, or even capitalization. But to completely delete a word, changing the meaning and the sense of the statute is not allowed. Your Honor, since we do not have any evidence.
Attorney Lopez, isn't that what the legislature does all the time when it amends statutes? It will replace one word with the next word, and not sure I'm following your argument. You're not. The legislature was within its power to amend the statute in 2001, was it not?
Yes, they could have amended the law, but the problem is that the governor vetoed this amend. And not only did they amend or they deleted a word, the publisher wasn't allowed to delete a word without.
Okay, let me stop you. I think you're conflating 3 separate events. Event number 1, legislature changes the law, or submits a bill to the governors for approval that changes the law by eliminating word minor. Event number 2, the governor doesn't go along with it. Governor vetoes it. And then event number 3 is the publisher doesn't get the message, sees the bill, doesn't know about the veto, and puts it in the VI code. And then as a result of that, for the next 20 years, everybody's operating under the wrong law.
Yes, that is correct, Your Honor, and this is why this is a problem. But since we don't have any evidence of them going about the correct process of Section 14B, we have a solution to fix this. We have a 3-part process where first, this court should reverse the decision of the lower court. Our second is that
We should instruct an emergency evidentiary hearing to find the evidence, if there is any, of the publisher going through the process of Section 14B, notifying the governor, every member of the legislature, and the code revisor. And third, we should pause all cases relating to wrongful death, because just as you said, Your Honor, this statute has been being used over the past 20 years. So the fact that the lower court misinterpreted this statute, that goes to say that maybe other cases might have misinterpreted it too. So this is why.
Excuse me, Attorney Lopez, let me make sure I follow all three of your requests. I know you're asking this court to reverse the lower court decision. Is that correct?
That's the first one.
The second one, I understand, is that somehow we should make or have an evidentiary hearing to determine what the mistake and who made the mistake?
Well, the mistake was made by the publisher because
so then why do we need an evidentiary hearing?
We have no evidence that they went to the governor and notified. Well, we have evidence because the governor vetoed, but what we do not know is that after this veto, they still published the law. And since the governor vetoed it, they should not have published the law because it was vetoed by the governor. So this is why we should have an emergency evidentiary hearing, because after the governor vetoed it, we do not know what happened, and this is the problem.
But we do know that the publisher was the one that made the mistake. Is that correct?
That is correct, because they
and let me just finish with this last. And your third matter that you want this court to address is that we should put a stay on all matters dealing with wrongful death until this is resolved?
Yes, that is correct, Your Honor, because children's lives are at stake here. And if we do not take care of this law, this is not fair to those children who this statute is actually intended for. It is not.
Excuse me. And again, you would agree with me that the statute written and even amended still allow minor children to bring action for wrongful death, right?
That is correct, Your Honor. But
so we shouldn't stop cases that are dealing with wrongful death where minors are involved, right?
No, we should not. But those cases where children are not partly or wholly dependent on decedent, like Alvin wasn't, we should relook at those cases, because it is not fair that those children who the statute is actually intended for, and it is not fair that Alvin was allowed to file for a wrongful death claim when he is an adult, independent child. And Your Honor, it is not fair that these children who the statute is intended for must fend for themselves. Their lives are at stake, Your Honor. Our purpose for telling you,
Lopez, you keep saying that the minor children who the statute is intended for, have to fend for themselves. Why are they fending for themselves? Isn't the law currently that minor children are permitted, whether you talk about the governor's veto or the publishers publishing the incorrect act, that never changed the minor's ability to file a claim. That part of the law never changed. You would agree?
That is correct, Your Honor. But
so the argument that you're making that somehow because Miss Lannister's adult son has filed some claim, that somehow he's taking away from minor children, those things don't correlate.
Well, Your Honor, this would bring me to my third point, because this would be sending the message. We are allowing just anyone such as Lannister.
What would it be sending?
Sorry?
What message would it be sending? It's not taking, in other words, do you view the fact that Miss Lannister's son has filed this claim as an adult for wrongful death, do you view this as somehow taking away from some other minor child whose parents might get harmed, that all of a sudden now they're not allowed to file claims?
Yes, we do, Your Honor, because this statute is intended for minor children partly or wholly dependent on decedent, adult children partly or wholly dependent on decedent, or maybe incompetent children partly or wholly dependent on decedent. This is sending the wrong public policy message, because the lower court took it too far, allowing an adult independent child.
Didn't the lower court interpret the statute that was published?
Yes, that is correct. But
so that would mean that if they solely just looked at the statute that was published, that they were correct in allowing Mr. Lannister to go forward with his claim.
No, Your Honor, we do not believe the lower court was correct because if we read the statute in its entirety, B1 talks about this statute being intended for children, partly or wholly dependent on decedent. B2 talks about minor children, and sections G9 talk about incompetent children or adult children who may still be partly or wholly dependent on decedent. The record initially stated a child who was independent and an adult filed for a wrongful death claim and the lower court allowed it. It does not say Alvin, but it does say that.
Disqualifies, in your view, what disqualifies Miss Lannister's son, adult son?
The record stated that he was not a child partly or wholly dependent on his mother. It stated that he was an adult and he was independent, Your Honor.
What did the law as established, what did the law as printed say?
I can read B1 for you. It states survivors mean the decedent's spouse, children, parents, and when partly or wholly dependent on decedent for support or services, or any blood relatives and adoptive brothers and sisters. Alvin still wasn't a child.
Comma of the and. Doesn't it list who can bring?
Yes, Your Honor, you are correct, but it first.
And it just says children. It doesn't say minor or adult. It just says children, which would encompass any child.
It does not mean any child. It does state children, but a child is a child is a child is a child only when partly or wholly.
Let me ask this other question, because I would hate to think that I am not my mother's child because I'm now 50. So are you saying that once you become 18, you are no longer the child of somebody?
What I'm saying, Your Honor. What I'm saying is, in this statute, it makes it clear that the child or the parent or the spouse must be partly or wholly dependent on decedent. And the record was.
Let me ask this question. Then why would before this statute was amended, right, or attempted to be amended, why would they, if it is as you argued, right, that it's really minor children, right? Why would they have had the term minor children, right, and then amend it to remove the word minor if the only logical conclusion is that by removing the word minor, they meant to provide for children, whether you were a minor or an adult? That's the only conclusion to be drawn by the legislature's action.
Yes, Your Honor, but they were intentional when they deleted the word minor in B1, but not in B2, because G and I were always there when it stated that incompetent.
What if he filed his claim under B1? There's no requirement that he follows B3. What if he decided to file it under B1? I'm a child, that's my mother, and I'm filing a wrongful death action.
That is correct, but B1 still states, even before they deleted the word minor, it still stated that the child must be partly or wholly dependent on decedent for support or services. So even if
doesn't that refer, because of how it's written, doesn't that refer to all the people that are then listed after wholly and in part? Blood relatives, adopted brothers, adopted sisters, that those people who are wholly and partly responsible. Isn't that who that speaks to, and not the initial part of adults, children? I mean, children.
It speaks to anyone who is partly or wholly dependent on decedent for support or services. Alvin wasn't. He wasn't dependent in any way of his mother. He was an independent.
So your argument is that any person who seeks to file a wrongful death action must be wholly or partly dependent on the decedent.
Yes, that is correct, Your Honor. That is what.
And that would include Ms. Lannister's spouse.
Yes, it includes spouse, children.
Spouse was the only person working. If a spouse is the only person, the living spouse is the only person working, and the decedent spouse is a housewife or a house husband not working, and that person dies, then that means that the spouse who survives, who was the breadwinner, doesn't have a right to file a claim because they are wholly or partly dependent on the spouse that died?
Your Honor, I see that my time is up. Can I answer your question and conclude?
Yes.
Well, if they were the breadwinner, if they at home, the other spouse still did the work, so they somehow were dependent on the spouse.
At the end of the day, the statute was intended for parents, children, and spouses, partly or wholly dependent on the decedent for support or services. We ask this court to reverse.
Thank you.
Thank you.
Thank you.
Right. So St. Croix Central doesn't have any other squads. They're welcome to stay on and listen in. And I will admit St. Croix Seventh-day Adventist. All right, St. Croix Seventh Day. How are you? Can we get your camera and microphone on so we can make sure we're all communicating and can hear each other?
Hello.
Hello. How's it going? Can you hear me?
Yes, I can hear you.
All right, you're coming through just fine. All right, justices, when you're ready, we'll have them put their notice of appearance on the record. All right, please put your notices of appearance on the record.
Good afternoon. My name is Larry Kai Albert. That is spelled Leariekaibert. I prefer to be called Kai. I am from the law firm of the St. Croix Seventh-day Adventist School. I represent the appellees in this matter, and I will be answering question 1.
Good afternoon, Your Honors. My name is Daniela Christian. That is spelled DANIELLACHRISTIAN. I am from the St. Croix Seventh-day Adventist Law Firm. I will be representing the appellees in this case, addressing issue 2.
All right, and while Mr. Albert comes up again, I want to take the time to recognize, I think Denacia would be how you pronounce it, Denacia Nelson. She was an alternate who, was part of the squad and was there for the practices as well. And we want to, give credit out there that she participated this year. So, Mr. Albert, you may begin when you are ready.
May it please the court. Today, we uphold a fundamental legal principle. Defendants must bear their rightful share of responsibility. The Moot Superior Court did not err in refusing to allow defendants to shift blame onto non-parties, nor did it err in denying contribution claims against those parties. The law is clear. 5 VIC subsection 1451 establishes that defendants bear the burden of proving contributory negligence. Furthermore, 5 VIC subsection 76 ensures that wrongful death actions hold directly responsible parties accountable. The trial court's ruling aligns with the statutory law and established law precedent, preventing the dilution of liability. I will demonstrate why the court's decision should be upheld by addressing 2 critical points. 1, the defendant failed to prove contributory negligence under 5 VIC subsection 1451. And 2, contribution claims against non-parties are improper.
Attorney Albert, the party below was unable to present those claims to the jury because the court wouldn't let them, right? The court said contribution claim could not be considered by the jury. Isn't that right?
Correct.
So they had no opportunity, even though they wanted to.
That is correct. And I will explain why.
Go ahead, please.
Do you want me to explain now or during?
Sure. Yes. Yeah.
Okay. The court did have the right to deny their argument to come into the court because Lannister did settle with the parties outside of courts already before she succumbed to her death. And also, they had the right to deny because of the time period that the case was brought in to be argued. The legal standard is clear. 5 VIC subsection 1451 states that contributory negligence does not bar recovery, but may reduce damages if proven. The burden of proof rests entirely on the defendant to show that the plaintiff was negligent. Critically, the law does not require courts to consider fault attributed to non-parties. Did the defendants meet this burden? No.
Let me ask this, Attorney Albert. You indicated that the contributory negligence, if I understand it, would that be reference to Miss Langston's failure to be trained properly? Is that what you consider contributory negligence?
Correct.
But that was not able to be brought out in the lower court. In other words, the defendants weren't able to bring that to the jury's attention. The judge in the lower court denied even the opportunity. Is that correct?
Correct.
So why should we even be focusing on contributory negligence? Are you saying that we should consider it now in this appellate court?
I'm saying we should consider it now because if you look back at the facts, even though Lannister was not properly trained to drive the vehicle for St. Thomas Super Shuttle, it could have been anybody else because the brakes did fail on the van, indicating that if anyone else was driving that same exact vehicle to transport the passengers from one location to another, that the brakes would have still ended up failing. They attempted to introduce third-party negligence, but failed to provide compelling admissible evidence. The trial court properly excluded these speculative assertions, ensuring they did not influence the outcome. In World Fresh Market versus Palamo, the Virgin Islands Supreme Court ruled that apportionment applies only to named defendants. In this case, Oceanborn and the 1% were those defendants. Allowing the defendant's argument would contradict this binding precedent and place an unfair burden on the plaintiff.
But Attorney Albert, didn't the Palermo case say that if World Fresh Market had filed a cross-claim for contribution against the landlord, then the jury could have looked at the comparative fault of those two parties who would be defendants, that is, the original defendant sued by the plaintiff, and then the third-party defendant sued by the other defendant, World Fresh. And isn't that the same as what happened here? Didn't the 1% and Oceanborn both file contribution claims against all of the other plaintiffs? The other defendants.
They were not really defendants, but also you must remember in World Fresh Market versus Palamo that procedural rules such as timely entry of judgments are governed by the Virgin Islands rules of civil procedure. And the Supreme Court did affirm in the decisions, indicating that despite procedural delays, the final judgment was valid. Comparative negligence under 5 VIC subsection 1451D establishes that damages are apportioned only among defendants found liable in the case. World Fresh confirms that the term defendants applies only to those named and found liable. Contribution claims apply only to legally responsible parties. The wrongful death statute in 5 VIC subsection 76 reinforces this principle. Liability must rest with the direct wrongdoer, not external parties. Act number 6413 clarified that wrongful death actions must be pursued against those legally responsible.
Attorney Wabir, didn't the court say that there were no superseding causes, independent causes, meaning that everything just flowed into one?
Correct.
And
The
if that
court did
and if that-
affirm that, yes.
and if that's the case, wouldn't it be unfair to the defendants, or to the appellants in this case, to not be able to present before the jury where there may be others who contributed to your client's injuries?
No, it would not be unfair. And it wouldn't be unfair because remember that Lannister did settle with these other parties, did compensate her before her time of death came upon her. She did settle and they did compensate her.
Why wouldn't the defendants be permitted to bring forth evidence at the trial to show that there were others who were potentially or contributed to your client's injuries?
They could bring forth that, but when the other when Lannister,
do them from doing that?
May you repeat your question?
Didn't the court prohibit them from doing that?
The court did prohibit them from doing that, but the court did have a reasonable cause as to why they prohibited them.
And that's my question to you. Isn't it unfair that the appellants in this case are unable to present the full story to the jury so that the jury can make a determination as to fault?
Well, even though if they do present this full story to the jury would still not have to require these other parties to come into court because Lannister already settled with them outside of court. Therefore, they do not need to come back into court to be dealt with the same compensating business that Lannister already settled with them outside of court for.
Okay.
Isn't there another concern that all of these other defendants have already settled out of court? Now there's going to be a second trial, and the jury is not even permitted to know about the other parties or the other settlements. Therefore, isn't your client going to get a double recovery potentially? Because the jury is going to be thinking, oh, this poor deceased woman suffered all these injuries just because of these two actors, discounting everything else that happened and discounting the fact that her estate's already been paid by all of these other actors.
Could you repeat your question, please? Sorry.
Aren't we looking at the possibility of your client getting a double recovery because your client has already recovered from all the people that settled? The jury is prohibited from learning about those settlements or those parties, and the jury is now going to determine, are these two remaining defendants negligent? And if so, did they cause damage to this deceased person?
Well, it is that they did cause damage to the deceased, to Lannisters. They were part of the reason why Lannister did eventually meet her death sooner than later. But remembering that they did already settle outside of court for compensation, Lannister has set an agreement with both parties, with all the other contributors that led to her death. They already settled. So it doesn't make sense to bring them back into court with people that has not really settled with her already. They're in court because they have not settled with her and compensated her properly. The other contributors to her death, they already settled outside of court. They already made an agreement and compensated. Therefore, they should not be brought back into court.
So your time is up. If
Yes.
you could go ahead and summarize.
Okay. Your Honors, this is not just a matter of statutory interpretation. This is a matter of justice This is a matter of upholding the integrity of the legal system. In 5 VIC subsection 1451, it's restricting comparative negligence to named defendants and ensuring wrongful death liability remains with those directly responsible. Allowing contribution claims against those parties would undermine legal precedent and place an unjust burden on plaintiffs. For these reasons, the court should affirm the ruling of the Superior Court, because in this courtroom, in this jurisdiction, and under the laws of the Virgin Islands, justice must prevail. Thank you.
Thank you.
Thank you.
All right. Well, the judges are telling their scores. Ms. Christian, can you come up and stand at the camera? Okay. Can we get more light in your room or something so you all don't turn out purple? You did your notices of appearance and you were perfectly visible, and then something changed. You're not quite visible in there.
Because I'm black.
Well, if that was the case, you would have never shown up correctly. So there's something else going on. Something happened. Something changed in the lighting or something like that, where you both aren't appearing like you did when you did your notices. There you go. Yes, that's much better. All right. Moot Justices, are you good to go?
Good.
All right, then you can begin when you're ready.
May it please the court? We all understand that while the legislature makes the laws, it is the judiciary that interprets them. That is the bedrock of our legal system, and today we are called upon to uphold that principle. The Superior Court correctly determined that the long-standing practice of allowing adult children to recover under the wrongful death statute remains in force despite the governor's light item veto of the 2001 legislative expansion. Why? Because the law is rooted in stare decisis, stability and legal interpretation, grounded by statutory authority, legislative history, and judicial precedents.
Okay, excuse me, right there, Attorney Christian. Judicial precedent, those courts, and especially the Supreme Court in the case of Bertrand and the case of Gerald, didn't refer to the amended statute at all, and perhaps wasn't aware that the code was not reporting correctly what the law as seen through the governor's veto. That's judicial precedent. The second you said is legislative intent, but after the governor vetoed the legislation, the legislature had the opportunity to override the veto, and the legislature did not override the veto. Therefore, one can infer that the legislative intent was to allow the governor's veto to stand. I can't remember what the third prong was, but just go ahead and respond to those two if you would.
Even though the governor vetoed the expansion in 2001, the revised version of the Virgin Islands Code was never properly put into the new law. So therefore, the law is still technically speaking incorrect, but since the law has not been revised and it is the law that the people of the Virgin Islands stand by, is the law that they go by.
The incorrect law.
It is technically not correct because it is the law that is in the book, but if you would like to look at it in the way that it is incorrect because of the information that has been recently discovered, then yes, it would be considered incorrect.
And therefore, you are asking us to make a ruling affirming the decision below relying upon an incorrect law.
Correct. Though the law would not be incorrect because the law that the Superior Court is going by is the law that is currently in the text, in the statutory text.
But isn't it only there because the publisher made a mistake?
Yes, even though the publisher did make a mistake, the time for the law to be corrected has passed.
Are you referring to section 14B of Title I?
Yes, sir. Yes, Your Honor.
Continue.
The foundation of this case lies in Section 5, Virgin Islands Code, subsection 76, governing wrongful death actions. Courts have consistently interpreted this statute to allow recovery by adult children. Let's examine the legislative intent. Clearly reflected in Section 5, Virgin Islands Code, subsection 76, which governs wrongful death actions. In 2001, legislature passed Act number 6413, explicitly expanding the class of individuals entitled to recover. The governor vetoed the expansion, striking it with a pen. But did that erase the right? No, because the published version of the Virgin Islands Code is prima facie evidence of the law. It must be corrected until proven otherwise, and it was never corrected. The courts speak, the law speaks, the court listens, and the courts have spoken again and again.
So, Attorney Christian, let me interrupt you. I understand your argument, but the last comment you made about the court, the law speak, the courts listen. The law also, in this case, it's clear that there was an error, made by the publishing company. Should not the court be aware and mindful of that and try to do what is, as you say, listen to what the law said? Because the law would basically uphold the right of the governor to veto, and the veto would have made an adult unable to bring a wrongful death action. Isn't that correct?
Correct. Although that is correct, because the veto was never placed in practice, it was never placed in the law books, and if the courts did not follow what was in the book, it would make it more difficult for the statutory text to be considered reliable, as if there would be one written mistake in the text, it loses credibility, because if there was one mistake in the book, there could be many more, therefore, which would make the text unreliable.
Attorney Christian, what at the moment that the governor vetoed the bill or portions of the bill and returned the bill to the legislature as an act, wasn't that at that moment the effective law of the land?
Can you repeat the question, please?
Yes. The moment that the governor returned the bill to the legislature as an act, even with his line item vetoes of certain portions of it, didn't at that moment that became the law? Irrespective of whatever the publisher printed, wasn't at that time that was the law?
At that moment, it should have been the law, but the version that the legislature passed it did not include the governor's veto. It included the class of individuals. It included it without the veto, which expanded the class of individuals entitled to recover.
Oh, how if the legislature disagrees with a governor's veto, do they have any kind of recourse?
Yes, yes, the legislature has the ability to disagree with the governor's veto, but they
doing what?
They did not
doing what?
They did not follow up with that action, but at the same time they also did not reject the governor's veto, and they also did not update it to include the governor's veto in the statutory text.
Christian, what was the legislature required to do if they disagreed with the governor's veto?
The legislature was required to. Can you repeat the question, please?
Okay. What would the legislature be required to override the governor's veto?
If the legislature disagreed with it, then yes.
Did the legislature do that?
No, they did not.
So that would mean that the law as returned, or the bill, the act as returned by the governor is the law. Correct?
Correct.
Which would mean that Miss Lannister's son would not be able to bring a claim because he's not a minor.
Although
that's true, then how is it that he was able to make it this far?
Because the Supreme Court was going based off of what the statutory text say, and in the statutory text it does not say that only minor children can recover. Like, the word minor was never included in the statutory text.
Now know that that's wrong. That was an error. That was a mistake by the publisher, and that's not the law. Should we not now correct ourselves and put in what the law actually is?
If the law was to be corrected now, it would mean to go back all of those years to then retrial every other person that has been able to benefit under the codified statute to make everything even.
That's here with us now.
Can you repeat?
So you're the only one that's here with us now. So why should we not remand this entire case back to the trial level to implement the appropriate and the actual law?
Because if it was to break the tradition now, it would mean to break it would mean to not stand by precedents, which would basically be saying that the codified statute is irrelevant and therefore makes the statutory text unreliable for the attorneys and citizens.
But isn't the codified text unlawful?
At the present moment, based on the governor's veto in 2001, the lawful text is unlawful, but it is quite difficult to have a book and not be able to abide by the book, knowing that it's incorrect and that I see that my time has expired. May I answer your question and briefly conclude?
Yes, you may.
Even though that the codified statute would be incorrect, it would be very difficult to not be able to rely on the law books. It would be very difficult to keep up if a lawyer or attorney or a judge have had to constantly go back to the legislature to obtain the updated law, even though the law is not properly written in the book. It would make it very difficult for them to keep track of the different laws. In conclusion, this case is more than just about statute. It is about respecting the rule of law, recognizing judicial consistency, and honoring the rights of grieving families. We respectfully ask this court to affirm the decisions of the Moot Superior Court. Thank you.
Thank you.
Christian.
Right. We are now to the point of our 10-minute break, which is almost exactly on time. So we will be back at 2:25. So, we are on. I did not review the schedule very well at all. I This is the second time I put the two squads from the same school in a row. So, St. Croix Seventh Day Appellants. Y'all there? There you go. All right. Can you come and stand at the camera? Let's make sure that you're still showing up. There you go. Okay. All right. And you can hear me just fine and everything?
Yes, we can.
All right. Then, judges, you ready for notices of appearance?
Yes.
All right.
Yes.
Please put your notice of appearance on the record.
Good afternoon, Your Honors. My name is Darnell Nelson. That is spelled DARNELLNELSON of the law firm of the St. Croix SDA School, representing the appellants arguing issue 1 contribution claims.
May it please the court. Good afternoon. My name is Angelica Griffin. That is spelled ANGELICAGRIFFIN. I am with the law firm of the St. Croix Seventh-day Adventist School, representing the appellants, arguing issue number 2.
All right. Well, Mr. Nelson comes back up to the podium. I want to take the time to recognize Amarise McSween, who was an alternate on this squad this year. So she put all the hard work in, just like everyone else on the squad. Congratulations for the accomplishment on that. Mr. Nelson, you can begin when you are ready.
May it please the court. I stand before you today to respectfully argue that the Moot Superior Court erred in its decision to prevent the defendants, the 1% and the Oceanborn, from asserting that other parties contributed to the death of Lannister and from seeking compensation from those parties. In support of this position, I present 3 central arguments. 1, the right to argue contribution and comparative liability. 2, the foreseeability of an unbroken chain of events. And 3, how the court's ruling conflicts with established legal precedents under jury's determination. The standard of review for this issue is de novo, meaning that this court must evaluate the trial court's decision based solely on its legal correctness without deferring to the lower court's judgment. Firstly, I would like to address the principle of joint and several liability. This principle ensures that all parties responsible for causing harm are held accountable in proportion to their respective fault. The trial court's decision to bar the defendants from presenting evidence regarding the role of other parties in contributing to the harm prevented the jury from conducting a fair and full assessment of both causation and liability.
Attorney Nelson, doesn't the contributory negligence statute, that is Title V, Section 1451, allow for the jury to apportion fault among quote unquote defendants? And in this case, the only 2 defendants are the 1% and Oceanborn. So there is no other party that is a defendant in this case for which the jury below could have apportioned liability according to that statute. And I believe that that is consistent, is it not, with the Supreme Court's ruling in Palermo versus World Fresh?
Yes, Your Honor. The law is clear under 5 VIC Section 1451, which mandates that all contributing parties be considered when determining fault. By excluding evidence of other responsible parties, the trial court's ruling stands in direct contradiction to this statutory requirement.
But excuse me, sir, doesn't the statute say all contributing defendants. And didn't the Palermo case say that there were no other defendants in the case? And in this case, down below, after the settlements of all the other original defendants, they were no longer defendants. So there was nobody other than the two remaining defendants, for the jury to apportion liability among.
Well, Your Honor, in World Fresh Markets versus Palermo, the court ruled that apportionment of fault applies only to named defendants. However, in that case, the defendants did not attempt to introduce evidence of third-party fault. In contrast here, the defendants tried to argue third-party fault but the court wrongly prevented them from doing so. Furthermore, established case law consistently supports the notion that the jury, not the judge, must determine questions of proximate cause and negligence. In Aubin versus Kazi Foods and Miller versus VI Wheeler State, the Supreme Court of the Virgin Islands reaffirmed that such determination should be left to the jury. By barring the defendants from presenting evidence about third parties' fault, the trial court improperly inferred with the jury's essential role in determining causation and fault.
Excuse me, Attorney Nelson. Regarding that, isn't it also part of our legal precedent that when matters are settled, the parties who are part of that settlement, that evidence should not be brought into a case because the jury might also incorrectly imply, because they settled the case, that they're liable, and therefore the jury might actually not only infer but assume that the party who settled is liable, and the defendants who are presently in court are probably less likely.
Can you please repeat, Your Honor?
Okay. As you are aware, your argument is that the court trial below basically erred by not allowing your defendants to bring in evidence of liability on the behalf of the other parties. Is that correct?
Yes, Your Honor.
But you're also aware that the other parties settled their cases. Is that correct?
Yes, Your Honor.
And if the lower court, would have allowed the jury to hear that those other defendants settled their cases, wouldn't it likely be that the jury would infer that because they settled the case, that they were probably the one liable for causing the accident?
No, Your Honor. Since it is a jury's role to determine proximate cause and not the judge.
All right, thank you.
Next, I turn to the issue of foreseeability, which is crucial to the argument at hand. The defendants argued that the sequence of events, though intricate, was entirely foreseeable and resulted from the negligence of multiple parties. This concept is well established in negligence law, particularly in Jeffers versus Lassane. The Supreme Court held that foreseeability was key in determining whether Lassane could be held liable for the harm caused by his actions. The core inquiry in this case is whether the harm was a natural and probable consequence of his conduct. Similarly, in this case, the issue at hand is whether the harm was caused a natural and probable consequence of the other party's actions. The facts of this case clearly demonstrates that the initial brake failure triggered a series of events, making a secondary accident highly foreseeable.
And also, didn't the court already make that determination in regards to the conduct being as one course and not independent courses?
Well, Your Honor, it is stated that another accident would likely be foreseeable. Since the bus crashed, another accident would occur.
So didn't the court already determine that it was one sequence of events?
Yes, Your Honor.
All right. And so how does that affect your case?
Well, Your Honor, the trial court prevented the jury from considering the parties' SCSS, GMC, and all about cars their involvement, thereby forcing defendants to bear the full burden of liability and liability caused by others. Finally, I would like to emphasize the importance of the jury's role.
The court bound by that ruling?
Can you please repeat?
It wasn't the court bound, meaning the trial court. Wasn't the trial court bound by the appellate court's ruling that the superseding cause did not apply?
Yes, Your Honor.
Okay. So if that is the case, why shouldn't the case just proceed with just you all?
Well, Your Honor, Lannister Lannister died when we asked during this trial. That is why we're asking for a new trial so that we can include the other defendants as well.
Okay.
Finally, I would like to emphasize the importance of the jury's role in determining proximate cause, which lies at the heart of fairness of this trial. The law in the Virgin Islands has long upheld that proximate cause is a factual issue that should be determined by the jury, not by the court. This principle has been reinforced time and time again. Yet, in this case, the trial court stripped the jury of its essential function by limiting the defendant's ability to argue third-party fault. This was not just a procedural limitation. It was an overreach by the trial court that denied the defendants a fair opportunity to present a complete defense.
Attorney Nelson, isn't it true that at least as an initial matter, the court has to make a decision whether there is a continuous chain of events or whether the two or more than two events are so distant in time and space or otherwise that they cannot be considered as one continuous act. Go all the way back to the Palsgraf case in 1928 when the New York Supreme Court and Justice, or I should say New York Court of Appeals, and Justice Cardoza determined that the train employee assisting a passenger onto the train who dropped a package onto the sidewalk, the package, unknowing to anyone, exploded because it had fireworks, knocked over a scale way down the hallway. The scale fell on Miss Palgraf, and she filed a lawsuit. Doesn't the court initially have to decide, is this a continuous chain of events, or is this an intervening cause that was not foreseeable? And because it was not foreseeable, then the duty did not extend to Mrs. Palsgraf way down the way.
Can you please repeat your question?
I'm not going to do it so long. But,
can you please,
yeah, I'll do it in a shorter version. Doesn't the trial court, have to decide in the first instance if something is potentially foreseeable, and only foreseeable events impose a duty upon an actor? The example I just gave you, somebody far removed from a incident where a bag blew up, the scale fell over on this lady, and she filed a lawsuit, but the court said, no, nobody could have foreseen that would happen, an innocuous package falling onto the ground. Who could have imagined it held fireworks? Who could have imagined it was going to blow up? Who could have imagined the scale was going to fall over? Who could have imagined it would hurt this person? Similarly here, brakes fail, vehicle goes into the water. At the same time, here comes a boat, knocks into the same site. At the same time, a seaplane is flying overhead and pilots are distracted. Professional pilots who are supposed to be paying attention to what they're doing. Who could have assumed that that person would have crashed right into the site? Isn't it proper for the court in the first instance, did the trial court here, make the determination that no, these are way too far removed for me to say this is a continuous chain of events?
Well, Your Honor, the facts of this case clearly demonstrate that the initial brake failure triggered a series of events which would likely make a secondary action highly foreseeable. It doesn't matter if a seaplane would fall in or come into place, an accident will occur.
But that, in the first instance, it is the judge who has to decide whether to allow it to go to the jury, correct? And if it's not foreseeable, the judge can take it away from the jury. Is that correct?
Well, Your Honor, in both World Fresh Market and Zilka, the exclusion of evidence related to third-party fault is depriving the jury of its essential role in determining the proximate cause. And this exclusion was not just a procedural mistake, it was a serious violation to the jury's right to assess all facts and reach a just verdict. So, in conclusion, the Moot Superior Court erred in blocking the defendants from presenting evidence of third-party negligence. The principle of joint and several liability, foreseeability, and the jury's role in determining proximate cause all favor in allowing the defendants to argue that other parties contributed to the harm. Therefore, we respectfully request that this court reverse the trial court's decision and remand the case, ensuring that all responsible parties are appropriately considered in the determination of liabilities. Thank you, Your Honor.
Thank you, Attorney Nelson.
All right. Well, the Moot justices are finishing up with the scoring. Ms. Griffin, let's get you front and center. Okay. Moot justices, give me the all clear when you're 1, 2, 3. All right, Ms. Griffin, you may begin when you are ready.
May it please the courts? The Moot Superior Court erred when it allowed Mr. Alvin Lannister to maintain an individual action for the recovery of damages in this wrongful death lawsuit. The courts allowed tradition to supersede statute. The courts misapplied the plain language of Title V of the Virgin Islands Code, Section 76, and the courts ignored the governor's veto. The appellants request that the Moot Superior Court reverse the lower court's decision and act in favor of the 1% LLC and Oceanborn. Your Honors, the legislature makes the laws. The executive has the power to sign or veto the law. The judiciary is then left to interpret them. But what happens when the judicial system allows tradition to supersede the law? The wrongful death statute.
Attorney Griffin, let me interrupt you. You indicate that the court possibly allowed precedents to dictate the law, but in fact, the code itself that the lower court was following that allowed a adult to proceed with a wrongful death claim, that's what the code actually have in black and white. Is that not true?
Could you repeat the question?
All right. My question is, you indicated that the lower court was following precedent is and not the law. Is that correct? Am I misunderstanding your argument?
Yes, Your Honor.
Okay. By making that argument, you are sort of implying that the judge didn't follow what was in the Virgin Islands Code. Is that correct?
Correct, Your Honor.
But go ahead. I'm sorry. Didn't mean to interrupt you.
In Title V of the Virgin Islands Code, Section 76, subsection B1, it states, the decedent spouse, children, parents, and when partly or wholly dependent on the decedent for support or services, any blood relatives and adoptive brothers. The use of the umbrella term children may seem to include adults. However, subsection B2 provides a clear and critical limitation. Minor children means unmarried children under the age of 18. Your Honors, we are here today because Mr. Alvin Lannister, Miss Natasha Lannister's son, is acting as an individual party in this case. Based on this statute, he is not eligible to be an individual party. Mr. Alvin Lannister is an adult. He is fully independent of Miss Lannister prior to her death. In Ubiles versus the People, the Virgin Islands Supreme Court held that courts must apply statutory definitions before considering the precedents. When engaging in statutory interpretation, courts are meant to interpret statutory language by first applying any statutory definitions that are written in the statute, and then they must apply the common definition. In Act number 6413, the legislature attempted to delete the word minor from subsection B, signaling its intent to expand recovery rights to adult children. However, that amendment appears under the governor's objection section of the act, indicating that the governor exercised a line item veto to strike that specific change. As a result, the effort to expand the definition failed, and the term minor children remains intact in the governing law. Regardless of which version of the statute the court looks to, whether it's the incorrect, erroneously published version or the version that the governor of the U.S. Virgin Islands signed into law, it does not authorize recovery for adult independent children. So no matter how broadly...
Attorney Griffin, do we know that the gentleman who is the adult child in this case was independent?
Yes, Your Honor.
We know that he does not fit within somebody who's partly or wholly dependent. Is that, in other words, the second half of the sentence in B1 of Section 76?
Could you repeat your question, please?
The adult child plaintiff, does that person claim to be partly or wholly dependent upon the decedent for support or services?
No, Your Honor. Mr. Alvin Lannister has not claimed to be partly or wholly dependent on Miss Lannister for finances, for emotional support, for any of that.
So that he would only then be able to prevail or bring this action under the statute if the word minor is stricken from the first part of B1 of Section 76, correct?
He would only be able to recover individually if minor was removed from B2. However, it is not.
Okay. Anyway, I'm saying from B1, but let me just ask you about section 14 of Title 1 and specifically subsection B, where it says, talking about the publisher putting into the code what the law is. And then it says in subsection B of section 14 that if neither the legislature nor the governor or anybody else within 30 days of notice from the publisher that here's what the new code looks like, you have an objection, let me know. And nobody let the publisher know within 30 days. This statute, and that means it's a statute put in place by the legislature of the Virgin Islands, approved by the governor. Statute says then that becomes law. How do you get around subsection B of section 14 of Title 1?
Your Honor, subsection B of 1 VIC 14 does in fact outline the corrective process to fix a mistake. The mistake that occurred was that the version of 5 VIC section 76 that was printed included the rights for adults to recover. Notably, there is no mention in this fact pattern that the corrective process outlined in section 14 was followed. This omission further confirms that the courts must rely on the legislature's enacted version of the law rather than a misprinted statute. A printing error, Your Honors, does not supersede legislative enactment. The governor signed the law that strikes the ability for an adult independent to recover. Mr. Alvin Lannister is not able to recover under 5 VIC section 76. This principle was also affirmed by the Texas Supreme Court in Fleming Foods of Texas Incorporated versus Rylander, which held that when legislative enactments are in conflict with prior judicial decisions, the statute must govern.
Attorney Griffin, did the defendants challenge the validity of what was in the code at the trial?
Could you repeat that question?
Sure. Did the defendants challenge the validity of the statute that was published in the code at the trial level?
No, Your Honor. They did not challenge it because they were not aware of the...
Why wouldn't that be considered a waiver of the provisions that the actual law should be applicable? Why wouldn't that be a waiver in your case?
Well, Your Honor, it wouldn't be a waiver because in both versions of the law, the version of the law that includes adult recovery and the version of the law that has removed it, both have the same definitions of who can recover, that being minor children who are dependent on their parents.
Isn't what is published in the code says children?
What is published in the code says children in B1, right. In subsection B1. How
Mr. Lannister is? Isn't he a child of Miss Lannister?
He is a child of Miss Lannister. However, subsection B2 narrows that definition down to minor children. No. Any mention of
B2 provides a definition for minor children. It just says minor children means, or I take that back. Let me make sure. Yeah, minor children means. That's all that says in B2. But and that was to coincide with what the original law was, which was only minor children could recover, which is what, if we follow the governor's veto, then that would be the law, right? Correct?
What would be the law is what the governor vetoed. The governor vetoed the removal of the word minor from subsection.
I understand that. But what I understand is that The publisher published the incorrect statute. They published what the legislature passed, which removed the word minor. So it just said children. That means it could be a minor child or an adult child, right?
Your Honor, the error of the publishers does not make that version the correct certified version. The correct certified version excludes adults from recovery.
Why does it not?
It does not exclude it excludes adult from recovery because in Title V Virgin Islands Code, Section 76B2, minor children means that everywhere in that statute now means minor children and minor children alone. And even if
Attorney Griffith, does it really remove adult children from being able to claim it?
Yes, Your Honor, it does.
Doesn't the statute specifically say that survivors mean the decedent's spouse? Let's presume that we follow what you say, that what the governor vetoed is the law, which means we're going back to the 1974 statute, right? Which provides that survivors mean the decedent's spouse, minor children, parents. We agree with that?
Yes, Your Honor.
And then it says, comma, when partly or wholly dependent on the decedent for support or services, comma, any blood relatives and adopted brothers and sisters. Wouldn't Mr. Lannister be considered a blood relative?
Mr. Alvin Lannister is a blood relative. However,
go ahead. I'm sorry. Go ahead.
However, the way it is written implies and defines that only blood relatives who are partly or wholly dependent on the decedent can recover. There is no mention in our fact pattern today that Mr. Alvin Lannister was dependent on Miss Lannister. I recognize that my time has concluded. May I briefly conclude?
Please do.
It is not our intent to entirely bar Mr. Alvin Lannister from recovering. It is instead to ensure that he recovers correctly as a beneficiary under Trevor Lannister, who is Miss Lannister's husband. The statute is clear. The courts must be clear. The appellants are requesting that the courts reverse the lower court's ruling and remand this case for a new proper trial. Thank you.
Thank you.
Thank you, Attorney Rick.
All right, good job. So, is the Moot justices finished their scoring and taking notes? I'm admitting Charlotte Amalie High School. We are on our last round of today's competition, and it is Charlotte Amalie High School appellants who are going to be arguing last here. And I want to say a welcome to Attorney General Ray. He is in the chat and listening to the last few arguments before he makes his keynote speech. So, Charlotte Amalie, can you hear me just fine?
Yes, yes, we can.
All right, and we can hear you just fine. So, Moot justices, when you are ready, let me know. All three. All right, please put your notices of appearance on the record.
Good day, Your Honors, and all in attendance. I am Sumaya Mark. That is SUMYAHMARK, partner at the Amalia Law Firm, here on behalf of the appellants, and I will be addressing the first question on appeal, the denial of the lower court to allow for claims for contribution.
Good day, Your Honors, and all in attendance. I am Shrisha Elize. That is SHERISHAELIZEE, here on behalf of the appellants, and I will be addressing the second question on appeal. The ability for non-dependent adult children to recover for wrongful death under Title V VIC Section 76.
Proceed when you're ready.
May it please the court. Your Honors, The lower court erred when it restricted the duty of the jury to hear all facts, including all parties, whether settled or not, who contributed to the harm suffered by Natasha Lannister either through fault, causation, or both. Your Honors, this case was never a two-party tort. It was a complex, devastating multi-actor tragedy, one in which brakes failed on a poorly maintained van, a van that flipped violently and left a woman dying on the road, followed by a plane crashing onto that exact location. Two intersecting spheres of harm. But the jury was told to ignore everyone and everything except the two defendants left standing, in violation of this court's previous directive. The Moot Superior Court's ruling should be overturned for the following reasons. 1. The trial court's approach functionally determined a superseding cause for a second time, something that this court has explicitly told them not to do. And in hearing all evidence from all materially contributing actors, the jury can then and only then make an appropriate determination under Section 1451. To my first point, Your Honors, while the trial court never used the term superseding cause, this time its actions created a result just as, if not more, problematic. It placed total blame on the last two defendants standing, and it did so by removing, nay denying, vital context from the jury. The jury was never allowed to hear about St. Thomas Super Shuttles, the dealership that sold a potentially unsafe vehicle, or the manufacturers whose brakes may have failed, or Miss Lannister's lack of training. In a case where multiple actors clearly contributed to 17 tragic outcomes, the jury was barred from hearing about any other actors and asked to assign 100% responsibility to just two. That is not
Attorney
what...
Mark,
yes?
You correctly reference Section 1451 of Title V, but Section 1451 of Title V talks about contribution among, quote, defendants, unquote. And by the time this trial took place, there were only two defendants. That was the seaplane and the 1%. And consistent with the Palermo case, where the landlord, joint tortfeasor, perhaps, but not a defendant in the case, was specifically excluded by the Supreme Court because the landlord was not a defendant. Sounds to me like the trial court applied the law consistent with the language of 1451 and the Palermo case.
Well, Your Honors, while Fresh Markets v. Palermo addressed apportionment, yes, but that was only after fault was appropriately determined. This does not allow for the exclusion of relevant facts from a new trial. Instead, the court went further. It barred all evidence of how the harm occurred if the actor had already settled or wasn't named. Additionally, in Wolfresh, the Landers PDCM played no part in the harm. To continue, on my second point, the jury was never allowed to hear about St. Thomas Super Shuttles, as I said. That is not what joint and several liability was designed to do. The law ensures a plaintiff can recover, but it does not require us to pretend other significant factors did not exist. The jury was functionally told to watch the post-credit scene and write a review on the entire film. You cannot do that. I note that last year, this court ruled that the superseding cause doctrine was incompatible with the Virgin Islands comparative negligence statute and requested a new jury trial. Not a sequel, not a new season, but in a reboot with a full new jury cast. In Miller v. I Real Estate and Albany v. Cassie Foods, this court emphasized that causation is a question for the jury, especially in complex multi-actor situations. But here, the jury never got the chance to make that decision. The court's exclusion of context functionally created strict liability for two companies based on not on their share of fault, but on who remained in the courtroom.
Attorney Mark, let me interrupt you. Even though the trial judge below restricted the jury from hearing about the other parties which had settled out, they still the jury could hear the evidence regarding your client's, the present defendant's responsibilities or lack of responsibility or actions. So it's not that the jury still couldn't make a decision that your client's or the defendant was not liable. Isn't that correct?
Your Honor, that is simply not fair. Because
Well, you say it's not fair. I understand that. But let me ask you this. If the other party settled their case with the plaintiff and the defendants in this present case was allowed to say to the jury, these parties over here that are not a part of this case is already paid for liability. We should not be responsible. Don't you think that's also unfair?
Your Honor, I do not believe, Your Honor, no. To cite to R.J. Reynolds v. Jared, no rational jury, acting on the basis of the full evidentiary record and without being inflamed by passion, prejudice, or other improper consideration, could determine that only 1% LLC and Ocean Born are responsible. They did not manufacture brakes. They did not sell the van. They did not service the van. They did not crash the van. They did not build a guardrail. They did not train Miss Lannister. They are not in no way 100% responsible without an improper superseding cause instruction influencing their determination. That is why the Supreme Court ordered specifically a new jury trial. That brings me to my second point, Your Honors. Nothing in 5 VIC section 1451 prevents a jury from hearing the full story on how an injury occurred. That statute governs apportionment of liability on the verdict form, not the admissibility of evidence related to fault or causation. But the trial courts conflated the two and barred even basic evidence about other contributing actors. That undermined the jury's entire ability to understand how the tragedy unfolded.
Attorney Mark, the appellate court ruled on the issue of the superseding causes. And so once the appellate court rules, isn't the trial court required to follow what the appellate court has told them to do? And in this situation, it would mean that their ruling to not allow all of the other defendants' issues to come forward would be the correct ruling in following the appellate court.
In following, let me reiterate. We should first consider the first request of the Supreme Court, which is to start a new jury trial. That means every actor, regardless of whether they're still in the case, must be included back into the case.
Not when the appellate court has specifically said this specific issue is concluded, meaning it's determined, no superseding causes involved. So go have a new trial, but go have a new trial without the arguments of superseding causes.
Yes, that is exactly what I'm saying. So to remove the superseding cause and create an entirely new argument, you must include all including contributing factors that go beyond the defendants who still remain in court. That includes the manufacturer.
Defendants who remain in court are you.
Yes, correct.
Okay.
I'm not saying they have to be added back. All I'm saying is the jury must have all the facts and the evidence related to every single contributing clause.
Not added back. If they're not added back, wouldn't it be that people are just throwing in these things out there with nobody to challenge them? Specifically, the parties who are not defendants?
The parties who are... But Your Honors, none of that determines whether facts should still be included within the jury's determination.
Isn't it that for purposes of your argument, that you want them in there because you're trying to establish to the jury why you are not 100% at fault? So it does matter.
What I'm trying to allow for the jury to say is, I want for my clients to have a fair trial. And barring the jury from all relevant evidence and placing the blame only on them, only to the jury's view, that's not fair. So for this new jury trial, to follow justice in a clean way, this jury and this trial, this court must include all these factors.
Even though some of those factors will be addressing matters that are by now, because of the appellate court's ruling, are irrelevant.
But Your Honors, that is not for us to discuss. That is for the jury to discuss. That is exactly what the Supreme Court ordered.
Isn't the jury only supposed to receive relevant, admissible evidence?
The jury is supposed to receive, of course, Your Honors.
So
I'm saying that every actor who played a case in these 17 tragedies.
If the Supreme Court, the appellate court, has made a ruling that in effect turns these other defendants and what role they played, their factors irrelevant, then they should not be put before the jury.
Your Honors, this is a new trial. Regardless of their determination, a new trial still has to be conducted. And like I've said, the trial court ignored the clear commands to abide by this court's rule to conduct a new trial. Your Honors, I see that my time has elapsed. May I please briefly conclude?
Please do.
Inclusion of all relevant contributing factors and actors was incorrectly refused. This court should vacate the Moot Superior Court's ruling on this issue and request a new trial once again. Your Honors, thank you for your time.
Thank you.
Thank you, Attorney Mark.
All right, Ms. Elizé, Moot Justices, let me know when you're ready to go. 1, 3. All right, Ms. Elizé, you can begin when you are ready.
May please the court. Your Honors, this question specifically addresses the interpretations by the courts of 5 Virgin Islands Code, Section 76. The Moot Superior Court erred in holding that recovery by non-dependent adult children has been the precedent of the courts. And point 2, the version of Title 5 VIC, Section 76, that allows any action for personal injury to survive is not an approved, signed, binding, or active law and would cause additional issues for the courts. The Moot Superior Court's ruling that non-dependent adult children had standing to sue under the Virgin Islands Wrongful Death Statute is incorrect and stands against prior decisions of this court.
But Attorney Elizé, what about the Bertrand against Mystic case and the Gerald against R.J. Reynolds case? Didn't the Virgin Islands Supreme Court, without batting an eye, allow those adult survivor claims to proceed to verdict?
Yes, Your Honors, they allow for adult children who are partly or wholly dependent on the decedent to file suit.
Did those cases even address the question of whether or not those adult children were dependent? I understand and I acknowledge this, that Section 76 of Title 5 B1 talks in 2 different places of who's a survivor who may bring an action: the decedent's spouse and minor children and parents in the 1974 version, and then any blood relative who is partly or wholly dependent. But in the 2 cases I just mentioned, Bertrand and R.J. Reynolds, I don't believe there was any analysis, correct me if I'm wrong, about whether or not those adult children were dependent upon the decedent.
Your Honor, in R.J. Reynolds v. Gerard, it was questioned whether or not the adult children were dependent. In R.J. Reynolds, 3 adult children were denied suit because they did not have a close enough relationship with their mother.
Now, was it that case where the adult son was in California and never came home to see his mother in St. Thomas, and yet was nonetheless allowed to pursue his survivor claim and went to verdict?
Yes, Your Honor, that is one of the people involved in R.J. Reynolds. However, that son was allowed to file suit because he proved that he had a connection with his mother. He called his mother every day from California, which is how he proved that he had a close relation with his mother and was allowed to file suit. To continue, nowhere in Title 5 VIC, Section 76 uses non-dependent, where the misinterpretation may lie is in subsection B1, which reads, survivors means the decedent's spouse, minor children, parents, and when partly or wholly dependent on the decedent for support and services, any blood relatives, and adoptive brother and sisters. The opposition will conveniently overlook the word non-dependent. They would act as though non-dependent solely means an adult child who does not live with his or her parent. However, if this court affirms the use of non-dependent, we risk expanding the class of who can sue under the Virgin Islands wrongful death statute, meaning that any estranged blood relative, no matter how fraught, strained, contentious.
When you say that to give it the opposite reading would mean that we're opening the scope of those who may file. What do you mean by that?
So by affirming the use of non-dependent, it would mean that any person related to the decedent can file suit. It could be grandparents, even an emancipated child who never knew their parents. It can basically mean that anybody who is related to the decedent by blood can file suit, no matter their relationship, good or bad.
But who would be reading it as expanding the definition of blood relatives to include those who were independent?
Whoever is wanting to file suit, whoever sees the word non-dependent as a way to get money.
But I thought that Lannister was filing suit because he was a child, and that's what the statute had. The statute just says children, and he's a child of Miss Lannister, and so he's entitled. Is there some other avenue that he is using to file his claim?
So, Your Honor, according to Act 6413, yes, Lannister is fighting as a child. However, according to the law, which was signed by Governor Charles Wesley Turnbull in 2001, minor children is included. There is no clause that says only on child. The law only reads minor child.
Is Mr. Lannister a minor child?
No. However, Mr. Lannister is a blood relative of the decedent. Therefore, he can file suit.
Okay, but can he file suit simply because he's a blood relative? Or is there some other requirement for the blood relative?
Yes, the other requirement for the blood relative, and I read, when partly or wholly dependent on the decedent for support or services. That is the requirement.
So, do we know whether the jury had evidence before it to show that he was wholly or partly dependent on his mother so that he would be entitled to proceed?
No, Your Honor, there is nothing mentioned in the facts to show that he was dependent. That would be up for a jury to decide.
Right. And so, if I understand it, where there has been a jury award, right? Correct?
Yes.
So, would that mean that the jury determined that he was in fact wholly or partly dependent on his mother in awarding him damages?
No, because the court has not been following the law. The court has been following Act 6413, which uses child, not minor child. Therefore, in the ruling.
But would it matter? If I understood your argument, what you're saying is that whether we follow the part with minor or non-minor doesn't really matter because there's a section that speaks to blood relatives, and you agree that he's a blood relative, right?
Yes.
Right. But what you're saying is that by just being a blood relative doesn't mean you get to claim or recover. You have to, in addition to being a blood relative, you have to show that you were wholly or partially dependent on the decedent, correct?
Yes, correct.
Right. So if I follow you, that the jury has to determine whether he's wholly or partially dependent on the decedent, then that means he is allowed to file the claim, but he still has something he has to prove. And if the jury has awarded him, then is it okay for us to determine that, okay, I guess the jury believed he was wholly or partially dependent on his mother?
Yes, Your Honors, that is 100% correct.
Then why would we not leave? Why would we not now in this case? Why would we not leave the decision that came out from the jury in the lower court under these circumstances?
There are two reasons, Your Honor. One, because the lower courts use the word non-dependent. Non-dependent was never mentioned in the law of Title 5 VIC Section 76, nor Act number 6413. It was never mentioned. So therefore, I'm asking the court to vacate that decision. Now, if a new jury wants to determine if Lannister is partly or wholly dependent, I am 100% fine with that. My client is 100% fine with that. However, we cannot continue to use the verdict that said non-dependent. And moving on to my second point, Your Honors.
Wait, tell me that again. That fine line distinction you're making. You said that the trial court used the word non-dependent.
Correct.
As to Lannister.
Yes.
That the jury had to do what?
Now, the jury had to. So going forward from now, the jury has to determine if he's partly or wholly dependent according to the law.
Yeah, but what happened at the trial? That's what I need to make sure I understand. So that's why we're here. You want us to vacate the award. Yes. And I think you made the argument that the jury was instructed about a non-dependent. Tell me, I need to make sure I understood that part of the argument.
So the jury, as instructed by the lower court, used Act 6413 to determine if he was a child. They never determined if he was partly or wholly dependent because they did not know that the law says minor child. Act 6413 only says child, so they never determined if he was partly or wholly dependent.
Gotcha. Okay.
Okay. So now moving on to my second point. On June 5th, 2001, Governor Charles Wellesley Turnbull line item vetoed the deletion of the word minor in subsections B1, E3, and E4, and exercised his veto power and reverted the legislature's intended changes so subsection D reads, no action for personal injury shall survive, and any such action pending at the time of death shall abate, whether or not filed at the time of death.
If I can interrupt you just briefly, you're correct with what you just said about Governor Turnbull, but in fact, the code itself, once it was published, does not actually show that the governor vetoed that particular section regarding minor. Is that correct?
Correct, Your Honor. And that is a violation.
Go ahead. I'm sorry. Go ahead.
Sorry. That is a violation of 1 VIC Section 14, which reads in relevant part that the publisher may not alter the sense, meaning, or effect of any act.
But also in our code, I think it's correct that the legislature have 30 days after it's been published to bring to the attention of the publisher any error or any need to correct. Is that right?
Yes, Your Honor. But however, what I just read comes before that part. You cannot give 30 days if what was written was altered.
All right. Thank you. Thank you.
With death being the ultimate injury, the law, Title 5 VIC, Section 76, shifts personal injury resulting in death to a wrongful death case, taking everything that led up to the death into consideration, still offering the potential for due compensation when the person was injured and can no longer speak for themselves. In closing, it is not our Your Honors, I see that my time has elapsed. May I please be given time to briefly conclude?
Please do.
The issue is not if Lannister can recover. The lower court must make that determination according to the law. Title 5 VIC, Section 76, signed into law by Governor Turnbull on June 5, 2001. Your Honors, thank you for your time.
Thank you.
Thank you, Attorney Elise.
All right. Good afternoon, everyone. That was our last argument for the day. So I would like to welcome Attorney General Gordon Ray, if he wants to turn on his video. And he was going to be our keynote here this afternoon. He is on, so hopefully he, there he is. All right. So, Attorney General Ray received his Bachelor of Arts from Indiana University, graduating summa cum laude with honors, majoring in history, and graduating in 1967. He received his Master's of Arts in History from Harvard University in 1968, and he received his Juris Doctorate from Stanford University Law School in 1974. From 1968 to 1970, he worked as a teacher and community developer in the Peace Corps in Ethiopia. In the mid-1970s, Attorney General Ray served as Special Assistant to the Chief Counsel of the Senate Select Committee on Intelligence Activities. Then in the early 1980s, he moved to the Virgin Islands, where he served as the United States Attorney. He was in private practice until he was appointed the 20th Attorney General of the Virgin Islands in August of 2024. Attorney General Ray, you're very welcome. We're glad to have you. You got to see the last few rounds of arguments and see really the impressive caliber of the students, and you've gotten to read the fact pattern. So we look forward to hearing what you have to say.
Well, I have a few things to say. First, can you hear me okay? Is the sound all right?
Yes, you're coming through just great.
Okay, very good. Well, first I have to say, I've watched the arguments for the last, about an hour. I'm very impressed. This is a sharp set of students. And actually, I have to say, I'm a little bit embarrassed because some of them argue much better than lawyers do. So I hope we see them in the courtrooms in the years to come. It gives me some hope for the future. So thank you very much for encouraging all of this with your Moot Court program. I think it's really, really great. I don't want to bog us down in a lot of legal details. I know everybody's brains are pretty much burned out by this point. But what I would like to do is just talk for a couple of minutes a little bit about my journey in the law. And I'd like to do that because I suspect many of the students here are considering pursuing careers in the law. And as you know, it's a long path. You have to get out of high school. You've got to go to college for 4 years and get a degree. You've got to go to law school for 3 more years. Then you may have to work as a clerk or a judge or heaven knows what, and then push forward. And some of you may be wondering, is it worth it? Does it take any kind of special background? Are there any ways to get a leg up? Well, obviously, doing what you're doing now is giving you a leg up and giving you a taste of it. But what is there out there? So every lawyer probably has a different story as to how they got to where they got and what they're doing. Lots of twists and turns, a lot of different obstacles. But I just wanted to speak for 2 or 3 minutes to you first, a little bit about my background and what got me into lawyering. And some of you may find some inspiration in it. And it may also give you a little bit more of an understanding, not only of some of the things that can happen, but some of the very good things that can happen, some of the opportunities that it gives you. I grew up in Appalachia, East Tennessee, basically a poor part of the country. My father only had 1 year of college, and my mother didn't even get out of high school. So obviously, background of parents, et cetera, is not going to make a huge difference in whether you end up becoming a lawyer, because I ultimately did become a lawyer. But I never even thought about becoming a lawyer until I was in my mid-20s. And I followed a lot of other careers. first thing I wanted to do when I was in high school was to be a musician. I played with rock and roll bands and jazz bands. I was a drummer and did a very good job of it, and actually got a music scholarship to Indiana University. That lasted my career in music, at least my professional career at Indiana University, lasted about 6 months when I realized there were a lot of musicians who were a lot better than I was. So I went into a different field. I went into history and loved history as well. Graduated there and went to graduate school at Harvard, again in history. Did well there. I got my master's degree, but decided, I don't think I want to do this. Academia is kind of boring. Also, the civil rights movement was hitting full steam then. I was involved in a lot of the big civil rights protests, and also the Vietnam War was at its height, and I was one of those people you read about who was an opponent of the Vietnam War and quite vocal about it. So what I decided to do was to see if I could find ways to do some more good in the world. And I joined the U.S. Peace Corps. The Peace Corps training that I went through was done on St. Croix. And so I was here in 1968 on St. Croix as a Peace Corps volunteer being trained, and then was sent to Ethiopia. And I spent 2 years in Ethiopia as a Peace Corps volunteer. It was a life-changing experience, totally life-changing to be working in such a very different culture and in an extremely poor culture. If you were 25 years old, you were an old man in Ethiopia of those days, just because of the poverty and the tough experiences. Came back to the States in 1970, settled in California. Again, the civil rights and anti-war movements at that point were going full steam. And I decided, the best way to express myself, to make a difference, is to become a lawyer. And so at the tender age of 26, I enrolled in law school there at Stanford University. The law school is a 3-year process, and it was a very full 3 years. I had to work for a living because I came from a family that didn't have any money, and I didn't have much. Peace Corps didn't pay me very much money. So I worked with a law firm for about 20 hours a week while I was in law school. I managed to get through all of that, did a lot of environmental law. I helped write Stanford's environmental law handbook. But then was faced with another set of decisions that many of you may face if you go into law, and that is, what kind of law should I go into? What expresses me? The big law firms would come to Stanford and try to recruit students. That just wasn't the world I wanted to be in. I didn't want to spend my time representing corporations. I wanted to help people. And so I ended up joining a criminal defense firm in Los Angeles, worked there for a year or so, and then had a fantastic time. The person who changed me most, I think, in law school and who woke me up to the things that lawyers can do was my criminal law professor, Tony Amsterdam. Tony Amsterdam represented virtually everyone on death row, people who were awaiting execution. And his advice still rings in my ears. One day we had a talk, and he said, "Gordon, if you don't like the way prisons get run, don't stand on the outside and carp. Become a prison warden." I thought, okay. That's an interesting thought. I can use law to get inside of entities that I feel need some change and some help. Well, after law school and working for a year or so as a criminal lawyer in LA, I got an astounding opportunity, and that was to work with a Senate investigating committee, a committee in Washington, D.C. that was investigating the FBI's attempts to undermine the civil rights movement and the CIA's attempts to assassinate foreign leaders. And so I ended up in Washington. It was a intense job, but one where I felt I could really make a difference. We made reports. We got a committee set up that became the permanent intelligence committee of the U.S. Senate. It was basically an opportunity of a lifetime. I was involved in writing the reports, again, on the FBI attempts to undermine civil rights movement and discredit Martin Luther King, as well as the CIA attempts to assassinate foreign leaders. When that committee ended in 1976, I didn't know what I was going to do. The head of the committee offered me a job back with his big law firm in New York City, and I said, that's just not me. Turns out he also had gone to law school with the United States Attorney in Washington, Earl Silbert. And he said, what if I give Earl a call and see if you could become a federal prosecutor? I said, now that sounds interesting. That all worked out. I became a federal prosecutor in Washington, did that for about 5 to 6 years, ended up as the executive assistant U.S. attorney, which is sort of the second in command of that entire office of about 160 federal prosecutors and attorneys. But then there was an administration change. The new president appointed a new U.S. attorney who then asked me, of course, to step down because that's the way it works. I did that, but U.S. Virgin Islands needed a assistant U.S. attorney, a special one down here. So I came down to the U.S. Virgin Islands and worked based mainly out of St. Croix as a federal prosecutor down here. In 1983, I joined up with a local attorney, Thomas Alcon, and we began doing injury cases. We represented injured people. The oil refinery was going full steam, got involved in environmental litigation, and of course also did criminal defense work. And that was an extraordinarily rewarding time. I've been in private practice from 1983 through now, or basically through last year, which is 2024. So that was some 41 years in private practice after all that government time. Most of that time I spent, again, doing environmental litigation, criminal defense, and that sort of thing. In April of this past year, the governor asked me if I would be interested in serving as Attorney General, heading up the Virgin Islands Department of Justice. And being a crazy man, I said, sure, that sounds interesting. I said yes. I started working in May of 2024 and was ultimately confirmed in October of 2024. And I intend to keep doing this work until the end of the governor's term, which will be in January of 2027. Why did I decide to become an attorney general? Well, I saw it as a real opportunity to make a difference, a chance to give back to the community, and also to do what I just like doing, which is doing positive things. So let me just take a second to tell you about the Justice Department, because some of you may be interested in that kind of a career. What does the Justice Department do? Well, it has multiple divisions, and each of the divisions has a set of lawyers and also support staff. There's a criminal division that prosecutes all the criminal cases in the Superior Court or local court of the Virgin Islands. There's a white-collar crime division, which at this point is small, but I'm trying to build up, which focuses on economic crimes. We have a civil division that represents the government both in its own lawsuits and in suits that have been brought against the government. We have a Solicitor General's division that handles all of the appeals for the government, as well as reviews all departments' contracts for legal sufficiency. Quite busy division. There's a special investigation division, which basically helps attorneys on their cases, helps with victims assistance, that sort of thing. There's a division that looks at parents and parental and child support. We have a medical examiners division. We have a Medicare fraud unit, a sexual offender registry division, the gaming and casino division. The list goes on. It's a multifaceted job, but it keeps you plugged into a lot of different fascinating areas. What do I want to do with the Justice Department? Well, I saw it as a chance to try to bring the Virgin Islands Justice Department up to fully modern standards. I'd like to add more employees, and I've been bringing in some new employees, and I'm pushing very hard on that to bring it up to strength. I brought down trial trainers from the National Association of Attorney Generals that have been working with that worked for a week with our attorneys and our support staff to satisfy us all that they were up to national standards. We're working on putting in a new case management system that's going to interface not only with the police department, but with the courts and with the defense bar so that we can get discovery out quickly, move cases faster, and get better and fairer resolutions. I'm also interested in fairer resolutions because I'm not a prosecutor that thinks everybody ought to go to jail. There's a lot of people that shouldn't go to jail, but who do need help. And so I'm a big believer in diversion programs, programs where people are not put in jail, but rather have to complete anger management, drug treatment, or whatever. And if they do all of that, then the case is dismissed because I think a lot of people need help. And I think this is a justice department, and helping people is a big part of justice. I'm also trying to reach out more to the public and keep the public informed about what we're doing and what we're trying to do. And I'm also reaching out to the Virgin Islands Police Department, the U.S. Attorney's Office, public defenders, the courts, all the different other elements that have to work in tandem in order for justice to get done. So I can say in conclusion of all of this that looking back on my life, I'm very satisfied that I chose lawyering as my profession. It's given me endless opportunities to do positive and very interesting things. Everything from bringing justice to marginalized people, to helping injured people, to helping clean up the environment, trying to incentivize manufacturers to produce safer products, and improving the operations of a critical governmental agency, the Department of Justice. So I urge all of you who feel inspired by what you've been doing with the Moot Court program and by what you read about the law in general to please stay with it. Sometimes it gets tough. Sometimes you get criticized and hollered at unfairly. That's part of the game. Sometimes you got to work day and night. That's part of the game. But I can promise you, having done this now, I've been a lawyer for a little over 50 years in total. It was worth it. It was a very positive and solid way to spend a life. And I encourage all of you who have the energy to do it and have the desire to do it to please push ahead. I was asked also just to say a word or two about one of the legal issues that I know you all have been thinking hard about, and that is, what about proximate cause? Okay, I don't want to sound like a judge or a lawyer too much, but let me just say a little bit about causation in civil cases. I know that plays a lot in a lot of the arguments that you've been doing and looking at. Proximate cause is a major element of a civil liability case. For a person or an entity to be liable for damages incurred by another person or another entity, the actor has to in some way have caused the injury or the damages. If there's no causal link, there can be no liability. So if let's say that you're crossing a street in a crosswalk and I'm driving my car and I'm going too fast and I hit you and break your arm, obviously there's a direct causal link. I did it. And that's essential. On the other hand, if I'm driving my car and somebody 2 miles away is crossing a crosswalk and a different car hits them, I'm not liable for that because there's no causal link. But the plot thickens in some jurisdictions, actually in most of them. For me to be held liable for injuring you, I have to have done it either intentionally or negligently. In other words, on purpose or carelessly. And if I didn't injure you on purpose or out of carelessness, then I'm generally not liable to you, even if I injured you. Again, that's the way it comes out in most jurisdictions. So, in effect, the law says in this instance that even though you were injured through no fault of your own, and the person who injured you can be identified, me, if that person didn't mean to injure you and wasn't careless or negligent, then you can't collect damages for your injury from me. Okay? That may sound unfair, but that's the way it appears to run in most jurisdictions. But the plot thickens even more because there's an additional element. That element is whether the actor, even if negligent, could have reasonably foreseen the injuries that his accident caused. And I know that's been a big part of the case that you've been looking at. What does that mean? Well, let's say I'm driving 60 miles an hour through a marked school zone and I hit a student crossing the road in a crosswalk. My action clearly causes injury. I was clearly negligent for driving too fast through a school zone. And hitting a student crossing the road was a reasonably foreseeable and predictable outcome of my negligent behavior. So even under this more stringent test, I'm liable. But what about more remote causal links? Let's say I'm driving way too fast through a marked school zone and a rooster dashes into the road. I'm going too fast to avoid the rooster and I hit it. It knocks the rooster into the air and the rooster hits a student who's standing beside the road in the head, and it injures him. Was my hitting the rooster and knocking the bird into the student's head the cause of the student's injury? Yes, because but for my negligent driving, I could have missed the rooster and the student wouldn't have been injured. Was my driving too fast in the school zone negligent? Oh, yeah. But was it reasonably foreseeable that by driving too fast in the school zone, I might hit a rooster that would slam into the head of a student standing beside the road? That's a tougher one. While driving too fast in the school zone raises a foreseeable risk that a student might get injured, the precise route by which the student is injured by a hit rooster that slams into his head doesn't strike me as predictable or foreseeable. But since I am at fault, having hit a rooster because I was driving negligently, and because my actions in fact caused a student to be injured, isn't it more fair to hold me responsible for the injury than to exonerate me because the peculiar means of harm was not predictable and thereby require the innocent student to bear the cost of his or her injury? Well, that doesn't sound very fair either. How do courts resolve that? Well, let's take a look at this fact pattern briefly that you've been looking at. It involves a boat negligently tied up at a dock that floats free, and a seaplane's flying overhead, and the pilot's distracted and fails to see the unmoored boat in his landing path. And it turns out that a van driving along a road on a bluff ahead of the plane has lost its brakes, causing the van to go over the bluff and land on the ground along the bluff's front. And it just so happens that the seaplane's pilot, because he was distracted and failed to notice the boat in his path, had to pull up suddenly, crashes into the bluff, and debris from his crash strikes the driver of the van. So who's responsible to the injured driver of the van for this fiasco? Well, what's predictable? What's negligent? What's foreseeable? Several parties clearly caused the injury. The problem with the van's brakes was a cause. The failure to train the van driver about how to avoid brake problems was a cause. The distraction of the seaplane's pilot was clearly a cause, and so was the failure of the boat's crew to properly moor the boat, because that failure is what caused the pilot to pull up at the last minute. Moreover, each of these failures that I've just described amounts to negligence by the party involved. But which of those negligent parties could have reasonably foreseen that their negligence might result in harm to a van driver or to anybody? Clearly, whoever knew the brakes were defective and failed to either fix them or to alert the van driver about the problem or train the van driver, they were negligent. And because of that, the van went over the bluff. Apparently, nobody got hurt when that happened, but that put the van in the place where debris from the seaplane would hit it when the seaplane crashed. Well, that's definitely not something that's very foreseeable. That the driver might be injured while driving a van with faulty brakes was clearly and reasonably foreseeable, but it wasn't really foreseeable by my reckoning that the faulty brakes would put the driver at a spot where a negligently piloted seaplane might crash and shower the driver with debris. So I have a hard time putting together foreseeable liability there on that part. What about the seaplane pilot? Well, I think he was pretty clearly negligent because he didn't pay close attention while he was flying his plane. And it was that very negligence that caused his plane to crash and shower the van driver with debris. While it might not have been reasonably foreseeable that a van driver would be in that very location, it was reasonably foreseeable that someone might be there and that injuries might result. And so it seems to me that his responsibility is pretty clear-cut. So I would blame that seaplane pilot for a lot of this. What about the boat crew? Well, they were certainly negligent in failing to properly moor the boat, but it stretches credulity to conclude that they should reasonably have foreseen that their actions might cause the pilot of a seaplane to immediately pull up, causing him to crash and shower bystanders with debris. They could, however, have reasonably foreseen that their negligence might cause their boat to hit another boat or to otherwise cause damage or injury. Should that be sufficient to hold them responsible? Well, most juries, as I'm sure you all know by now, most jurisdictions seem to leave it to juries to determine whether the link between a party's negligent act and the harm that act caused amounts to proximate cause. In short, the issue is treated as a factual determination. The proximity and foreseeability of the injury is left to the attorneys to argue and the jury to decide. This appears to be the approach taken by courts in the Virgin Islands. However, in some instances, a court may determine that the evidence is so slight as to not reasonably warrant the inference of proximate cause. And in those instances, the court is not required to leave the matter to the speculation of the jury. So basically, how much sense does it make to say that something was foreseeable or not? That's what it all boils down to. I took a brief look, and then I will leave you at Virgin Islands cases, and just to read one or two quotes from them to you, so you'll know how it stands here in the U.S. Virgin Islands. It's pretty much along the lines I read to you, and just explain to you. One of our lead cases says, quote, "Proximate cause is established where the party who bears the burden shows that an original act is wrongful or negligent, and in a natural and continuous sequence produces a result which would not have taken place without the act." In other words, but for the negligent act, this event never would have happened. So that's part of our standard. The Virgin Islands Supreme Court has, quote, "recognized foreseeability as the touchstone of premises liability in the Virgin Islands because foreseeability permeates every element of a negligence claim." So that's that foreseeability element that I was just talking to you about. Although foreseeability is implicated, the court says, to some degree in every element of negligence, each element requires a distinct and separate analysis. So the jury has to take a close look at this foreseeability issue. Another of our, a different court, but one that we often rely upon here, says, quote, "under tort law, the test for proximate cause is often foreseeability. If the harm that occurred was a foreseeable consequence of the action, then that action is a proximate cause of the harm." So again, foreseeability plays a huge part. Finally, that same case goes on and says, quote, "a proximate cause is an actual cause that is also legally sufficient to support liability. Although many actual causes can exist for an injury, the law does not attach liability to all actors responsible for those causes. The likelihood of calling something a proximate cause increases as the cause becomes more direct and more necessary for the injury to occur." So that's where the standard stands. And reasonable people can differ on any given fact pattern just about as to whether or not it's foreseeable or not, and exactly what is meant by that. So enjoy your life in law, and I wish you all the very, very best. And if anybody has any questions or thoughts, I'm ready to entertain them.
I certainly have a few follow-ups on that. First, I don't know that I've ever regretted not thinking of a fact pattern more than your chicken scenario. Oh, like I really wish that had come up to my mind in January of this year when I was doing this, because
next year.
Right? I mean, there are so many cases that I've read that is like the Virgin Islands version of that. It's just great. I actually, as the Attorney General, I think it would be good to maybe pose a question more related to the second issue. I don't know that I've presented a question before that is might more visually be depicted better than the serpent eating its tail than that issue. Because the questioning on both days kept running into the same answers that brought you back to the same questions. And it didn't seem like there was an easy stop for either side. Yeah, you could always come back with another question that circled back around into the questioning. And I think this issue presents some very values that are not just legal values in our society, but really significant values. I use the concept of legislative notice, right? The law needs to be published in advance, and people need to know it and understand it in order to be, or at least have the opportunity to know it and understand it in order to be liable. There's a reason our Constitution prohibits ex post facto laws, both against the federal government, but the original text actually prohibits that against the states. There are very few prohibitions against the states in the federal constitutions. It's one of them. The United States Supreme Court in Vui v. City of Columbia, they extended the concept of ex post facto law to the judiciary. In that case, the state Supreme Court had reinterpreted the law to make the defendant liable, and the Supreme Court said, well, you can apply that going forward, but you can't apply that retroactively.
froze
this
on me there. There
interpretation
you
had
go.
been out there.
Okay.
So yeah, so this issue today we're dealing with the question of, well, separation of powers is huge. We have three branches of government, and if a bill doesn't get signed by the executive, as one of our moot litigators from Charlotte Amalie High School said on Tuesday, it's just a bill sitting on Capitol Hill. And that is just the heart of our checks and balances and separation of powers. But then it presents this other issue of, well, the law is published that people would access, says what was wrong. And what do you do with that? And I don't think that our legislature's direction, we included, I think it's one VIC something. I don't know that clearly says it other, because it says, well, the code reviser can only change grammar through mistake. But then it says, but if the legislature doesn't react to an error in a certain amount of time, the error becomes law. Well, okay, does the substantive prohibition on mistakes changing the law still apply, or is that second portion to all mistakes, whether it's substantive or not? So I don't. What are your thoughts on that issue and how that sort of fits into our civil structure and how we sort of view limits on government and society?
Well, first, to be honest with you, I haven't thought a lot about that issue.
Fair.
And I haven't researched it or looked into it to any depth. I haven't run into it. Fortunately, all of the massive number of civil cases I handled, I don't think there was ever a disparity between what was in the printed version of the rules and what had actually been passed. Although I do know that our printed versions are falling pretty far behind, and that's been a serious problem in several of the matters that we've had. No, but I agree that's an interesting argument. I think that would be a good one to work with on your next set of moot courts as well.
Right, make them go through it again. I think they might revolt against me if I put that in front of them. So for the students, you've had an amazingly varied career, not just in law, but through your life. And you went to law school later than a lot of people do. A lot of people, power through and don't stop. What advice would you give the students right now who are maybe considering it, but what would you say for them to try and do in order to decide if it is a career that would work? There's so many different parts to a career. What would you recommend to take on and see?
Well, I mean, obviously they couldn't start to go to law school until they had done their undergraduate work, their 4 years of college. And I would suggest that during that time, they try to go to court a few times, see what's happening. We always love to have interns, and I know a lot of attorney general's offices, law firms, etc., like to bring in interns for a summer, and that's a great way to get a feel to see if this is something you're interested in or not. Law, though, as you know, is so varied. It can be everything from working with a Senate committee to trying cases, to preparing contracts, to doing wills. I mean, it's endless, and it's the sort of thing to get you into all of the stuff of life. And as you know, on the criminal side, for instance, I've worked both sides, so to speak. I've done a lot of criminal defense work for many, many years, handled a lot of huge criminal cases, and I've done a whole lot of prosecution, including prosecuting a lot of very big cases as well. And I think seeing both sides and working both sides makes you better, and also gives you just a broader sense of justice, of the fact that everybody that commits a crime isn't necessarily a bad person. It can come from a lot of different places, or is not necessarily an uncurable person or an unchangeable person. And I think that's a positive side of working both sides. And so I would suggest students who think they might be interested in the law to maybe try a summer internship or something like that with a law firm that does a variety of things, or with a government agency, Justice Department, or virtually any other that deals with legal issues.
Yes, I actually a student from last year. It David Bourne is an attorney. His nephew interned at the VIDOJ. He really the feedback I got, he thought it was a great experience. And that was through the Department of Labor. I assume that program is still going. So the students. Yeah, so students, you can get your applications in. Actually, the application period is coming up, I believe. It's either started already or it starts in May. But you go to the Department of Labor, you put your internship application in, and you say where you want to work. If you want to work at the Virgin Islands Department of Justice, you say that, and you can even, there's no guarantee you're going to be placed there, but if you want to go to the civil division, you can note that you want the civil division. If you want to be in collective bargaining for that, you can note that. You can note any, the Attorney General did a great job of sort of telling you the moving parts of that. Also, the Virgin Islands Supreme Court, they take interns every summer. And that isn't, for those of you who maybe already know you don't want to be a lawyer, but are maybe interested in government work. The procurement division it takes on an intern up there. It's not just like you're interning in a judge's chambers or something like that. You're getting that exposure. Judge Henderson, does the district court take on any interns through the Department of Labor program or anything?
I do not believe we do that through the Department of Labor program. I know at some point we did do that because I used to do that when I was in high school. This is where I worked every summer in high school and through college. And so I do know that we have had it in the past. Since I've been here, we have not had any interns. But that's not something that I can't inquire about. That's for sure.
Awesome. Please let me either get back to me or otherwise, I guess I could direct them to contact the general inquiry number about potential internships or whatever, and someone will talk to someone who will get back to them.
Yeah.
So,
I would also just throw out that another good reason to get into law, and it's sort of what got me down that track, was that if you get involved in a cause or something that you're really interested in, and it turns out that law can play a very big part in how those things get done, be it civil rights. We could go down the whole list of things. Law can be a critical vehicle or route for getting things done, for aiming toward things. I mean, that's what got me actually to decide I'm going to go to law school, because it's obvious the things I cared about, you need lawyers out there doing them, seeing that they work. And that can be a real incentive. So I'd ask people just to, your students there, just to keep that in mind. They may end up with many other interests. They may get absorbed in certain areas that are not legal, but it may be that if they became a lawyer, they could advance that area even more.
Very true. To the schools, are there any questions? You've got, first off, any attorney general of any jurisdiction is a wonderful chance to ask questions of, but an attorney general like Attorney General Ray, with his just long history of experience and diverse experience, is also great. Do any of the schools, you can obviously, turn your camera on, unmute your microphone or whatever and ask it, or you can send it to me in the chat. Do you have any questions for him, even specifically about interning or anything like that, or more generally, or anything? Because we have a little bit of time yet. We're not, I'm still waiting. About half of the scores are finalized. I still have the other half of the scores to go. So we'll be sitting in silence if we don't have questions either way. So,
but you could sing or do something.
Right. Well, I will take the opportunity to, again, anyone in the, on here, I'm going to put the art auction fundraiser in the group chat. Like I said, please take a look at it. And even if I understand if you have no desire to purchase anything, I just ask that you look at it and then try to share it with 3 people who you think would be interested. hopefully they would buy, but just interested. They'd think a piece on there is remarkable. As I said before, there's really some great opportunities for someone who collects art. There's Sherry Erickson and Don Dulka. They're two very well-known artists who sell for quite expensive. There's a $3,000 piece by Erickson for $1,000 opening bid, and there's a $19,000 piece by Don Dulka that's available for $9,000. But then on the other end, we have those wonderful historic photos that are reproduced, and they're I think someone has bid on, or they've been, all four of them have been bid on, so I think they're at $20 now. But still, that's a pretty low bid to make. So. As I said, it takes we need to raise another $17,000 in order to get back to in-person rounds of the competition and do all of that. And we have about a year to do that. So I would just encourage all of that. With that, while we're waiting for the final, since no comments have come in the chat, I guess we can take a few minutes break here, unless you have anything else that you want to say that came to mind, Attorney General Ray.
Well, I can talk on forever, but I think I've said what I really wanted to say, and that is I want to really encourage this group of students to take a serious look at a legal career. And I have to repeat again, I was impressed as I watched the different arguments being made with how well prepared they were, with their demeanor, with the way they dealt with you judges. It was impressive, and that gives me real hope for the future.
I agree. I mean, in practice, I have definitely had people who aren't as good as the students I've dealt with here. There is a question actually that just came in. So attorneys, judges, they point out that currently they're talking about implementing a medical school at UVI. What are your views on possibly a Virgin Islands School of Law or UVI School of Law?
Well, if you're asking me, I don't see anything wrong with it. I think it could be great. It would give people an opportunity to go to law school here, because otherwise it could be an extraordinarily expensive operation to have to go. Right now, to become a lawyer, you have to leave your home. You have to leave the Virgin Islands. You have to live in the States. And what I've seen, and I've seen it happen over the years, I've been a member of the Virgin Islands Bar for 42, 43 years. What I've seen is that the number of local Virgin Islands lawyers has actually been sort of decreasing. And that's because, there's several different reasons, but one big reason is if you go up to the States, you go through law school, 3 years, there's law firms up there that offer you good jobs, you stay, and you don't come back. And that's, I see that happening with some frequency. So many of the lawyers now practicing in the Virgin Islands live full-time in Florida or wherever, and are members of the bar and kind of bounce back and forth. But there's fewer and fewer native Virgin Islanders who are actually, that I've seen, that are actually going into the practice of law. And I think a law school could really help that, because then you would have grown up here, you could do your college here, do law school here, you would be a critical part of the community, an integral part of the community, and hopefully you would stay.
I would agree with all of that. What about the potential, people from the States coming to a law school and experiencing life in the Virgin Islands while learning the law?
I think that would be fantastic too, and I think that could well happen. And I really think that experiencing different cultures is critical. Like I said, I grew up in Appalachia and in East Tennessee in the mountains, which is one culture, very distinct. I lived all around the country in New England and Midwest and California, but then I also lived in Ethiopia for 2 years, and I was totally immersed in Ethiopian culture. I spoke Amharic. I still know some Amharic. I haven't spoken it a lot recently, but I had to live in a culture that was completely different from any I experienced before. But after a while, you settle in, you learn it, and also for stateside people down in who moved to the Virgin Islands, there's there's several different cultures here that they have to get exposed to and incorporated into. And I think it broadens you. I think it helps you. It opens your eyes more. It makes you more tolerant. And it shows you that there's a lot of different ways that things can be done, not just one.
Yeah, I agree. I think if there would be one real benefit, in addition to local, Virgin Islanders going to school and being lawyers here, and how that would probably increase that percentage, I think that a law school in a territory would have a huge impact, no matter how small the number of attendees from the states there. I think it would have a huge impact in the consciousness of the law and what it means for territories and territorial rights. We had Professor Adams from Stetson University. She just hosted a symposium in the last 18 months where it addressed sort of territorial law and what law schools could do to teach more about what the law is applied to the territories, because territorial status often has a different the law is just different. The incorporation doctrine means that if a law isn't written specifically to apply to the U.S. Virgin Islands, Guam, if those aren't written in the law and it just says the United States or doesn't say anything, the law doesn't apply to us. I mean, Obamacare doesn't apply to the Virgin Islands. At first it was interpreted to apply, and then it was reinterpreted not to apply, and we stand with it not applying in the Virgin Islands.
I have to agree with you.
So,
make the difference.
Yeah, I think that's a great question, or even I guess suggestion. It might even be more than a question. So we are still a little over halfway here. So I guess let's take a 10-minute break, and we will reconvene. And I'll announce the scores then.
Oh,
Okay, and
Attorney
thank you.
Thorpe,
Yes.
I had a question for Attorney General Gordon. Do you
Sure.
think that future lawyers should go to the Peace Corps?
Do I think that? I'm sorry, you just broke up a little bit. Do I think lawyers should go to the Peace Corps?
Do you think that future lawyers should consider going to the Peace Corps?
Yes, I think everybody should consider going to the Peace Corps. I know the Peace Corps enrollment has dropped considerably, but I think it's an astounding chance not only to do good and help people, but it also is a good way to experience different culture, which broadens you and makes you a much more open-minded and tolerant person. So I'd say yes, absolutely.
I think that's a wonderful question, and I, as someone who I didn't do the Peace Corps, but I was a national student exchange student to UVI in undergrad. I spent a year there. My time at UVI led directly to me applying to law school at Howard University School of Law and attending there. Just, as someone who grew up in a very tiny area in rural northern Wisconsin, I wanted to, at least within the context of the United States, get as diverse of an educational background as I could. And so after a year at UVI, Howard seemed like the best opportunity for that. And I do think that I am not just a better person, but a better lawyer for that diverse background. Obviously it makes you more tolerant. There's we know these things through multiple years of multiple sociological studies and stuff like that. But it also, I think, makes you more of a critical thinker. You're because you've had to learn different cultures and different perspectives and take that in. You're better at taking a moment to take in the situation and think it through, rather than just reacting from a narrow viewpoint.
Right. Yeah, I mean, to me, one of the major things I got from working in the Peace Corps and being in a little mud hut in the village in Ethiopia for 2 years, as the only English speaker, so I didn't speak English. I was totally immersed in the culture. Everybody I knew, talked with, met, etc., was an Ethiopian. And I worked in the schools there, and I also worked on some of the community projects. But what it really what I really saw was that all sorts of things I had always just taken for granted, there are completely different ways to do them and think about them. And if you were to, I spent time in some other cultures as well and have seen them with yet other ways to do and think about the things that all people think about and do. And I realized that there's just a massive range. And I guess it made me into a cultural relativist.
Yeah, you don't, it doesn't go away. You don't magically just go back to not having that experience or thinking. It definitely, I think I have to agree. It changes you. Is sorry, Amalia Law, was Ms. Jaboynes the one more question, or do you have another question after that? Oh, okay, it was her. Um, so all right then. Let me look here. We still have about three more squads who have scores being entered. So, yeah, I think we will now, first off, just a massive thank you to Attorney General Ray, who came in and did a wonderful a talk on, being a lawyer. The concept of proximate cause, I think, is just remarkable. I think that you gave real life scenarios and walked through the fact pattern in a way that we haven't done thus far, and so it was a really good a way to think about it in that regard. I liked it.
Thank you. It's an honor for me to be here. I really appreciate the invitation, the opportunity to talk to new aspiring potential lawyers.
Yeah, I'm glad you enjoyed it as well. Thank you so much. So with that, we maybe don't need to take a break. We could start with comments from the Moot justices. So Judge Henderson, since your camera is up and everything, you got to listen to all of the students today and hear them argue. Any observations and comments, advice after all this?
Sure. Let me say that I thought that the students all did. I mean, first of all, let me start off this way. Congratulations to each of you for even participating in this competition. It cannot be easy. You're in school, all these things are going on, and you're preparing to read all of these cases, which are things that lawyers have to do or students in law schools have to do. And having no legal experience at all, for you to be able to do that is just remarkable. And you really should pat yourselves on the back for what you did to be able to be at this point. So I thought that it was truly my honor to be here to serve as a Moot Justice for this year's Moot Court competition. Some students, I just felt that your nerves probably got the better of you. I'm not sure how you did yet on Tuesday, but it was clear that some of you had a little bit of nerves, and that's okay. This isn't, the kind of competition where you just run around the field. There is a truly mental component to this. And I think we don't really take into consideration how difficult it can be in these mental competitions that you have to do, where you have to think on your feet and be prepared and have things all in your minds all at once to be able to respond to questions that you don't really know what the questions will be. So don't be too hard on yourselves. But then there were also some students that were just exceptional to me. You were poised, you were clear in your arguments. You actually brought out some issues that I didn't think that you would catch, and you caught it. And you were there to be able to present it and to present it well. And I thought that that was really, really exceptional. And for those of you who were answering our questions, who you might have got a little bit tripped up on it, but then you got yourself right on back. And there were some of you who, I will be honest with you, even though what you were arguing clearly was not a winner, but that wasn't the point. The point is you believed in your case and you believed in what you were arguing, and you stuck your grounds to what, as wrong as you were, you stuck your grounds to that. But think about it this way. That's how laws are changed. Even though I may think that what you're arguing wasn't really correct, you may convince other jurists that you're correct, and that's how laws change. So it was just an honor to participate this year and to listen to all of the arguments coming out, to see you prepare and get to this day that you worked so many months for to get to this point. And so as you leave today knowing that you all gave it your best and it was received well.
I I think that's just a remarkable sort of capstone commentary. Yesterday, Professor Adams, who's done multiple presentations on VI law, she wrote a paper on one VIC4. She then was the main organizer of the bank symposium, and then most recently did a territorial law symposium involving the VI. She was talking about an article by Dean Prosser, as in Prosser and Keaton on torts. It was called Palsgraf Revisited, and she had some other commentary. But that article does this really great job of summarizing the history of the actual Palsgraf case. And as Dean Prosser says, never was there a case that pulled itself up by its own bootstraps to such prominence than Palsgraf. And her comment was that. Because as it works out, it really ends up being a very split number of judges who voted one way. It was like 5 on the New York Court of Appeals voted with Cardozo and 4 voted with Andrews, and it was a similar tie in the intermediate appeals. And so, but she said, you know, what it what strikes her is perhaps that the narrative and the strength of the narrative is why Cardozo won. And I think that just ties in really well with yours. You know, you might convince another jurist. Cardozo wrote a remarkable opinion. Whether you agree with it inherently in feeling, it is a very convincing narrative when you read it. And you know, I think that um, that sort of confidence in your ability and in your argument and to present it can go a long way. And so I just think your commentary ties that all together really, really well. So with that, let's go to our Moot Chief Justice. Moot Chief Justice Brady, do you have, after all of the day, comments, observations, advice for the students?
Well, I wouldn't want to be presumptuous enough to give advice, but I join Judge Henderson in thanking all of you for the opportunity to participate. It was fun. I must confess, when Attorney Thorpe asked me the other day, I sort of unthinkingly said, sure, I'll do it. And then he sent me an email with like hundreds of pages of cases, and I was trying to figure out, how do I get back to Attorney Thorpe and say, you know what, I really can't do this. Do you expect me to read all of this stuff? And in any event, my goodness gracious, what a project all of you Moot Court students have taken on. And I congratulate each one of you for participating. What an undertaking! As though you didn't have your regular lives going on, you've got to somehow fit all of this in, and then get ready to participate in these sessions. So it's been and today was very, very impressive. I think this is maybe my third time of doing this. Third or fourth. I did it a couple of years ago, and then several years before that. I don't remember what happened way back then. That was before we had electronic access to everything. Last time around, it was by Zoom. But I think that this time around, generally speaking, the quality of the presentations, the quality of the arguments was superior. As I said, I commend all of you. The Attorney Thorpe doesn't make it easy on any of us just by coming up with these convoluted fact patterns. My goodness gracious, this talk about the Paulsgraf case. This is Paulsgraf on steroids, it seems. But anyway, I mean, just the mention of the Paulsgraf case here in 1928, the New York Court of Appeals, the highest court in the state of New York, has not open, but just really closely examined this Pandora's box, this can of worms of proximate cause. And here in the Virgin Islands, 100 years later, we're talking about exactly the same things. The details have changed, but so much of it hasn't changed. We're still trying to analyze in the civil arena responsibility for personal injuries based upon foreseeability and fault, and who can be held liable. All of the issues that we addressed today, these are issues that are obviously controversial. Not controversial, the issues aren't controversial, but they are so able to be subject to differences of opinion, and that's why we have lawsuits, right? That's why we have lawyers. The law is dynamic, and it is continually changing, and it is continually in need of bright persons to carry forward. And obviously, generally speaking, you're working as a lawyer for a client, whether it's an entity or a government or an individual. And your responsibility is an awesome responsibility, because lay people don't get to understand the workings of the law, and the obligation on the lawyer to carry through the client's interests is a very, very noble profession. So for those of you who are thinking about the law, I would encourage you wholeheartedly. So I do think everybody today, I think just about everybody did a very good job. Yes, few matters were, because they're so difficult, a few participants were tripped up on a couple of things, but by and large, everyone did very, very well.
I have to call you back, okay?
Generally speaking, you have shown yourselves to be very smart, very articulate, and let me suggest that not only in the law, not only in moot court, but in life generally, you can't minimize the importance of preparation. You must prepare. Those attorneys who are prepared can get away with maybe not being the smartest, or maybe not being the most articulate. But if you know your materials, if you know the law inside and out, as so many of you obviously do, if you take the time, there's no way around it. You got to take the time. But if you take the time and prepare, you can absolutely be successful. So again, it's my pleasure and honor to join with you all today, and my congratulations to everyone. Glad, be interested to see who comes out on top.
Wonderful remarks. I guess I should apologize. If it makes you feel any better, the law library was significantly smaller this year than it was last year, by like a lot. So Judge Cannon is our last member of the panel. Do you have any thing you would like to say or share with the students?
Yeah, I appreciate you allowing me to speak for a few minutes. First thing, I want everybody to know you all were extremely impressive. It was extremely difficult for me to grade you all. And I say that having been involved with the Moot Court since its inception, not only as a lawyer assisting students when I was in my private practice, but also as a judge who had been involved in the sort of evaluation. This group, you guys were extremely impressive. I also want to say this, even though I don't know if Gordon Ray is able to hear me. Uh, I don't want you all to think that I'm promoting Gordon Ray, but let me tell you, his background is very unique, and he was very humble about sharing with you his history. Uh, I just want you all to know that at one point he actually retired for, I don't know if he was a couple of years or 1 year, but he wrote a couple of books. One of them was a 600-page plus book on a 2-day war, the Civil War, which he got scholarly and academic praise for it. So I would tell you, if you got time in the future, look him up. He's not just this little guy with the white beard on the TV screen here, the monitor. He's an impressive person to sort of study. I want to just say this to you all. I was not only impressed with your ability to grasp the law, but to deal with the three judges here that question you all and sometimes might have confused the hell out of you. So I was impressed with your response. Some of you actually reminded me of my daughter. Um, she's also a lawyer who, even no matter how wrong she might have been, convinced me that she was right, even though in the back of my mind I just knew that that's not the right position. But I'm going to be convinced by this argument. So I just share that because some of you took positions that in the back of my mind I wasn't certain whether or not you were right, but I was impressed and persuaded by your argument, so that I had my own doubts, and not that I think of myself as some sort of scholarly judge who knows the law, but that just shows you how impressive your arguments were. Because if I felt that I knew something, some of you actually convinced me otherwise. So I thank you all. Thorpe, I think in the future you should definitely limit the information. Is this was a smaller one than last year? I think it'd be wise to get smaller and smaller. These young people have active lives, and so does the judges. So I would encourage you to work on brevity, not longevity here. And I appreciate being involved in this process. Thank you.
Judge Gannon, thank you so much for the kind words. And I might remind the audience that you have a spectacular background yourself.
Nothing
So
compared to what you have, Gordon. I would always say that. And I'm not saying that for you guys to be impressed with Gordon. I want you to learn, because this guy started off with, he's from West Virginia, but most of his life he's been in the Virgin Islands. I'm from Mississippi originally, but most of my life I've been here in the Virgin Islands. And to see the level of dedication that people who've come from the outside, who made this their home, who love this, who raised their kids and brought them into this culture and is giving back, is extremely impressive. So is Doug and Emil. I'm sorry is born here, so I got to give him credit for that. But if you come to Frederickstead, you make sure that you go by his dad's park over here, okay? But anyway, I just want to share with you all that we come back to the Virgin Islands, those of us who grown up here, those of us who come from elsewhere, we made this our home. So in the future, I hope some of you, when you get out there and get your education, you come back home, man. We need you, and we need the caliber of intelligence and sort of character and culture that you guys have shown in these arguments. I pray that you come back. So I appreciate that.
Oh, great. Thank you so much. I did want to, Judge Brady, you mentioned that you think this is the best arguments. I think this is the best arguments I've seen. Maybe I wasn't paying close enough attention in the past, but there are students who today took in information from questioning on Tuesday and took in information from Professor Adams on Tuesday, and they changed their arguments and applied it in real time today while dealing with. I have to say, you were one of the toughest panels I've ever constituted. I like your questioning was relentless. I wouldn't have wanted to be on the receiving end of those arguments and having to justify it. And I've got 16 years of practice. And so I truly do think this was on a level that we have not seen before. I want to take the time, as Judge Cannon said, this was, and Judge Brady, this was a lot of work and a lot expected out of you. So special thank you to the coaches, both the faculty coaches and the attorney coaches. You know, the students couldn't succeed without how much work you put in. Please be sure to fill out your forms and claim your 8 CLE credits because you earned them and more. We are so grateful to you. And I already mentioned the fundraiser, so my last note is that to the justices and to Attorney General, our keynote speaker, we actually have freshmen and sophomores on St. Croix Seventh-day Adventist School team. If you guys want to come on camera and show yourselves who are the underclassmen, and the same at Charlotte Amalie, Ms. Warner, this is her second year participating and she's only a sophomore. She was there last year as a freshman, and hopefully we'll see her for another 2 years. I don't know who the St. Croix students are that they don't have their camera on, but I think there are 3 out of them who are freshmen and sophomores. If you guys want to say hi.
They the 3 freshmen, the 3 have gone because they had to get the school bus.
Oh.
So only 3 of us remain here.
Which are the 3 who were underclassmen?
Amaris, who was the alternate on Tuesday. She's a 10th grader. Daniela is a 10th grader, and Denicia is a 9th grader.
Wow. Okay. And 2 of them argued. You didn't get to hear one of them argue. Ms. McSween was an alternate, but she argued on Tuesday. So we've got underclassmen like coming and doing this and succeeding. So, a special congratulations to you at St. Croix as a coach, Ms. Filbert. Taking on underclassmen and teaching them something so high level is a next level. So well done.
And Miss McSwain got through because when we realized the other party was not coming back, she had 1 week to prepare for it.
Oh, wow. Wow, that is impressive. That really is. A special congratulations to her. So with that, you clearly aren't here to listen to me. So individual awards. The 5th runner-up gets $100. The 4th runner-up gets $100. The 3rd runner-up gets $250. The 2nd runner-up gets $750. The 1st runner-up gets $925, and the best oralist today gets $1,250. So our 5th runner-up is Miko Griffith from Antilles School. Our 4th runner-up, and as I said on Tuesday, you are welcome to have your cameras on and show your celebration. That you don't have to do as you wish.
I was just about to say, I would like for them to turn them on so we can see their faces.
Right. I prefer that, but I don't want to force people. Whatever they're comfortable with, they're more than welcome to do. But my vote is yours as well. So 5th runner-up, Miko Griffith at Antilles School. So congratulations. 4th runner-up, Amaya Hamilton at St. Croix Central. Well done, St. Croix Central. Our 3rd runner-up, Abigail Jaboyne at Charlotte Amalie High School. Our 2nd runner-up, Angelica Griffin at St. Croix Seventh-day Adventist. So congratulations there. Our 1st runner-up, Aaliyah Boodhoo at Good Hope Country Day School. And our best oralist is Kiori Francois at All Saints School. So congratulations to the 6 of you. Well done. Is our squads. Our fourth place squad receives $675 to be split evenly among the participants, including the alternate if there's an alternate. Third place receives $900. Second place receives $1,050, and first place receives $1,500. So, in fourth place, we have Charlotte Amalie High School appellants, Samaya Mark and Cherise Alize. So, congratulations. In third place, we have St. Croix Seventh day Adventist appellants, Darnell Nelson and Angelica Griffin. In second place, we have Antilles appellants, Christina Francois and Miko Griffith. And in first place, we have Antilles appellees, Yuraj Dua and Ajay Mapiri. So congratulations to all of you. Very well done. I just and it was a really close. The team scores averaged out about a difference of 3 points from fourth to third. So you guys really were remarkable. I'm also really grateful that we have good scoring that averaged out, so there were no ties. So well done, everyone. I will I will take Judge Cannon's advice to heart and work on a more simplified problem for next year. And if there's anything else, by all means, I will. Otherwise, we can all log off and the students can continue their celebrations. Well then, enjoy the day and thank you all, everyone, so much. It's so appreciated.
Thank you all very much. It's a pleasure.